Chapter V of the AUDIOBOOK Councils. The third point of view, in which we are to consider the sovereign, is with regard to his councils. For, in order to assist him in the discharge of his duties, the maintenance of his dignity, and the exertion of his prerogative, the law has assigned him a diversity of councils to advise with. 1. The first of these is the High Court of Parliament, whereof we have already treated at large. 2. Secondly, the peers of the realm are by their birth hereditary councillors of the crown, and may be called together by the crown to impart their advice in all matters of importance to the realm, either in time of parliament, or, which has been their principal use, when there is no parliament in being. Accordingly Blackstone, speaking of the nobility of his time, says they might probably be called consuls a consulendo, reges inimtaos sibi, associant ad consulendum. And in our law books it is laid down that peers are created for two reasons. 1. Ad consulendum. 2. Ad defendendum regem, on which account the law gives them certain great and high privileges, such as freedom from arrest, and even when no parliament is sitting, because it intends that they are always assisting the sovereign with their counsel for the commonwealth, or keeping the realm in safety by their prowess and valor. Instances of conventions of the peers to advise the crown have been in former times very frequent, though now fallen into disuse by reason of the more regular meetings of Parliament. Sir Edward Coke gives us an extract of a record 5 Hen. Roman 4. Concerning an exchange of lands between the King and the Earl of Northumberland, wherein the value of each was agreed to be settled by advice of Parliament, or otherwise by advice of the Royal Councils. 199 Grand Council of Peers which the King promises to assemble before the feast of St. Lucia, in case no Parliament shall be called. Many other instances of this kind of meeting are to be found under our ancient kings, though the formal method of convoking them had been so long left off that when King Charles I in 1640 issued out writs under the Great Seal to call a great council of all the peers of England to meet and attend His Majesty at York previous to the meeting of the Long Parliament, the Earl of Clarendon * mentions it as a new invention, not before heard of, that is, as he explains himself, so old that it had not been practiced in some hundreds of years. But though there had not so long before been an instance, nor has there been any since, of assembling them in so solemn a manner, yet in cases of emergency our princes have at several times thought proper to call for and consult as many of the nobility as could easily be got together, as was particularly the case with King James Roman II after the landing of the Prince of Orange, and with the Prince of Orange himself, before he called that convention parliament which afterwards called him to the throne. Besides this general meeting, it is usually looked upon to be the right of each particular peer of the realm to demand an audience of the sovereign, and to lay before him, with decency and respect, such matters as he shall judge of importance to the public weal. And therefore, in Telio reign of Edward Roman II it was made an article of impeachment in Parliament against the two Hugh Spencers, father and son, for which they were banished the kingdom, that they by their evil coven would not suffer the great men of the realm, the king's good counsellors, to speak with the king, or to come near him, but only in the presence and hearing of the said Hugh the father and Hugh the son, or one of them, and at their will and according to such things as pleased them. B. 2. Malerium, and if the subject be a legal for inst. 53. Sir William Blackstone Nature then by the King's Council here mentions as a third council belong unxid his council for matters of ing to the sovereign, his judges of the law, namely his judges. Therefore, adds courts of law, for law matters, 1 inst. 110. I jailixway, when by statutes 16 Bic. Roman 2. And this, he says, appears frequently in c. 5. It was made a high o flianco to immer stilns, particularly 14 Edwa. Roman 3. See Jordan to this kingdom all ye papal bulls 5, and in other books of law, so tie or other processes I Rome, and it when the king's council is mentioned was enacted, that the offlanders should be generally, it must be defined, particular attached by their bodies and brought-ized, and Ellen elder tude, secundum s ejectam before the king and his council to answer. Royal Councils. free. But the principal council belonging to the sovereign is the Privy Council, which is generally called by way of eminence the council. And this is a noble, honorable, and reverend assembly of the sovereign, and such as he wills to be of his privy council in his court or palace. The sovereign's will is the sole constituent of a privy councillor, and this also regulates their number, which of ancient times was 12 or thereabouts. Afterwards it increased to so large a number that it was found inconvenient for secrecy and dispatch, and therefore King Charles Roman II, in 1679, limited it to 30, whereof 15 were to be the principal officers of state, and those to be councillors verdui officii, and the other 15 were composed of 10 lords and 5 commoners of the sovereign's choosing. But since that time the number has been much augmented, and now continues indefinite. Of this privy or secret council it is somewhat difficult to trace the origin, and more difficult to define the functions. It can readily be understood, however, that in the early period of our history, when every sovereign was his own minister, his inclinations and necessities would lead him to call to his aid those with whom by choice or circumstance he was placed in immediate contact, and with whom he could advise when the great councils of the realm were not assembled. And as these great councils possess judicial as well as legislative authority, it is not surprising to find this more select body exercising similar powers. When, therefore, the judicial functions possessed successively by the White-Najmadan Curia-Bijis had been gradually transferred to the courts of law, the original council, whatever its exact nature, seems to have retained all those powers of which for such offence. Here, by the expression and opinion the correctness of which sub off the King's Co-MWCZI, were understood, the sequent researches have fully justified, King's judges of his courts of justice, the reports of the committee on the subject matter being legal. This being the privileges of the peerage, passum, Sir General way of interpreting the word Harris Nicholas. Proceedings and Order Council, 3 inst. 125. But this int are predonencos of the Privy Council of England. Tion has been questioned by Sir John, printed under TLI direction of th*e Coleridge's Blackstone. Vol. I. P. Missioners of the Public Records. Hell 229, who is of opinion that TLI Council Lambsconts His Vol. I. Cly. 1. Here mentioned was a court of very extent. 4 ins. 53. Sive equitable jurisdiction, both in civil *C. Sir Harris Nicholas preface to the and criminal matters, the fountain from Proceedings SMD ordinances of the Wickley, in process of time, the courts of Privy Council of England, Chancery and Star Chamber were derived. Privy Council 201. The Curia Regis had not been expressly divested, and its proceedings accordingly exhibit an extraordinary combination of the executive and legislative functions of government. It is accordingly impossible either to define the limits of its authority, or to bring the duties which it performed within any general principle, until, indeed, as Sir Harris Nicholas remarks, the royal prerogative became restrained by the gradual increase of power on the part of the 2 other estates of the realm, and the jurisdiction of the courts of law and equity was clearly marked out. There was scarcely a department of the state which was not, in a greater or less degree, subject to its immediate control. No rank was too exalted or too humble to be exempt from its vigilance, nor was any matter considered too insignificant for its interference, its decision being the ultimate remedy for every grievance for which the common law courts could not provide redress. Under the pretense of affording a remedy which the suitor could not otherwise obtain, the council continually interfered with matters which were exclusively cognizable by the ordinary tribunals, and for this reason, and also because, being nominated by the crown, it was irresponsible except to the king, its proceedings were watched with considerable jealousy by the commons, who on several occasions made vigorous efforts to prevent it from illegally infringing upon the property and liberties of the people. The attempt of Richard Roman II to establish despotic power under the sanction of parliamentary forms, by the statute enabling his nominees to legislate upon all petitions and matters contained in the same, as they shall think best by their good advice and discretion, was one of the many acts of that weak and unfortunate monarch, which led soon after to his deposition, and the accession of the House of Lancaster, under whom complaints of the Council's interference became rather less frequent. The Commons, nevertheless, seem to have remonstrated several times, even in the minority of Henry VI, against its encroachments in assuming to deal with matters cognizable at the common law. These complaints are almost invariably directed against the assumption by the Council of judicial powers in questions Hallam, mid. Ages, O Roman 8. P. Roman 3 Peri. Vol. Roman 3. P. 266, and Hallam's mid. Preface to Proceedings and C. of the Die Ages Chap. Roman A. Part Roman 3. Privy Council. Hallam, mid. Ages Ep. Roman 8. Part C. 25 Edwa. Roman 3. Stat. 5c. 4. Rot. Roman 3. Relating to private right, a charge of which the justice is demonstrated by the fact that at this time a clear distinction had been established in the constitution of the body, which took upon itself the exercise of those functions, and the deliberative body, who were the advisers of the crown, and constituted the king's privy council in the modern sense of the word. The former, styled the Concilium Ordinarium, was composed, in addition to the privy councillors, of the chief justices and other temporal and spiritual peers, and was placed on a distinct footing by the Statute 3 Hen. Roman 7. c. 1, which conferred upon it a jurisdiction over riots, misbehavior of sheriffs, and other misdemeanors. Its sittings were thenceforth held in the Camera Stellata at Westminster, and it was soon known and ultimately became notorious as the Court of Star Chamber. The jurisdiction of this novel tribunal being prescribed in the statute by which it was constituted, the J. Privy Council, as the deliberative body which surrounded the throne now began to be called, assumed the exercise of those undefined legislative and administrative powers which it was supposed to possess as coming in the place of the curiabages, an usurpation which may be said to have been, in the succeeding reign, expressly sanctioned by the legislature, the Statute 31 Hen. Roman 8. c. 8. Having authorized the king, with the advice of his privy council, to set forth proclamations under such pains and penalties as seemed to them necessary, which were to be observed as though made by act of Parliament. But the act which conferred these extraordinary powers was repealed in the first year of Edward VI, and the arbitrary proceedings of his successor were founded either on the sanguinary statutes of her father or the legislative enactments of her own reign. The Privy Council of Elizabeth, except in the case of the monopolies, in relation to which the extent of the prerogative was somewhat indefinite, kept within the bounds of their proper authority, for the Court of High Commission, which was created by the first statute of that princess, though composed of privy councillors, was a distinct tribunal, intended to vindicate the dignity and peace of the Church, and to occupy the place of the larger jurisdiction, which had before been exercised under the authority of the Pope. The attempts which were made by Charles I. and his advisers to enlarge the jurisdiction of the Council, through the medium of the 8-tar chamber, led to the Privy Council. 203 Abolition of that court by the Statute 16 Car. I. c. 10, which, after reciting that of late years, the Council table hath assumed unto itself a power to intermeddle in civil causes, and matters only of private interest between party and party, and have adventured to determine of the estates and liberties of the subject contrary to the laws of the land and the rights and privileges of the subject. Proceeds to declare that neither the king nor his privy council have or ought to have any jurisdiction in such matters, but that they ought to be tried and determined in the ordinary courts of justice, and by the ordinary courts of law, since which the functions of the privy council, although never defined, have become gradually restricted to the constitutional limits within which they are now exercised. This noble assembly is presided over by the Lord President of the Council, an officer that by the statute of 31 Hen. Roman 8. c. 10 has precedence next after the Lord Chancellor and Lord Treasurer. Privy councillors are made by the sovereign's nomination, without either patent or grant, and, on taking the necessary oaths, they become immediately privy councillors during the life of the sovereign that chooses them, but subject to removal at his discretion. As to the qualifications of members to sit at this board, Any natural-born subject of England is capable of being a member of the Privy Council, on taking the proper oaths. But, in order to prevent any persons under foreign attachments from insinuating themselves into this important trust, as happened in the reign of King William in many instances, it is enacted by the Act of Settlement, that no person born out of the dominions of the Crown of England, unless born of English parents, even though naturalized by Parliament trade, shall be capable of being of the Privy Council. The DTI of a Privy Councillor appears from the oath of office, J. As to the origin of the office, Bow Council, both repealed by 9 Geo. Roman 4, c. 31. Sir Harris Nicholas. Preface to Pro. Macaulay's Hist of England, vols, seatings, and c. of Privy Council. Roman 3, and Roman 4, pastem. Privy Councillors formerly Po. This applies only to ordinary acts of cest certain peculiar and personal naturalization. The Luke King of the Privileges. C3 Hen. Roman 7. C. 14. Com Belgians, previous to his marriage with Mentadon by Edward Coke, 3 Ins. 38. The Princess Charlotte, and T. Late Prince and 9 Anne. C. Ig. Passed upon the consort, before his marriage, were both attempt of Gitchcart to stab Mr. Harley, enabled to be sworn of the Privy Council. Afterwards Earl of Oxford, when under. See also Hallam, Const. Hist. Vol. Examination in a Committee of the Privy. Roman 2. Ch. The Privy Council, which consists of 7 articles, 1. To advise the king according to the best of his cunning and discretion. 2. To advise for the king's honor and good of the public without partiality through affection, love, meed, doubt, or dread. 3. To keep the king's counsel secret. 4. To avoid corruption. 5. To help and strengthen the execution of what shall be their resolve. 6. To withstand all persons who would attempt the contrary. And lastly, in general, 7. To observe, keep, and do all that a good and true counsellor ought to do to his sovereign lord. The office of a Privy Councillor is now confined to advising the sovereign in the discharge of those executive, legislative, and judicial duties which the Constitution has reposed in him. But as these former have, since the accession of Queen Anne, been entrusted to responsible ministers, it has become the settled practice to summon to the meetings of the Council those members of it only, who, for the time being, hold the reins of government, or, in other words, the ministers of the Crown, and its most important proceedings accordingly consist in laying formally before the sovereign those measures which have been previously determined upon in the meetings of the Cabinet and for which, although adopted and carried out in the name of the sovereign, the ministers alone are accountable to Parliament. There are other acts of a still more formal executive character, which either by long-established custom, or special legislative provision, are to be done by the sovereign in council. The annual selection of sheriffs, for instance, the issuing of proclamations, and the extension to local courts of the enactments of modern statutes amending legal procedure, are effected by orders in council. Only those who are for the time no recognized legal existence, each honored with the confidence of the officer who conducts the exercise of the sovereign, attend the meetings of the royal authority, or prerogative, in his own Privy Council, as it is generally under department, is responsible for Teleosp 2 that no Privy Councillor shall attend measures only to which he has AUD unless specially summoned. These convivially assented. Hallam's Cons. His. Stitute the Cabinet. They are selected vol. Roman 3. Ch. 15. From among the ministers of the Crown p. Nearly every important act of the and are hence termed the Ministry, or sovereign from the first assumption of the administration, or the government. Regal dignity is done in council. Thus each member of the cabinet is usually all declarations of, or public engage invested with some of the higher offices meant by, the sovereign, or consents to of state, but they have no appointment marriages by members of the royal as members of the cabinet, which his family are by order in council. On Judicial Committee of the Privy Council. 205. The legislative functions which remain in the Privy Council are now solely exercised with reference to the colonies and other dependencies of the Crown, over which the authority of the Sovereign in Council is more or less extensive. In the Channel Islands it is said to be absolute, but in modern times the legislation for these islands has generally been by Act of Parliament. Laws and ordinances are, however, made in the Privy Council for those colonies and settlements which do not possess representative assemblies, and the legislative acts of most of the other dependencies of the Crown are therein approved or disallowed. Whenever also a question arises between two provinces, as concerning the extent of their charters and the like, the Sovereign in Council exercises original jurisdiction therein, upon the principle of feudal sovereignty. And so likewise when any person claims an island or a province in the nature of a feudal principality, by grant from the Sovereign or his ancestors, the determination of that right belongs to his Majesty in Council. As was the case of the Earl of Derby with regard to the Isle of Man in the reign of Queen Elizabeth, and the Earl of Cardigan and others, as representatives of the Duke of Montague, with relation to the island of St. Vincent in 1764. In colonial or admiralty causes, which arise out of the jurisdiction of this kingdom, with regard to these, although they may eventually involve questions of extensive property, the Privy Council continues to have cognizance, being the court of appeal in such cases, or rather the appeal lies to the Sovereign himself in Council, and from all the dominions of the Crown, excepting Great Britain and Ireland, an appellate jurisdiction, in the last resort, is vested in the same tribunal which now exercises its authority in the Judicial Committee of the Privy Council, who hear the allegations and proofs and make their report to the Sovereign, by whom the judgment is finally given. To this death of the Sovereign, the Privy Council to be crowned as the Queen Consort of assembles and orders the proclamation of George IV, may be cited as the successor, and on any great state illustrations of the matters with weekly emergency it institutes inquiries and the Privy Council may be called upon to determine the course of proceeding. Deal, simply because the law has the investigation as to the birth of the vited no other method of determining male heir of James II, the such questions. Inquiry as to the insanity of George the C. On this head the statutes 5 and 6 T. Leard, and the claim of Queen Caroline will. Roman 4. C. 83. 3 and 4 Vict. C. 65. 7. The Privy Council Committee, which is by statute a court of record, all the powers and authority of the Sovereign and Council of a judicial character are now delegated. It also decides on applications for the confirmation and extension of patents, and for the republication of books, which, after the death of the author, the proprietor under the Copyright Acts has refused to publish. There is also the Committee of Council for Education, which was first appointed in 1839 to distribute the sums annually voted by Parliament for educational purposes, and whose functions are purely administrative. The Board of Trade and the Local Government Board are also composed of members of the Privy Council, but their proceedings are entirely severed from, and independent of, the Council itself. The power of the Privy Council is to inquire into all offences against the government, and to commit the offenders to safe custody, in order to take their trial in some of the courts of law. But their jurisdiction herein is only to inquire, and not to punish. And the persons committed by them are entitled to their habeas corpus by statute 16 Car. IC. 10, as much as if committed by an ordinary justice of the peace. It was by the same statute that the Court of Star Chamber and the Court of Equests, both of which consisted of privy councillors, were dissolved, and it was declared illegal for them to take cognizance of any matter of property belonging to the subjects of this kingdom. The dissolution of the Privy Council depends upon the royal pleasure, and he may, whenever he thinks proper, discharge any particular member, or the whole of it, and appoint another. By the common law also it was dissolved ipso facto by the demise of the sovereign, as deriving all its authority from him. But now, to prevent the inconveniences of having no council and being at the accession of a new prince, it is enacted by Statute 6 and c. 7 that the Privy Council shall continue for 6 months after the demise of the crown, unless sooner determined by the successor. Vict. c. 69, 8 and 9 Vict. c. 30, 2 and 3 Vict. Tian of the Judicial Committee to the High C. 67, 7 and 8 Vict. c. 69, 15 and 16 Vict. c. Court of Appeal constituted by that 83 and 16 and 17 Vic. C. 115. Statute. The Judicature Act, 1873, S. 21, 5 and 6 Vict. C. 45. Authorizes the Crown and Council to See the Code of Regulations, report for all the power, authority, and jurisdic of Education Committee for 1874. 207. Chapter VI. Of the Sovereign's Duties. I proceed next to the duties incumbent on the sovereign by our Constitution, in consideration of which duties his dignity and prerogative are established by the laws of the land, it being a maxim in the law that protection and subjection are reciprocal. And these reciprocal duties are what, I apprehend, were meant by the Convention in 1688, when they declared King James had broken the original contract between king and people. But however, as the terms of that original contract were in some measure disputed, being alleged to exist principally in theory and to be only deducible by reason and the rules of natural law, in which deduction different understandings might very considerably differ, it was, after the Revolution, judged proper to declare these duties expressly and to reduce the contract to a plain certainty, so that whatever doubts might be formerly raised by weak and scrupulous minds about the existence of such an original contract, they must now entirely cease, especially with regard to every prince who has reigned since the year 1688. The principal duty of the sovereign is to govern his people according to law. Ni regis infinita aut libera potestas was the constitution of our German ancestors on the continent. And this is not only consonant to the principles of nature, of liberty, of reason, and of society, but has always been esteemed an express part of the common law of England, even when prerogative was at the highest. The king, says Blackstone who wrote under Henry Roman III, ought not be subject to man, but to God and to the law, for the law maketh the king. Let the king therefore render to the law what the law has invested in him with regard to authority, dominion and power, for he is not truly king where will and pleasure rules, and not the law. And again the tag. De more. Germ. C. 7. L. I. C. A. L. 2c. 16. Section. The sovereign's duties. King also hath a superior, namely God, and also the law, by which he was made a king. Thus Blackstone. And Fortescue also having first well distinguished between a monarchy absolutely and despotically regal, which is introduced by conquest and violence, and a political or civil monarchy, which arises from mutual consent, of which last species he asserts the government of England to be, immediately lays it down as a principle that the King of England must rule his people according to the decrees of the laws thereof, insomuch that he is bound by an oath at his coronation to the observance and keeping of his own laws. But, to obviate all doubts and difficulties concerning this matter, it is expressly declared by Statute 12 and 13 Will. Roman 3. C. 2. That the laws of England are the birthright of the people thereof, and all the kings and queens who shall ascend the throne of this realm ought to administer the government of the same according to the said laws. And all their officers and ministers ought to serve them respectively according to the same, and thereof all the laws and statutes of this realm, for securing the established religion and the rights and liberties of the people thereof, and all other laws and statutes of the same, now in force, are ratified and confirmed accordingly. And as to the terms of the original contract between king and people, these I apprehend to be now couched in the coronation oath, which by the statute 1W and M. Sen. 1c. 6 is to be administered to every king and queen, who shall succeed to the imperial crown of these realms, by one of the archbishops or bishops of the realm, in the presence of all the people, who on their parts do reciprocally take the oath of allegiance to the crown. This coronation oath is conceived in the following terms. The archbishop or bishop shall say, Will you solemnly promise and swear to govern the people of this kingdom of England, and the dominions thereto belonging, according to the statutes and Parliament agreed on, and the laws and customs of the same? The MNG or queen shall say, I solemnly promise so to do. Archbishop or bishop. Will you to your power cause law and justice, in mercy, to be executed in all your judgments? King or queen. I will. Archbishop or bishop. Will you to the utmost of your power maintain the laws of God, the true profession of the gospel, and the Protestant Reformed religion established by the law? Coronation Oath. 209 And will you preserve unto the bishops and clergy of this realm, and to the churches committed to their charge, all such rights and privileges as by law do or shall pertain unto them, or any of them? King or queen. All this I promise to do. After this the king or queen, laying his or her hand upon the Holy Gospels, shall say, The things which I have here before promised I will perform and keep, so help me God. A7ID then shall kiss the hook. This is the form of the coronation oath, as it is now prescribed by our laws, the principal articles of which appear to be at least as ancient as the Mirror of Justice's asterisk and even as the time of Blackstone, but the wording of it was changed at the Revolution, because, as the statute alleges, the oath itself had been framed in doubtful words and expressions, with relation to ancient laws and constitutions at this time unknown. However, in what form soever it be conceived, this is most indisputably a fundamental and original express contract, though doubtless the duty of protection is implicitly as much incumbent on the sovereign before coronation as after, in the same manner as allegiance to the sovereign becomes the duty of the subject immediately on the descent of the crown, before he has taken the oath of allegiance, or whether he ever takes it at all. This reciprocal duty of the subject will be considered in its proper place. At present woe are only to observe, that in the sovereign's part of this original contract are expressed all the duties that a monarch can owe to his people, viz., to govern according to law, to execute judgment in mercy, and to maintain the established religion. And with respect to the latter of these three branches we may farther remark that by the Act of Union * with Scotland 5 Ann. c. 8, 2 preceding statutes are recited and confirmed, the one of the Parliament of Scotland, the other of the Parliament of England, which enact, the former, that every king at his accession shall take and subscribe an oath to preserve the Protestant religion and Presbyterian church government in Scotland, the latter, that at his coronation he shall take and subscribe a similar oath to preserve the settlement of the Church of England within England, Ireland, Wales, and Berwick, and the territories thereunto belonging. Cap. 1 Section 2 Asterisk L 3 tr 1 c 9 Oath. Prino has also given you a copy. In the old folio abridgment of T.Li. of the Coronation Oaths of Richard Roman II. Statutes, printed by Ledoux and Mackay Signal Loyalty, Roman II. 246, Edward VI. Linea in the reign of Edward Roman IV. Their Ibid. 2.51, James I and L. Charkazai, is preserved a copy of the old Coronation Ibid. 26i. Vol. I. Chap T. Roman 7. The royal prerogative. It was observed in a former chapter that one of the principal bulwarks of civil liberty, or, in other words, of the British Constitution, was the limitation of the sovereign's prerogative by bounds so certain and notorious that it is impossible he should ever exceed them without the consent of the people, on the one hand, or without, on the other, a violation of that original contract which, in all states implicitly, and in ours most expressly, subsists between the prince and the subject. It will now be our business to consider this prerogative minutely, to demonstrate its necessity in general, and to mark out in the most important instances its particular extent and restrictions. From which considerations this conclusion will evidently follow, that the powers, which are vested in the Crown by the laws of England, are necessary for the support of society, and do not entrench any farther on our natural liberties than is expedient for the maintenance of our civil. There cannot be a stronger proof of that genuine freedom, which is the boast of this age and country, than the power of discussing and examining, with decency and respect, the limits of the royal prerogative, a topic that in some former ages was thought too delicate and sacred to be profaned by the pen of a subject. It was ranked among the arcana imperii, and, like the mysteries of the Bona Dea, was not suffered to be pried into by any but such as were initiated in its service. Because perhaps the exertion of the one, like the solemnities of the other, would not bear the inspection of a rational and sober inquiry. The glorious Queen Elizabeth herself made no scruple to direct her parliaments to abstain from discoursing of matters of state, and it was the constant language of this favourite princess and her ministers that even that august assembly ought not to deal, to judge, or to meddle. Royal prerogative. 211. With Her Majesty's prerogative royal, and her successor, King James I, who had imbibed high notions of the divinity of regal sway, more than once laid it down in his speeches, that is asterisk it is atheism and blasphemy in a creature to dispute what the deity may do, so it is presumption and sedition in a subject to dispute what a king may do in the height of his power. Good asterisk Christians, he adds, will be content with God's will, revealed in his word, and good subjects will rest in the king's will, revealed in his law. But, whatever might be the sentiments of some of our princes, this was never the language of our ancient constitution and laws. The limitation of the regal authority was a first and essential principle in all the Gothic systems of government established in Europe, though gradually driven out and overborne by violence and chicane in most of the kingdoms on the continent. We have seen, in the preceding chapter, the sentiments of Bractu and Fortescue at the distance of 2 centuries from each other. And Sir Henry Finch, under Charles I after the lapse of 2 centuries more, though he lays down the law of prerogative in very strong and emphatic terms, yet qualifies it with a general restriction, in regard to the liberties of the people. The king hath a prerogative in all things that are not injurious to the subject, for in them all it must be remembered that the king's prerogative stretcheth not to the doing of any wrong. Nihil nim aliud potest rex, nisi id solum cusiad de jure potestat. And here it may be some satisfaction to remark how widely the civil law differs from our own, with regard to the authority of the laws over the prince, or, as a civilian would rather have expressed it, the authority of the prince over the laws. It is a maxim of the English law, as we have seen from Blackstone, that rex debet est sub lege, quae lex facit regem. The imperial law will tell us that m omnibus imperioris accipiter fortuna, cui ipses leges Deus subjicit. We shall not long hesitate to which of them to give the preference, as most conducive to those ends for which societies were framed, and are kept together, especially as the Roman lawyers themselves seem to be sensible of the unreasonableness of their own constitution. Deset tamen principum, says Paulus, server leges, quibus ipse solidus est. Asterisk this is at once Stews, 479, 645. Blackstone 1, 3, tr. 1c, 9. King James's Works, 507, 531. Nav. 105, section 2. Finch, L. 8485. Ff. 212 The royal prerogative. Laying down the principle of despotic power and at the same time acknowledging its absurdity. By the word prerogative we usually understand that special preeminence which the crown has over and above all other persons and out of the ordinary course of the common law, in right of the regal dignity. It signifies in its etymology something that is required or demanded before, or in preference to, all others. And hence it follows that it must be in its nature singular and eccentric, that it can only be applied to those rights and capacities which the sovereign enjoys alone, in contradistinction to others, and not to those which he enjoys in common with any of his subjects, for if once any one prerogative of the crown could be held in common with the subject, it would cease to be prerogative any longer. And therefore Finch lays it down as a maxim, that the prerogative is that law in case of the king which is law in no case of the subject. Prerogatives are either direct or incidental. The direct are such positive substantial parts of the royal character and authority as are rooted in and spring from the sovereign's political person, considered merely by itself, without reference to any other extrinsic circumstance, as the right of sending ambassadors, of creating peers, and of making war or peace. But such prerogatives as are incidental bear always a relation to something else distinct from the person of the sovereign, and are indeed only exceptions in favor of the crown, to those general rules that are established for the rest of the community, such as that no costs shall be recovered against the crown, that the sovereign can never be a joint tenant, and that his debt shall be preferred before a debt to any of his subjects. These, and an infinite number of other instances, will better be understood when we come regularly to consider the rules themselves, to which these incidental prerogatives are exceptions. And therefore we will at present only dwell upon the sovereign's substantive or direct prerogatives. These substantive or direct prerogatives may again be divided into three kinds, being such as regard, first, the royal character. Finch, L. 85. He succeeds and pays them if he fails. By 16 and 17 Vic. C. 107. Although former acts gave costs, and part offendant in proceedings by the crown particular cases, to the crown, this is the for duties, penalties, or forfeitures under first act which imposes payment of like customs acts, is entitled to costs if costs on the crown in case of failure. Secondly, the royal authority. And, lastly, the royal income. These are necessary to secure reverence to his person, obedience to his commands, and an affluent supply for the ordinary expenses of government, without all of which it is impossible to maintain the executive power in due independence and vigor. Yet in every branch of this large and extensive dominion, our free constitution has interposed such reasonable checks and restrictions as may curb it from trampling on those liberties which it was meant to secure and establish. The enormous weight of prerogative, if left to itself as in arbitrary governments it is, spreads havoc and destruction among all the inferior movements, but, when balanced and regulated, as with us, by its proper counterpoise timely and judiciously applied, its operations are then equable and certain, it invigorates the whole machine, and enables every part to answer the end of its construction. In the present chapter we shall only consider the two first of these divisions, which relate to the sovereign's political character and avihority, or, in other words, his dignity and regal user, to which last the name of prerogative is frequently narrowed and confined. The other division, which forms the royal revent, will require a distinct examination, according to the known distribution of the feudal writers, who distinguish the royal prerogatives into the majora and minora regalia, in the latter of which classes the rights of the revenue are ranked. For, to use their own words, majora regalia imperi prsium entium bipectant, minora viro ad commodum pecuniarium immediate attinent, ethlio proprii fiscalia. 8 uni etiges fiscae pertinent. First, then, of the royal dignity. Under every monarchical establishment, it is necessary to distinguish the prince from his subjects, not only by the outward pomp and decorations of majesty, but also by ascribing to him certain qualities as inherent in his royal capacity, distinct from and superior to those of any other individual in the nation. For, though a philosophical mind will consider the royal person merely as one man, appointed by mutual consent to preside over many others, and will pay him that reverence and duty which the principles of society demand, yet the mass of mankind will be apt to grow insolent and refractory, if taught to consider their prince as a man of no greater. Peregrine de jure fisc. 1 c. 1 num. 9. The royal prerogative. Perfection than themselves. The law therefore ascribes to the king, in his high political character, not only large powers and emoluments, which form his prerogative and revenue, but likewise certain attributes of a great and transcendent nature, by which the people are led to consider him in the light of a superior being, and to pay him that respect which may enable him with greater ease to carry on the business of government. This is what I understand by the royal dignity, the several branches of which we will now proceed to examine. 1. And, first, the law ascribes to the king, or queen regnant, the attribute of sovereignty or preeminence. Rex est vicarius. Says Bracton. Et minister de in terra. Omnis quaedam sub eo est. Et ipse sub nihilo, nisi tatidem sub Deo. He is said to have imperial dignity, and in charters before the conquest is frequently styled Hasilius and Imperator, the titles respectively assumed by the emperors of the East and West. His realm is declared to be an empire, and his crown imperial, by many acts of parliament, particularly the statutes of 24 Hen. Roman 8. c. 12 and 25 hen, Roman 8. c. 28, which at the same time declare the king to be the supreme head of the realm in matters both civil and ecclesiastical, and of consequence inferior to no man upon earth, dependent on no man, accountable to no man. Formerly there prevailed a ridiculous notion, propagated by the German and Italian civilians, that an emperor could do many things which a king could not, as the creation of notaries and the like, and that all kings were in some degree subordinate and subject to the emperor of Germany or Rome. The meaning, therefore, of the legislature, when it uses these terms of empire and imperial, and applies them to the realm and crown of England, is only to assert that our king is equally sovereign and independent within these his dominions as any emperor is in his empire, trademark, and owes no kind of subjection to any other potentate upon earth. Hence it is that no suit or action can be brought against the sovereign, even in civil matters, because no court can have jurisdiction over him. For all jurisdiction implies superiority of power. Authority to try would be vain and idle, without an authority to redress. And the sentence L. 1 c. A. Hex allegavit, quod ips omnes liber seld. Tit. Of Hon. I. 2. Tates haperit in regno suo, quas imperator. See also 24 Geo. Roman 2. C. 24. 5 Geo. Roman 3. Vindicabat in imperio. M. Paris, A.D. C. 27. 1095. Sovereignty. 215 of a court would be contemptible, unless that court had power to command the execution of it. But who, says Finch, shall command the king? Hence it is, likewise, that by the law the person of the sovereign is sacred, even though the measures pursued in his reign be completely tyrannical and arbitrary. For no jurisdiction upon earth has power to try him in a criminal way, much less to condemn him to punishment. If any foreign jurisdiction had this power, as was formerly claimed by the Pope, the independence of the kingdom would be no more. And if such a power were vested in any domestic tribunal, there would soon be an end of the Constitution, by destroying the free agency of one of the constituent parts of the legislative power. Are then, it may be asked, the subjects of England totally destitute of remedy in case the crown should invade their rights either by private injuries or public oppressions? To this we may answer, that the law has provided a remedy in both cases. And first, as to private injuries. If any person has, in point of property, a just demand upon the crown, he must petition him in his high court, where his judges will administer right jus a matter of grace, though not upon compulsion. And Telias is entirely consonant to what is laid down by the W. Titers on natural law. A subject, says Pufendorf, so long as Ho continues, a subject hath no way to oblige his prince to give him his due. When he refuses it, though no wise prince will ever refuse to stand to a lawful contract. And if the prince gives the subject leave to enter an action against him upon such contract in his own courts, the action itself proceeds rather upon natural equity than upon the municipal laws, for the end of such action is not to compel the prince to observe the contract, but to pursue ad degrees him. And as to personal wrongs, it is well observed by Locke asterisk, the harm which the sovereign can do in his own person no being likely to happen often, nor to extend itself far, noi being able by his single strength to subvert the laws, noi oppress the body of the people, should any prince have so much weakness and ill nature pound is to endeavor to do it, the inconveniency, therefore, of some particular mischiefs that may happen sometimes when a heady prince comes to the throne, are well recompensed by the peace of the public and security of Finch, L. 83. Asterisk law of N and NB, 8 C. 10. Finch, L. 255. On 216 the royal prerogative. The government, in the person of the chief magistrate being thus set out of the reach of danger. Next, as to cases of ordinary peonage-like oppression, where the vitals of the Constitution are not attacked, the law has also assigned a remedy. For as a sovereign cannot misuse his power, without the advice of evil counselors and the assistance of wicked ministers, these men may be examined and punished. The Constitution has therefore provided, by means of indictments and parliamentary impeachments, that no man shall dare to assist the crown in contradiction to the laws of the land. But it is at the same time a maxim in those laws that the king himself can do no wrong, since it would be a great weakness and absurdity in any system of positive law to define any possible wrong, without any possible redress. For as to such public oppressions as tend to dissolve the Constitution, and subvert the fundamental principles of government, they are cases which the law will not, out of decency, suppose, being incapable of distrusting those whom it has invested with any part of the supreme power, since such distrust would render the exercise of that power precarious and impracticable. For wherever the law expresses its distrust of abuse of power, it always vests a superior coercive authority in some other hand to correct it, the very notion of which destroys the idea of sovereignty. If, therefore, for example, the two houses of Parliament, or either of them, had avowedly a right to animadvert on the sovereign, on each other, or if the sovereign had a right to animadvert on either of the houses, that branch of the legislature, so subject to animadversion, would instantly cease to be part of the supreme power, the balance of the Constitution would be overturned, and that branch or branches in which this jurisdiction resided would be completely sovereign. The supposition of law, therefore, is that neither the sovereign nor either House of Parliament, collectively taken, is capable of doing any wrong, since in such cases the law feels itself incapable of furnishing any adequate remedy. For which reason all oppressions which may happen to spring from any branch of the sovereign power must necessarily be out of the reach of any stated rule, or express legal provision, but, if ever they unfortunately happen, the prudence of the times must provide new remedies upon new emergencies. Indeed, it is found by experience that whenever the unconstitutional oppressions, even of the sovereign power, advance with royal perfection, 217 gigantic strides, and threaten desolation to a state, mankind will not be reasoned out of the feelings of humanity, nor will sacrifice their liberty by a scrupulous adherence to these political maxims, which were originally established to preserve it. And therefore, though the positive laws are silent, experience will furnish us with a very remarkable case, wherein nature and reason prevailed. When King James Roman II invaded the fundamental constitution of the realm, the convention declared an exlocation whereby the throne was rendered vacant, which induced a new settlement of the crown. And so far as this precedent leads, and no farther, we may now be allowed to lay down the law of redress against public oppression. Therefore, any future prince should endeavor to subvert the constitution by breaking the original contract between king and people, should violate the fundamental laws, and should withdraw himself out of the kingdom. We are now authorized to declare that this conjunction of circumstances would amount to an abdication, and the throne would be thereby vacant. But it is not for us to say that any one or two of these ingredients would amount to such a situation, for there are precedent would fail us. In these, therefore, or other circumstances, which a fertile imagination may furnish, since both law and history are silent, it becomes us to be silent too, leaving to future generations, whenever necessity and the safety of the whole shall require it, the exertion of those inherent though latent powers of society which no climate, no time, no constitution, no contract can ever destroy or diminish. 2. Besides the attribute of sovereignty, the law also ascribes to the king in his political capacity absolute perfection. The king can do no wrong, which ancient and fundamental maxim is not to be understood as if everything transacted by the government was of course just and lawful, but means only two things. First, that whatever is exceptionable in the conduct of public affairs is not to be imputed to the sovereign, nor is he answerable for it personally to his people, for this doctrine would totally destroy the constitutional independence of the crown, which is necessary for the balance of power in our free and active, and therefore compounded, constitution. And, secondly, it means that the prerogative of the crown extends not to do any injury. It is created for the benefit of the people, and therefore cannot be exerted to their prejudice. Royal prerogative. The sovereign, moreover, is not only incapable of doing wrong *, but even of thinking wrong. He can never mean to do an improper thing, in him is no folly or weakness. And therefore, if the crown should be induced to grant any franchise or privilege to a subject contrary to reason, or in anywise prejudicial to the commonwealth, or a private person, the law will not suppose the sovereign to have meant either an unwise or an injurious action, but declares that he was deceived in his grant, and thereupon such grant is rendered void, merely upon the foundation of fraud and deception, either by or upon those agents whom the crown has thought proper to employ. For the law will not cast an imputation on that magistrate whom it entrusts with the executive power, as if he was capable of intentionally disregarding his trust. But attributes to mere imposition, to which the most perfect of sublunary beings must still continue liable, these little inadvertencies, which, if charged on the will of the prince, might lessen him in the eyes of his subjects, yet still, notwithstanding this personal perfection which the law attributes to the sovereign, the Constitution has allowed a latitude of supposing the contrary, in respect of both houses of Parliament, each of which, in its turn, has exerted the right of remonstrating and complaining to the king, even of those acts of royalty which are most properly and personally his own, such as messages signed by himself, and speeches delivered from the throne. And yet, such is the reverence which is paid to the royal person, that though the two houses have an undoubted right to consider those acts of state in any light whatever, and accordingly treat them in their addresses as personally proceeding from the prince, yet among themselves, to preserve the more perfect decency, and for the greater freedom of debate, they usually suppose them to flow from the advice of the administration. But the privilege of canvassing thus freely the personal acts of the sovereign, either directly, or even through the medium of his reputed advisers, belongs to no individual, but is confined to those august assemblies, and thereto the objections must be proposed with the utmost respect and deference. One member was sent to the Tower for suggesting that His Majesty's answer to the address of the Commons contained high words to fright the members out of their duty, and another registered for saying that a part of the King's speech seemed rather to be calculated for the meridian of calm, during 18 Nov. 1G 85. Com. Durin. 4 Dec. 1717. Germany then Great Britain, and that the king was a stranger to our kingwage and constitution. In farther pursuance of this principle, the law also determines that on the part of the sovereign there can be no negligence or lashes, and therefore no delay will bar his right. Nullum tempus occurret regi has been the standing maxim upon all occasions. For the law intends that the king is always busy for the public good, and therefore has not leisure to assert his right within the times limited to subjects. In the king also could never be any stain or corruption of blood, for if the heir to the crown had at any time been attainted of treason or felony, and afterwards the crown had descended to him, this purged the attainder ipso facto when Henry Roman VII, who, as Earl of Richmond, stood attainted, came to the crown. It was not thought necessary to pass an Act of Parliament to reverse this attainder, because, as Lord Bacon in his History of that prince informs us, it was agreed that the assumption of the crown had at once purged all attainders. Neither can the king in judgment of law, as king, ever be a minor or under age, and therefore his royal grants and assents to Acts of Parliament are good, though he has not, in his natural capacity, attained the legal age of 21. By a statute, indeed, 28 Henry Roman 8. c. 17, power was given to future kings to rescind and revoke all acts of Parliament that should be made, while they were under the age of 24. But this was repealed by the Statute 1 Edwal. Vi. c. 11, so far as related to that prince, and both statutes are declared to be determined by 24 Geo. Roman 2. c. 24. It has also been usually thought prudent when the heir apparent has been very young, to appoint a protector, guardian, or regent for a limited time, but the very necessity of such extraordinary provision Finch, L. 82, Co. Lit. 90, this D. Watvi, Horace Tubing, N. C. 187, rule is, however, subject to various ex-Attorney General v. Arsons 2 MNLW, exceptions. Thus the Statute 9 Geo. Roman 3. 23. Lu criminal prosecutius as triae. 16. Takes away the right of suit of the sons, felonies and misdemeanors which crown or telios claiming from the crown are instituted in the name of the sovereign against such as have held in adverse. There is at common law no limitation, possession of lands and sea. Against it for 3 Cam. 227. But by various statutes 60 years. Guttel v. Baldwin, 11 criminal proceedings must now be insti East 488. And by stat. 21 Jack. I aftertooted within certain limited periods of an adverse possession of lands by a subject time. For 20 years, the Crown can only Finch, L. 82. Recover by information of intrusion. Boko, Lay. 43. 2 Inst. Pro M. Free. Sufficient to demonstrate the truth of that maxim of the common law, that in the king is no minority, and therefore he has no legal guardian. 3. A third attribute of the sovereign is his perpetuity. The law ascribes to him in his political capacity an absolute immortality. The king never dies. Henry, Edward, or George may die, but the king survives them all. For immediately upon the decease of the reigning prince in his natural capacity, his kingship or imperial dignity by act of law, without any interregnum or interval, is vested at once in his heir, who is eo instanti, king to all intents and purposes. And so tender is the law of supposing even a possibility of his death, that his natural dissolution is generally called his demise, demissio regis, vel quorum, an expression which signifies merely a transfer of property, for when we say the demise of the crown, we mean only that, in consequence of the disunion of the king's natural body from his body politic, the kingdom is transferred doctor demise to his successor, and so the royal dignity remains perpetual. Thus too, when Edward Roman IV in the 10th year of his reign was driven from his throne for a few months by the House of Lancaster, this temporary transfer of his dignity was denominated his demise, and all process was held to be discontinued, as upon a natural death of a king. We are next to consider those branches of the royal prerogative, which invests the sovereign with a number of authorities and powers, in the exercise whereof consists the executive part of government. This is wisely placed in a single hand by the British Constitution, for the sake of unanimity, strength, and dispatch. Were it placed in many hands, it would be subject to many wills. Many wills, if disunited and draw in different ways, create weakness in a government, and to unite those several wills and reduce them to one is a work of more time and delay than the exigencies of state will afford. The king. The methods of appointing the sim made by authority of the great guardian or regent have been so various, council and parliament. See the several and the duration of his power so uncertain, instances mentioned by Sir W. Blackstone, that from hence alone it may be collected vol. I. p. 248, and the statutes 51 Geo Roman 3. That his office is unknown to the common c. 1. 52 Geo Roman 3. c. 8. Will. Roman 4. c. 2. Law. And therefore, as Sir Edward Coke and 3 and 4 Vic. c. 52. says, for instance. 58. The surest way is to have M. 49 Hen. VI. Pi. Authority. 221 asterisk or Queen of England is therefore not only the chief, but properly the sole, magistrate of the nation, all others acting by commission from, and in due subordination to, him asterisk or her. In like manner as, upon the great revolution of the Roman state, all the powers of the ancient magistracy of the Commonwealth were concentrated in the new emperor, so that, as Gravina expresses it, ejus unius persona veteris reificum visec. Majestas per si w nullatas magistratium potestates exprime better. After what has been premised in this chapter, I shall not, I trust, be considerable as an advocate for arbitrary power, when I lay it down as a principle, that, in the exercise of lawful prerogative, the sovereign is and ought to be absolute, that is, so far absolute, that there is no legal authority that can either delay or resist him. He may reject what bills, may make what treaties, may create what peers, may pardon what offenses he pleases, unless where the Constitution has expressly, or by evident consequence, laid down some exception or boundary. declaring that thus far the prerogative shall go, and no farther. For otherwise the power of the crown would indeed be but a name and a shadow, insufficient for the ends of government, if, where its jurisdiction is clearly established and allowed, any man or body of men were permitted to disobey it in the ordinary course of law. I say, in the ordinary course of law, for I do not now speak of those extraordinary recourses to first principles, which are necessary when the contracts of society are in danger of dissolution, and the law proves too weak a defense against the violence of fraud or oppression. And yet the want of attending to this obvious distinction has occasioned these doctrines of absolute power in the prince and of national resistance by the people to be much misunderstood and perverted, by the advocates for slavery on the one hand, and the demagogues of faction on the other. The former observing the absolute sovereignty and transcendent dominion of the crown laid down, as it certainly is, most strongly and emphatically in our law books as well as our homilies, have denied that any case can be accepted from so general and positive a rule, forgetting how impossible it is in any practical system of laws to point out beforehand those eccentric remedies which the sudden emergency of national distress may dictate, and which that alone can justify. On the Grig. 1 Section. The Royal Prerogative. Other hand, overzealous republicans, feeling the absurdity of unlimited passive obedience, have fancifully, or sometimes factiously, gone over to the other extreme. And, because resistance is justifiable to the person of the prince, when the being of the state is endangered, and the public voice proclaims such resistance necessary, they have therefore allowed to every individual the right of determining this expediency, and of employing private force to resist even private oppression, a doctrine productive of anarchy and, in consequence, equally fatal to civil liberty as tyranny itself. For civil liberty, rightly understood, consists in protecting the rights of individuals by the united force of society. Society cannot be maintained, and of course can exert no protection, without obedience to some sovereign power. And obedience is an empty name if every individual has a right to decide how far he himself shall obey. In the exercise, therefore, of those prerogatives which the law has given him, the sovereign is irresistible and absolute, according to the forms of the Constitution. And yet, if the consequence of that exercise be manifestly to the grievance or dishonor of the kingdom, the Parliament will call his advisers to a just and severe account. For prerogative consisting, as Locke has well defined it, in the discretionary power of acting for the public good, where the positive laws are silent, if that discretionary power be abused to the public detriment, such prerogative is exerted in an unconstitutional manner. Thus the sovereign may make a treaty with a foreign state, which shall irrevocably bind the nation, and yet when such treaties have been judged pernicious, impeachments have pursued those ministers, by whose agency or advice they were concluded. The prerogatives of the crown, in the sense under which we are now considering them, respect either this nation's intercourse with foreign nations, or its own domestic government and civil polity. With regard to foreign concerns, the sovereign is the delegate or representative of his people. It is impossible that the individuals of a state, in their collective capacity, can transact the affairs of that state with another community equally numerous as themselves. Unanimity must be wanting to their measures, and strength to the execution of their counsels. In the Sovereign. On Gov. 2 Section. Ambassadors. 223 Therefore, as in a centre, all the rays of his people are united, and form by that union a consistency, splendor, and power, that make him feared and respected by foreign potentates, who would scruple to enter into any engagement that must afterwards be revised and ratified by a popular assembly. What is done by the royal authority, with regard to foreign powers, is the act of the whole nation. What is done without the concurrence of the crown, is the act only of private men. And so far is this point carried by our law, that it has been held asterisk that should all the subjects of England make war with a king in league with the King of England, without the royal assent, such a backlash is no breach of the league. And, by the statute 2 Hen. V.C. 6, any subject committing acts of hostility upon any nation in league with the king was declared to be guilty of high treason. And though that act was repealed by statute 20 Hen. Vi. C. 11, so far as relates to the making this offense high treason, Yet still it remains a very great offense against the law of nations and punishable by our laws, either capitally or otherwise, according to the circumstances of the case. 1. The sovereign, therefore, considered as the representative of his people, has the sole power of sending ambassadors to foreign states and receiving ambassadors at home. This may lead us into a short digression, by way of inquiry, how far the municipal laws of England intermeddle with or protect the rights of these messengers from one potentate to another, whom we call ambassadors. The rights, the powers, the duties, and the privileges of ambassadors are determined by the law of nature and nations and not by any municipal constitutions. For, as they represent the persons of their respective masters, who owe no subjection to any laws but those of their own country, their actions are not subject to the control of the private law of that state, wherein they are appointed to reside. He that is subject to the coercion of laws is necessarily dependent on that power by whom those laws were made. But an ambassador ought to be in 4 inst. 152. Church, the Statute 11 and 12 Vic. C. 100a. Asterisk doubts having arisen whether diplow was passed to authorize the crown diplomatic relations could be established enter into such relations, provided with the Pope, who was, at that time, ambassador or diplomatic agent of the temporal sovereign of the states of the Pope were not an ecclesiastic. The royal prerogative, dependent of every power except that by which he is sent, and till of consequence ought not to be subject to the mere municipal laws of that nation wherein he is to exercise his functions. If he grossly offends, or makes an ill use of his character, he may be sent home and accused before his master *, who is bound either to do justice upon him, or avow himself the accomplice of his crimes. But there is great dispute among the writers on the laws of nations, whether this exemption of ambassadors extends to all crimes, as well natural as positive, or whether it only extends to such as are mala prohibita, as coining, and not to those that are mala in se, as murder. Registered our law seems to have formerly taken in the restriction, as well as the general exemption. For it has been held, both by our common lawyers and civilians, that an ambassador is privileged by the law of nature and nations, and yet, if he commits any offense against the law of reason and nature, he shall lose his privilege. And that therefore, if an ambassador conspires the death of the sovereign in whose land he is, he may be condemned and executed for treason, but if he commits any other species of treason, it is otherwise, and he must be sent to his own kingdom. And these positions seem to be built upon good appearance of reason. For since, as we have formerly shown, all municipal laws act in subordination to the primary law of nature, and, where they annex a punishment to natural crimes, are only declaratory of and auxiliary to that law, therefore to this natural universal rule of justice ambassadors, as well as other men, are subject in all countries, and of consequence it is reasonable that, wherever they transgress it, they shall be liable to make atonement. But, however these principles might formerly obtain, the general practice of this country, as well as of the rest of Europe, seems now to pursue the sentiments of the learned Grotius, that the decrees as was done with Count Gyllenberg, Tugi's ambassador, was arrested by order the Swedish minister, A.D. 1716. Of Cromwell, and afterwards tried, con *sp. L. 26-21. Victed and executed for an atrocious Van Leeuwen in ff. 57-17. Bar murder. 1 Halo, p. c. 99, Foster, 188. Baydox Puff. 1. 8 c. 9, section 9 and 17. Van the prisoner pleaded the privilege of Beinkerschuk to foroligator, cc. 17-18, ambassadors, but failed to prove that he 9 was joined with his brother in the com *1 co u. Rep. 175. 3 bolster. 27. Mission. A fact which must have been *= 4 ints. 153. Unknown to human Vattel, who con. 1 roll. Rep. 185. Cited the proceedings of the Protector of Foster's reports, 188. In 1:654, breach of the law of nations. Vattel b. Dong Pantelin Saw, brother of T. Lipor. Ambassadors. 225 Security of ambassadors is of more importance than the punishment of a particular crime. And therefore few, if any, examples have happened within the last 2 centuries, where an ambassador has been punished for any offense, however atrocious in its nature. In respect to civil suits, all the foreign jurists agree that neither an ambassador nor any of his train or commites can be prosecuted for any debt or contract in the courts of that kingdom wherein he is sent to reside. Yet Sir Edward Coke maintains that if an ambassador make a contract which is good gentium he shall answer for it here. But the truth is, so few cases, if any, had arisen, wherein the privilege was either claimed or disputed, even with regard to civil suits, that our law books are in general quite silent upon it previous to the reign of Queen Xvnne, when an ambassador from Peter the Great, Tsar of Jalaskovy, was actually arrested and taken out of his coach in London, for a debt of £50 which he had there contracted. Instead of applying to be discharged upon his privilege, he gave bail to the action, and the next day complained to the Queen. The persons who were concerned in the arrest were examined before the Privy Council, of which the Lord Chief Justice Holt was at the same time sworn a member, and 17 were committed to prison, most of whom were prosecuted by information in the Court of Queen's Bench, at the suit of the Attorney General, and at their trial before the Lord Chief Justice were convicted of the facts by the jury, reserving the question of law, how far those facts were criminal, to be afterwards argued before the judges, which question was never determined. In the meantime the Tsar resented this affront very highly, and demanded that the Sheriff of Middlesex and all others concerned in the arrest should be punished with instant death. But the Queen, to the amazement of that despotic court, directed her secretary to inform him that she could inflict no punishment upon any, the meanest of her subjects, unless warranted by the law of the land, and therefore was persuaded that he would not insist upon possibilities to satisfy, however, the clamors of the foreign ministers, who made it a common cause as well as to appease the wrath of Peter. A bill was brought into Parliament, and afterwards securiteg legatorum at uitati, qua expona et pr exponderat. De jure b. and p. 1, 2c, 18 section 4. For inst. 153. Vol. 226. The EAL prerogative passed into a law to prevent and punish such outrageous insolence for the future. And with a copy of this act, elegantly engrossed and illuminated, accompanied by a letter from the Queen, an ambassador extraordinary was commissioned to appear at Moscow, who declared that though Her Majesty could not inflict such a punishment as was required, because of the defect in that particular of the former established constitutions of her kingdom, yet with the unanimous consent of the Parliament, she had caused a new act to be passed to serve as a law for the future. This humiliating step was accepted as a full satisfaction by the Tsar, and the offenders, at his request, were discharged from all farther prosecution. This statute 7 N.C. 12 recites the arrest which had been made in contempt of the protection granted by Her Majesty, contrary to the law of nations and in prejudice of the rights and privileges which ambassadors and other public ministers have at all times been thereby possessed of, and ought to be kept sacred and inviolable. Wherefore it enacts that for the future all process whereby the person of any ambassador, or of his domestic or domestic servant may be arrested, or his goods distrained or seized, shall be utterly null and void. And the persons prosecuting, soliciting, or executing such process shall be deemed violators of the law of nations and disturbers of the public repose, and shall suffer such penalties and corporal punishment as the Lord Chancellor and the 2 Chief Justices, or any of them, shall think fit. But it is expressly provided that no traitor within the description of the bankruptcy laws, who shall be in the service of any ambassador, shall be privileged or protected by this act, nor shall any one be punished for arresting an ambassador's servant, unless his name be registered with the Secretary of State, and by him transmitted to the Sheriffs of London and Middlesex, exceptions that are strictly conformable to the rights of ambassadors, as observed in the most civilized countries. And, in consequence of this statute, thus declaring and enforcing the law of nations, these privileges are now held to be part of the law of the land, and are constantly allowed in the courts of common law. 2. It is also the prerogative of the Crown to make treaties Boyer's Annals of Queen Anne. Van Beinkersch c. 15 Prop Finum. Fitzk. 200, Straw. Making war or peace. 227 leagues and alliances with foreign states and princes. For it is by the law of nations essential to the goodness of a league that it be made by the sovereign power, decrees, and then it is binding upon the whole community. And in England the sovereign power, quod hoc, is vested in the king. Whatever contracts, therefore, he engages in, no other power in the kingdom can legally delay, resist, or annul. And yet, lest this plenitude of authority should be abused to the detriment of the public, the Constitution, as was hinted before, has here interposed a check, by the means of parliamentary impeachment, for the punishment of such ministers, as from criminal motives advise or conclude any treaty, which shall afterwards be judged to derogate from the honor and interest of the nation. 3. Upon the same principle also the sole prerogative of making war and peace is vested in the Crown, for it is held by all the writers on the law of nature and nations, that the right of making war, which by nature subsisted in every individual, is given up by all private persons that enter into society, and is vested in the sovereign power. And this right is given up not only by individuals, but even by the entire body of people, that are under the dominion of a sovereign. It would indeed be extremely improper that any number of subjects should have the power of binding the supreme magistrate, and putting him against his will in a state of war. Whatever hostilities, therefore, may be committed by private citizens, the state ought not to be afflicted thereby, unless that should justify their proceedings and thereby become partner in the guilt. Such unauthorized volunteers in violence are not ranked among open enemies, but are treated like pirates and robbers. According to that rule of the civil law haes hae sunt qui nobis, aequibus nos pulis helium decrevimus, si ceteri latrons aut piarceton sunt. And the reason which is given by Grotius, why according to the law of nations a denunciation of war ought always to precede the actual commencement of hostilities, is not so much that the enemy may be put upon his guard, which is matter rather of magnanimity than right, but that it may be certainly clear that the war is not undertaken by private persons, but by the will of the whole community, whose puff. 11. N. V. A. C. 9, Section 6, ff. 50, 16, 118. P. Puff. B. 8 C. 6, Section 8, and Barbier, N. De jure B. and P. 1. 3 C. 3, Section 11. Right of willing is in this case transferred to the supreme magistrate by the fundamental laws of society, so that in order to make a war completely effectual, it is necessary with us in England that it be publicly declared and duly proclaimed by the royal authority, and then all parts of both the contending nations, from the highest to the lowest, are bound by it. And wherever the right resides of beginning a national war, there also must reside the right of ending it, or the power of making peace. And the same check of parliamentary impeachment, for improper or inglorious conduct, in beginning, conducting, or concluding a national war, is in general sufficient to restrain the ministers of the crown from a wanton or injurious exercise of this great prerogative. 4. But as the delay of making the war may sometimes be detrimental to individuals who have suffered by depredations from foreign potentates, our laws have in some respects armed the subject with powers to impel the prerogative, by directing the ministers of the crown to issue letters of marque and reprisal upon due demand. The prerogative of granting, which is nearly related to, and plainly derived from, that other of making war, this being indeed only an incomplete state of hostilities, and generally ending in a formal denunciation of war. These letters are grantable by the law of nations whenever the subjects of one state are oppressed and injured by those of another, are indeed justices denied by that state to which the oppressor belongs. In this case, letters of marque and reprisals, words used as synonymous and signifying, the latter, a taking in return, the former, the passing the frontiers in order to such taking may be obtained, in order to seize the bodies or goods of the subjects of the offending state, until satisfaction be made, wherever they happen to be found. And indeed this custom of reprisal seems dictated by nature herself, for which reason we find in the most ancient times very notable instances of it. But here the necessity is obvious of calling in the sovereign power to determine when. Grat. De jure B. and P. 1. 3 C. 2. at the Olympian Games by his father Neleus. Dafresni, tit. Markup. And for debts due to many private subjects. See the account given by Nestor in of the Pylian kingdom, out of which the 11th book of the Iliad, of the booty the king took 300 cattle reprisals made by himself on the Epean for his own demand, and the rest were nation, from whom he took a multitude equably divided among the other credit of cattle, as a satisfaction for prize 1 tors. Granting safe conducts. 229 reprisals may be made, else every private sufferer would be a judge in his own cause. In pursuance of which principle it is with us declared by the statute forehand. VC 7. That if any subjects of the realm are oppressed in the time of truce by any foreigners, the king will grant mark in due form to all that feel themselves grieved. Which form is thus directed to be observed. The sufferer must first apply to the Lord Privy Seal, and he shall make out letters of request under the Privy-Seal, and if, after such request of satisfaction made, the party required do not within a convenient time make due satisfaction or restitution to the party grieved, the Lord Chancellor shall make him out letters of marque under the Great Seal, and by virtue of these he may attack and seize the property of the aggressors. Nation without hazard of being condemned as a robber or pirate. But the granting of letters of marque under this statute has long been disused. If during war a subject, not having a commission from the crown, should take an enemy's ship, the prize would belong, not to the captor but to the sovereign, or to the admiral as his grantee. And therefore to encourage the fitting out of armed vessels in time of war, the Lord High Admiral, or Lords Commissioners of the Admiralty, are authorized by several statutes to grant commissions to private persons fitting out such ships, which are thence called privateers. Any prizes captured by such vessels are divided according to the terms of the agreement between the owners and the master and crew. But the Crown has nevertheless the prerogative of releasing a prize at any time previous to its condemnation in the prize court. Letters of marque, as these commissions are also called, are valid only during the war, and may be vacated either by express revocation, or by the cruelty or other misconduct of the parties. Carth 399. To wood 433. Belike inviolable. The conference was *29 Geo, Roman 2. C. 34. 19 Geo, Roman 3. C. G7. Of opinion that the adjudication of J.J. Revutier 24 Geo. Il C. 47. Ing and the acknowledgement of neutral *Sterling v. Vaughan, 11 East, 6 and 9 rights were alike desirable and necessary. 5 Rob. Adam, Rep. 9. For improving our system of war, and the siege on Ferenco which met at Paris, bringing it into harmony with the ideas in 1856, after the close of the war with and principles of modern civilization. Russia closed its labors by recommend this proclaimed opinion of several of ing to the established governments of the great powers of Europe may possibly world t entire abolition of the system lead to treaties, by which the prerogative of privateering, and that in time of wartime of the crown in issuing letters of neutral flags and neutral goods should mark will become matter of history. 230 The Coil Prerogative. 5. Upon exactly the same reason stands the prerogative of granting safe conducts, without which, by the law of nations, no member of one society has a right to intrude into another. And therefore Pufendorf very justly resolves that it is left in the power of all states to take such measures about the admission of strangers as they think convenient, those being ever excepted who are driven on the coast by necessity, or by any cause that deserves pity or compassion. Great tenderness is shown by our laws, not only to foreigners in distress, as will appear when we come to speak of shipwrecks, but with regard also to the admission of strangers who come spontaneously. For so long as their nation continues at peace with ours, and they themselves behave peaceably, they are under the protection of the laws, though liable to be sent home whenever the sovereign sees occasion. But no subject of a nation at war with us can, by the law of nations, come into the realm, nor can travel himself upon the high seas, or send his goods and merchandise from one place to another, without danger of being seized by our subjects, unless he has letters of safe conduct, which by divers ancient statutes must be granted under the Great Seal and enrolled in Chancery, or else are of no effect. the sovereign being supposed the best judge of such emergencies as may deserve exemption from the general law of arms. But passports under the sign manual, or licenses from our ambassadors abroad, are now more usually obtained, and are allowed to be of equal validity. A subject of a friendly state, however, may freely enter and as freely leave the realm, but when he enters, he is required by the statute 6 and 7 will. Roman 4. c. 11. To make a declaration of his name and country, of the registration of which a certificate is given to him, to be delivered up on his again leaving the country, the object of this registration being to keep the government informed of the number and names of resident foreigners, so that criminals or persons infringing our laws may be summarily removed from the kingdom. Indeed, the law of England, as a commercial country, pays a very particular regard to foreign merchants in innumerable instances. One I cannot omit to mention. That by Magnus C. Law of Nature and Nations, 8 Vict. c. 66, 10 and 11 Vict. c. 83. v. 3. 0. 3, Section 9. 15 Hen. vi. c. 3. 18 Hen. vi. c. 8 C. Stat. 6 and 7 will. Roman 4. c. 11, 7 and 29 Hen. vi. c. 2. Charta it is provided that all merchants, unless publicly prohibited beforehand, shall have safe conduct to depart from, to come into, to tarry in, and to go through England, for the exercise of merchandise without any unreasonable impose except in time of war. And if a war breaks out between us and their country, they shall be attached, if in England, without harm of body or goods, till the king or his chief justiciary be informed how our merchants are treated in the land with which we are at war. And, if ours be secure in that land, they shall be secure in ours. This seems to have been a common rule of equity among all the northern nations, for we learn from Steamoke that it was a maxim among the Goths and Swedes, quam legem exturi nobis 20 sura, indem illis poemis. But it is somewhat extraordinary that it should have found a place in Magna Charta, a mere interior treaty between the king and his natural-born subjects, which occasions the learned Montesquieu to remark with a degree of admiration, that the English have made the protection of foreign merchants one of the articles of their national liberty. But indeed it well justifies another observation which he has made, that the English know better than any other people upon earth how to value at the same time these three great advantages: religion, liberty, and commerce. Very different from the genius of the Conmu people, who in their manners, their constitution, and even in their laws treated commerce as a dishonorable employment and prohibited the exercise thereof to persons of birth, or rank, or fortune. And equally different from the bigotry of the canonists, who looked on trade as inconsistent with Christianity *, and determined at the Council of Melfi, under Pope Urban Roman II, A.D. 1090, that it was impossible with a safe conscience to exercise any traffic, or follow the profession of the law. These are the principal prerogatives of the sovereign respecting this nation's intercourse with foreign nations, in all of which he is considered as the delegate or representative of his people. But in domestic affairs he is considered in a great variety of on the declaration of war against vessels returning from foreign ports to Russia, in 1854, time was, by proclaimeth those of Russia were also for a certain tion, allowed to the subjects of that period of time exempted from capture, prior to remove from Tili Kedum and Decret 18811, also to clear their vessels at all our ports. Ac. Condi, Apud Baron c. 16. 232 The royal prerogative. Characters, and from thence there arises an abundant number of other prerogatives. 1. First, he is a constituent part of the supreme legislative power, and, as such, has the prerogative of rejecting such provisions in Parliament as he judges improper to be passed, the expediency of which constitution has before been evinced at large. I shall only farther remark that the sovereign is not bound by any act of Parliament unless he be named therein by special and particular words, the most general words that can be devised. Any person or persons, bodies politic or corporate, and affect not him in the least, if they may tend to restrain or diminish any of his rights or interests. For it would be of most mischievous consequence to the public, if the strength of the executive power were liable to be curtailed without its own express consent, by constructions and implications of the subject. Yet, where an act of Parliament is expressly made for the preservation of public rights and the suppression of public wrongs, and does not interfere with the established rights of the Crown, it is said to be binding as well upon the sovereign as upon the subject: and, likewise, the sovereign may take the benefit of any particular act, though he be not especially named. (2) The sovereign is considered, in the next place, as the generalissimo, or the first in the military command, within the kingdom. The great end of society is to protect the weakness of individuals by the united strength of the community. And the principal use of government is to direct that united strength in the best and most effectual manner, to answer the end proposed. Monarchical government is allowed to be the fittest of any for this purpose. It follows, therefore, from the very end of its institution, that in a monarchy the military power must be trusted in the hands of the prince. In this capacity, therefore, of general of the kingdom, the sovereign has the sole power of raising and regulating fleets and armies. Of the manner in which they are raised and regulated, I shall speak more when I come to consider the military state. We are now only to consider the prerogative of enlisting and of governing them, which indeed was disputed and claimed, contrary to all reason and precedent, by the Long Parliament of 8 case of Magdalen College, 11 Rep. 74. 11 Rep. 71. 7. Appointment of havens. 233 King Charles I, but, upon the restoration of his son, was solemnly declared by Statute 13 Car. Roman 2. c. 6 to be in the king alone, for that the sole supreme government and command of the militia within all his majesty's realms and dominions, and of all forces by sea and land, and of all forts and places of strength, ever was and is the undoubted right of his majesty, and his royal predecessors kings and queens of England, and that both or either House of Parliament cannot, nor ought to pretend to the same. This statute, it is obvious to observe, extends not only to fleets and armies, but also to forts and other places of strength within the realm. The sole prerogative as well of erecting, as manning and governing of which belongs to the sovereign in his capacity of general of the kingdom. And all lands were formerly subject to a tax, for building of castles wherever the king thought proper. This was one of the 3 things, from contributing to the performance of which no lands were exempted, and therefore called by our Saxon ancestors the Trinota necessitas, sc. Hontes reparcuio, arsis construtio, et expeditio contra hosteni. And this they were called upon to do, so often that, in the time of Henry Roman II, as Sir Edward Coke from Paris assures us, there were 1,115 castles subsisting in England, the inconveniences of which, when granted out to private subjects, the lordly barons of those times, were severely felt by the whole kingdom, for as William of Newburgh remarks in the reign of King Stephen, erant in Anglid quadamodo tot reges vel potiutiani quatamini ** castlerum. But it was felt by none more sensibly than by 2 succeeding princes, King John and King Henry Roman III. And, therefore, the greatest part of them being demolished in the barons' wars, the kings of after times have been very cautious of suffering them to be rebuilt in a fortified manner. And Sir Edward Coke lays it down, that no subject can build a castle, or house of strength, embattled, or other fortress defensible, without the license of the crown, for the danger which might ensue, if every man at his pleasure might do it. It is partly upon the same, and partly upon a fiscal foundation, to second his marine revenue, that the sovereign has the prerogative of appointing ports and havens, or such places only for persons and merchandise to pass into and out of the realm, as he in his wisdom sees proper. By the feudal law all navigable J. Cowles Incup, lit. Casalorum operario, seld. Jan. Adage. The royal prerogative. Rivers and havens were computed among the regalia and were subject to the sovereign of the state. And in England it has always been holden, that the sovereign is lord of the whole shore, and particularly is the guardian of the ports and havens which are the inlets and gates of the realm. And therefore, so early as the reign of King John, we find ships seized by the king's officers for putting in at a place that was not a legal port. Trade. These legal ports were undoubtedly at first assigned by the crown, since to each of them a court of portmote is incident, the jurisdiction of which must flow from the royal authority. The great ports of the sea are also referred to as well known and established by statute 4 Hen. Roman 4. c. 20, which prohibits the landing elsewhere under pain of confiscation, and the statute 1 Eliz. c. 11 recites that the franchise of lading and discharging had been frequently granted by the crown. But though the king had a power of granting the franchise of havens and ports, yet he had not the power of resumption, or of narrowing and confining their limits when once established, but any person had a right to load or discharge his merchandise in any part of the haven, whereby the revenue of the customs was much impaired and diminished by fraudulent landings in obscure and private corners. This occasioned the statutes of 1 Eliz. c. 11 and 13 and 14 Car. Roman 2. c. 11 s. 14, which enabled the crown by commission to ascertain the limits of all ports, and to assign proper ivharfs and keys in each port, for the exclusive landing and loading of merchandise. A power which has since been transferred to, and is now more appropriately vested in, the commissioners of the treasury. No pier, jetty, or embankment can, however, be erected in or near to any public harbor, without notice to the Admiralty, and the Board of Trade is now enabled to authorize the construction of piers and harbors, subject to the future confirmation of Parliament. The erection of beacons, lighthouses, and seamarks is also a branch of the royal prerogative, whereof the first was antent like a 2 feud. T. 56. C. 150. Dav. 956. Mayor of Exeter v. P. 16 and 17 Vic. C. EO 7 S. 9. Warren 5Q. V. 773. Under a penalty of £200. 46 Geo. Maddox. His. Ext. 530. Roman 3. C. 153. Foreigns. 148. 24 and 25 Vict. C. 45, 30 and 31 Vic. C. Repealed by the statute 6 Geo. Erection of lighthouses. 235 used in order to alarm the country, in case of the approach of an enemy, and all of them are signally useful in guiding and preserving vessels at sea by night as well as by day. For this purpose the Crown has the exclusive power, by commission under the Great Seal, to cause them to be erected in fit and convenient places as well upon the lands of the subject as upon the demesnes of the Crown, which power is usually vested by letters patent in the office of Lord High Admiral, or the Lords Commissioners exercising such office, by the statute 8 Eliz. c. 13. The corporation of the Trinity House were empowered to set up any beacons or seamarks wherever they should think them necessary, and if the owner of the land or any other person destroyed them, or took down any steeple, tree, or other known seamark, he forfeited 1,001, or in case of inability to pay it, he was ipso facto outlawed. That particular statute, and others passed to amend it, have indeed been repealed, but the superintendence and management of all lighthouses, buoys, and beacons in England and Wales and the Channel Islands is still vested in the Trinity House. Asterisk to this branch of the prerogative may also be referred the power vested in the sovereign by statutes 16 and 17 Vict. c. 107 of prohibiting the importation of arms, ammunition, and gunpowder, and likewise the right which the sovereign has, whenever he sees proper, of confining his subjects to stay within the realm, or of recalling them when beyond the seas. By the common law, every man may go out of the realm for whatever cause he pleases, without obtaining the leave of the Crown, provided he is under no injunction of staying at home, which liberty was expressly declared in King John's Great Charter, though left out in that of Henry Roman III. But, because that every man ought of right to defend the sovereign and his realm, therefore the sovereign at his pleasure may command him by his writ that he go not beyond the seas, or out of the realm, without license, and, if he do the contrary, he shall be punished for disobeying the sovereign's command. Some persons there anciently were, that, by reason of their stations, were under a perpetual prohibition of going abroad without license obtained, among which were reckoned all peers, on account of their being counsellors of the crown, all knights, who are bound to defend the kingdom from invasions, all wrought. Glaus. 1 Ric. Roman 2. M. 42 Prin. On 4 Ainst 136. 17 and 18 Vic. C. 104 S. 389. Ecclesiastics, who are expressly confined by the constitutions of Clarendon, on account of their attachment to the See of Colm, all archers and other artificers, lest they should instruct foreigners to rival us in their several trades and manufactures. This was the law in the times of Britain, who wrote in the reign of Edward I. And Sir Edward Coke gives us many instances to this effect in the time of Edward Roman III. In the succeeding reign the affair of travelling wore a very different aspect, an Act of Parliament being made, forbidding all persons whatever to go abroad without license, except only the lords and other great men of the realm, and true and notable merchants, and the king's soldiers. But this act was repealed by the statute for Jack I. C. 1. And at present everybody has, or at least assumes, the liberty of going abroad when he pleases. Yet undoubtedly if the sovereign by the writ of an exit regno under his great seal or privy seal, thinks proper to prohibit him from so doing, and the subject disobeys, it is a high contempt of the royal prerogative, for which the offender's lands shall be seized till he return. And then he is liable to fine and imprisonment. 3. Another capacity, in which the sovereign is considered in domestic affairs, is as the fountain of justice and general conservator of the peace of the kingdom. By the fountain of justice the law does not mean the author or origin, but only the distributor. Justice is not derived from the sovereign, as from his free gift, but he is the steward of the public to dispense it to whom it is due. He is not the spring, but the reservoir, from whence right and equity are conducted, by 1,000 channels to every individual. The original power of judicature, by the fundamental 5 I. Roman 2. Sin. 1 C. 2. So fully established, that the granting the writ of ne exit regno was that of it has long been considered a matter first employed to prevent the clergy of right. Beams on ne exit regno. From going to Eam, it was afterwards. 1 Hawk. P. C. 22. Sir William extended to laymen concerning measures. Blackstone adds here, that the king may, against the state, and it lately became send a writ to any man when abroad a part of the ordinary process of the commanding his return, but the exert chancery, in order to get bail from any size of this prerogative lias been long person, about to go abroad so as to with this suist, and it is not at all probable that draw his person or property from it will ever be resumed. 3 Inst. 84. Jurisdiction. The legality of this appli ad hoc autem creatis ast et electus, ut cataean of the writ was settled in the time justitium faciat universis. Brac. 1. 3. Tr. Of Charles Roman II, and its use soon became 1. The fountain of justice. 237 Principles of Society is lodged in the society at large, but as it would be impracticable to render complete justice to every individual, by the people in their collective capacity, therefore every nation has committed that power to certain select magistrates, who with more ease and expedition can hear and determine complaints, and in England this authority has immemorially been exercised by the sovereign or his substitutes. He therefore has alone the right of erecting courts of judicature, for, though the constitution of the kingdom has entrusted him with the whole executive power of the laws, it is impossible, as well as improper, that he should personally carry into execution this great and extensive trust. It is consequently necessary that courts should be erected to assist him in executing this power, and equally necessary that, if erected, they should be erected by his authority, and hence it is that all jurisdictions of courts are either mediately or immediately derived from the crown. The proceedings run generally in the sovereign's name, and are executed by his awful beasters. It is probable, and almost certain that in very early times, before our Constitution arrived at its full perfection, our sovereign in person often heard and determined causes between party and party. But at present, by the long and uniform usage of many ages, our sovereigns have delegated their whole judicial power to the judges of their several courts, which are the grand depositaries of the fundamental laws of the kingdom, and have gained a known and stated jurisdiction, regulated by certain and established rules, which the Crown itself cannot now alter but by Act of Parliament. In this distinct and separate existence of the judicial power in a peculiar body of men, nominated indeed, but not removable at pleasure by the Crown, consists one main preservative of the public liberty, which cannot subsist long in any state, unless the administration of common justice be in some degree separated, but courts erected by the sovereign course of the common law can only proceed according to the course erected by Act of Parliament as for the common law. The Queen, for example, the courts of bankruptcy and instance could not now erect a court of the county courts, chancery or a court of conscience, although thus the jurisdiction in equity and she make grant the franchise of a market admiralty possessed by the county courts and the court of pipe powder incident there may be conferred on the inferior courts too. Deg. Prerogative D. 20a. Courts, by order in council, issued in pursuance whose procedure is not according to the of the Judicature Act. 238. The royal prerogative, both from the legislative and also from the executive power. Were it joined with the legislative, the life, liberty, and property of the subject would be in the hands of arbitrary judges, whose decisions would be then regulated only by their own opinions and not by any fundamental principles of law, which, though legislators may depart from, yet judges are bound to observe. Were it joined with the executive, this union might soon be an overbalance for the legislative. For which reason, by the Statute of 16 Car. I. C. 10, which abolished the Court of Star Chamber, effectual care is taken to remove all judicial power out of the hands of the Privy Council, who, as then was evident from recent instances, might soon be inclined to pronounce that for law, which was most agreeable to the Prince or his officers. Nothing therefore is more to be avoided in a free constitution than uniting the provinces of a judge and a minister of state. In order to maintain both the dignity and independence of the judges in the superior courts, it was enacted by the Act of Settlement that their commissions should be made not, as formerly, durante hinc placido, but quambiu benici giserent, and their salaries ascertained and established, but that it should be lawful to remove them on the address of both Houses of Parliament. This provision has been reenacted in subsequent statutes, enabling the Crown to appoint additional judges, and specifically in the Judicature Act, 1873. In criminal proceedings, or prosecutions for offences, it would be absurd if the sovereign personally sat in judgment, because in regard to these he appears in another capacity, that oi prosecutor. Sir William Blackstone here adds of the judges as essential to the impartial that by teli noble improvements of that administration of justice, as one of the law in the statute of 1 Geo. Roman 3. c. 23. Best securities of the rights and liberties enacted at the earnest recommendation of his subjects, and is most conducive to of teli king himself from the throne, to the honor of teli crown. BL. Com. Vol. I. Judges are continued in their awful says during p. 2G7. The learned commentator much their good behavior, notwithstanding exaggerates the value of the statute 1 any demise of the crown, which was Geo. Roman 3. c. 23. The independence of the formerly held immediately to vacate their judges, says Mr. Hallam, we owe to seats, and their full salaries are absolutely the act of settlement, not, as ignorance secured to them during the continuance and adulation have perpetually asserted, of their commissions, His Majesty having to George III. See further been pleased to declare, that he looked Hallam's constitutional history of upon the independence and uprightness England, v. Roman 3. Cly. Roman 15. The public prosecutor. 239. All offences are, theoretically, against either the peace of the sovereign or his crown and dignity, for though in their consequences they generally seem, except in the case of treason, and a very few others to be rather offences against the kingdom than the crown, yet, as the public, which is an invisible body, has delegated all its power and rights, with regard to the execution of the laws, to one visible magistrate, all affronts to that power, and breaches of those rights, are immediately offences against him, to whom they are so delegated by the public. He is therefore the proper person to prosecute for all public offences and breaches of the peace, being the person injured in the eye of the law. And this notion was carried so far as the old Gothic constitution, wherein the sovereign was bound by his coronation oath to conserve the peace, that in case of any forcible injury offered to the person of a fellow subject, the offender was accused of a kind of perjury, in having violated the coronation oath. Dice heter fregis juramentum regis juratum da, and hence also arises another branch of the prerogative, that of pardoning offences, for it is reasonable that he only who is injured should have the power of forgiving. Of prosecutions and pardons I shall treat more at large hereafter, and only mention them here, in this cursory manner, to show the constitutional grounds of this power of the Crown, and how regularly connected all the links are in this vast chain of prerogative. A consequence of this prerogative is the legal ubiquity of the sovereign. In the eye of the law he is always present in all his courts, though he cannot personally distribute justice. His judges are the mirror by which his image is reflected. It is the R. Egil J. Fis, and not the royal person, that is always present in court, always ready to undertake prosecutions or pronounce judgment for the benefit and protection of the subject. And from this ubiquity it follows that the Crown can never beat. Stern. De jure Goth. 1. 3c. 3. A much from the legal fiction that the notion somewhat similar to this may be sovereign is the injured party, as from found in the mirror, c. 1 section 5. And so the necessity of placing it where it mag also, when the Chief Justice Thorpe was be promptly and judiciously exercised, condemned to be hanged for bribery, he the executive has, therefore, in all canuas sed gacramentum domini regis fretris naturally and necessarily been injurious. Ra. Perry. 2.5 Edwell. Roman 3. Vested with this prerogative. Hargrave. The prerogative of mercy would referring to 3 ints. 233, Shower 284, seem to be lodged in the Crown, not so ld. Rame 214, and 2t. The royal prerogative. Non-suit, for non-suit is the desertion of the suit or action by the non-appearance of the plaintiff in court. For the same reason also, in the forms of legal proceedings, the sovereign is not said to appear by his attorney, as other men do, for in contemplation of law he is always present in court. From the same origin of the sovereign being the fountain of justice, we may also deduce the prerogative of issuing proclamations, which is vested in him alone. These proclamations have then a binding force, when they are grounded upon and enforce the laws of the realm. For though the making of laws is entirely the work of a distinct part, the legislative branch, of the sovereign power, yet the manner, time, and circumstances of putting those laws in execution must frequently be left to the discretion of the executive magistrate. And therefore his constitutions or edicts concerning these points, which we call proclamations, are binding upon the subject, where they do not either contradict the old laws or tend to establish new ones, but only enforce the execution of such laws as are already in being, in such manner as the sovereign shall judge necessary. Thus the established law is, that the sovereign may prohibit any of his subjects from leaving the realm. A proclamation therefore forbidding this in general for 3 weeks, by laying an embargo upon all shipping in time of war, will be equally binding as an act of Parliament, because founded upon a prior law. But a proclamation to lay an embargo in time of peace upon all vessels laden with wheat, though in the time of a public scarcity, being contrary to law, and particularly to Statute 22 Car. Roman 2. c. 13. The advisers of such a proclamation, and all persons acting under it, found it necessary to be indemnified by a special Act of Parliament, 7 Geo. Roman 3. c. 7. A proclamation for disarming papists was binding, so long as it was in execution of what the legislature had first ordained. But a proclamation for allowing arms to papists, or for disarming any Protestant subjects, would not bind, because the first would have been to assume a dispensing power, the latter a legislative one, to the vesting of either of which in any single person the laws of England are absolutely strangers. indeed by the Statute 31 Hen. Roman A. C. 8. It was enacted that the king's proclamation should have the force of acts of parla. Co. Lit. 139. But the attorney which has the same effect as a non-suit in general may enter a non-volt prosqui, a civil action. The Fountain of Honor. 241 meant a statute which was calculated to introduce the most despotic tyranny, and which must have proved fatal to the liberties of this kingdom, had it not been luckily repealed in the minority of his successor, about 5 years after dot registered 4. The sovereign is likewise the fountain of honor of office, and of privilege, and this in a different sense from that wherein he is styled the fountain of justice, for here he is really the parent of them. It is impossible that government can be maintained without a due subordination of rank, that the people may know and distinguish such as are set over them, in order to yield them their due respect and obedience, and also that the officers themselves, being encouraged by emulation and the hopes of superiority, may the better discharge their functions. And the law supposes that no one can be so good a judge of their several merits and services as the sovereign himself who employs them. It has therefore entrusted him with the sole power of conferring dignities and honors, in confidence that he will bestow them upon none but such as deserve them, and therefore all degrees of nobility, of knighthood, and other titles are received by immediate grant from the crown, either expressed in writing, by writs or letters patent, as in the creation of peers and baronets, or by corporeal investiture, as in the creation of a simple knight. From the same principle also arises the prerogative of erecting and disposing of offices, for honors and offices are in their nature convertible and synonymous. All offices under the crown carry in the eye of the law an honor along with them, because they imply a superiority of parts and abilities, being supposed to be always filled by those that are most able to execute them. And, on the other hand, all honors in their origin had duties or offices annexed to them. An earl, Comes, was the conservator or governor of a county, and a knight, Miles, was bound to attend the king in his wars. For the same reason therefore that honors are in the disposal of the sovereign, offices ought to be one edwa, vi. C. 12. The Statute 31 Clamation concern. Any kind of hen. Roman 8. C. 8 contained a proviso that heresies against Christian doctrine, SNCH proclamation should not be which might bo punished with death, judicial to any person's inheritance. Awful B says, Beaumont says that upon this statute were liberties, goods and chattels, or infringe grounded all the clienges in the national the established laws. The penalty was religion made during no minority of fine and imprisonment, unless the pro etward vi. Vol. I. R. The royal prerogative. So likewise, and as the sovereign may create new titles, so may he create new offices, but with this restriction, that he cannot create new offices, with new fees annexed to them, nor annex new fees to old offices, for this would be a tax upon the subject, which cannot be imposed but by act of Parliament. Wherefore, in 13 Hen. Roman 4 a new office being created by the king's letters patent for measuring cloths, with a new fee for the same, the letters patent were, on account of the new fee, revoked and declared void in Parliament. Upon the same, or like reason, the sovereign has also the prerogative of conferring privileges upon private persons, such as granting place or precedence to any of his subjects as shall seem good to his royal wisdom, or such as converting aliens or persons bomb out of his dominions into denizens, whereby some very considerable privileges of natural-born subjects are conferred upon them. Such also is the prerogative of erecting corporations, whereby a number of private persons are united and knit together, and enjoy many liberties, powers, and immunities in their political capacity, which they were utterly incapable of in their natural. Of aliens, denizens, natural-born, and naturalized subjects I shall speak more largely in a subsequent chapter, as also of corporations at the close of this book of our Commentaries. I now only mention them incidentally, in order to remark the royal prerogative of making them, which is grounded upon this foundation, that the sovereign, having the sole administration of the government in his hands, is the best and only judge in what capacities, with what privileges, and under what distinctions his people are best qualified to serve, and to act under him. Under this head, therefore, I may mention the power conferred on the Crown by Stat. 1 and 2 Vict. c. 2 to grant pensions annually to an amount not exceeding in all 1,200 z per annum to persons who have just claims on the royal beneficence, or who by their personal services to the Crown, by the performance of duties to the public, or by their useful discoveries in science and attainments in literature and the arts, have merited the gratitude of the country. 4 Ins. 361. The royal prerogative of state. This prerogative was unto give a peer, on his creation, precedence restrained in Ireland, until the 4th before all others of the same rank was article of the Union extended the statute restrained by the Statute 31 Hen. Roman 8. Of Henry Roman 8 if not to all peers of c. 10 which settles the place or priest Ireland, at least to all peers of the united dance of all the nobility and great officers kingdom created after the Union. As the arbiter of commerce. 243-5. Another light, in which the laws of England consider the sovereign with regard to domestic concerns, is as the arbiter of commerce. By commerce, I at present mean domestic commerce only. It would lead me into too large a field, if I were to attempt to enter upon the nature of foreign trade, its privileges, regulations, and restrictions, and would also be quite beside the purpose of these commentaries, which are confined to the laws of England, whereas no municipal laws can be sufficient to order and determine the very extensive and complicated affairs of traffic and merchandise, neither can they have a proper authority for this purpose. For as these are transactions carried on between subjects of independent states, the municipal laws of one will not be regarded by the other, for which reason the affairs of commerce are regulated by a law of their own, called the law merchant or lex mercatoria, which all nations agree in and take notice of. And in particular it is held to be part of the law of England, which decides the cause of merchants by the general rules which obtain in all commercial countries, and that often even in matters relating to domestic trade, as for instance with regard to the drawing, the acceptance, and transfer of inland bills of exchange. Asterisk to this branch of the prerogative, however, may be referred the important functions which are now exercised by the Board of Trade. On the Restoration, in 1660, Charles Roman II created a council for trade and a council for foreign plantations, which in 1072 were superseded by a united council of trade and orientations. Being abolished, however, in 1675, its duties were exercised by the Privy Council until 1695, when the Board of Trade and Plantations was again revived, but only to / finally abolished in 1782 by the Statute 22 Dio. Roman 3. c. 82, when the business, so far as relates to the colonies, was transferred to the Secretary of State, the remainder of its duties were performed by a committee of the Privy Council. 4 years afterwards, namely, in 1786, a separate department or Board of Trade was established by an ordering council, for all matters specially relating to trade and the colonies, and it is upon this board, whose chief officials are the President and Secretary, who are always members of the executive government, that many important duties relating to trade and commerce are devolved. It has the general superintendence of all matters 7 Geo. Roman 4. c. 32. 30 and 31 Vict. c. 72. 244 The royal prerogative relating to merchant ships and seamen, and the carrying into execution the several statutes in force relating to them. For that purpose it is to require and receive returns as to trade and navigation, and originate and consider reports made to it by its inspectors and other officers. The board has also a partial control over local marine boards and may lay down rules as to the conduct of examinations, and as to the qualification of applicants for the posts of masters and mates of foreign-going as well as of home trade passenger ships, and it examines and certifies the fitness of engineers and steam vessels. It may grant licenses to persons to engage or supply seamen or apprentices for merchant ships in the United Kingdom, and investigate cases of alleged incompetency and misconduct. It has extensive powers, previously exercised by the Admiralty, for the protection of navigation and over tidal waters and foreshores and harbors. It also appoints officers to inspect anchors and chain cables, and, finally, It has authority by its inspectors at different ports to stop unseaworthy vessels from proceeding to sea. Trademark. The Board of Trade exercises a supervision over railways and railway companies, not only with respect to their original formation, but also as to their subsequent working. Railways were first placed under this control by the Statute 3 and 4 Vict. c. 97. A few years afterwards, the powers of the Board of Trade in this respect were transferred to a Board of Commissioners of Railways. But in 1851 all the powers of this latter board were retransferred to the Board of Trade, in whom they are now vested. Notices of application for railway acts, accompanied by plans, must be deposited with the board before any bill can be introduced into Parliament, and before a line can be opened for traffic. Notice must be given to the board and its permission obtained, on the report of an inspector, appointed by the board for those and other general purposes. So when accidents occur, notice must be given to the board, and an inspector is generally sent to inquire into the circumstances, and on his report the board may cause alterations to be made for the greater safety of the public. Again, the Board of Trade is charged with the registration of 17 and 18 Vict. c. 104, 25 and 26 Vict. c. 27 and 28 Vict. c. 27. 63. 36 and 37 Vict. c. 76. J. 25 and 26 Vict. c. 09, 29 and 30 Vict. c. 36 and 37 Vict. c. 76. 62. 9 and 10 Vict. c. 105. I. 24 and 25 Vict. c. 45. 14 and 15 Vict. c. 64. The Board of Trade. 245 All joint stock companies, under the Statute 25 and 26 Vict. c. 89, and in particular with carrying out the provision of the Statute 33 and 34 Vict. c. 61, requiring life assurance companies to make periodical statements of their affairs. It also registers copyrights and designs. And under its control have been placed the schools of design now established in almost all the large towns of the kingdom, the appointments connected with them being made by its president, Parliament voting annually a sum of money for their support. The board is further charged with the collection and publication from time to time of tables containing information with respect to the revenue, trade, commerce, wealth, population, and other statistics of the realm. And one of its departments collects and prepares the tables of the prices of calm which regulate the rent charge to be paid in lieu of tithe under the Tithe Commutation Act. Subject to these general observations under this branch of the royal prerogative, so far as it relates to mere domestic commerce, fall the following articles. First, the establishment of two public marts, or places of buying and selling, such as markets and fairs, with the tolls thereunto belonging. These can be set up by virtue of the grant of the Crown, or by long and immemorial usage and prescription, which presupposes such a grant. The limitation of these public resorts to such time and such places may be most convenient for the neighborhood, forms a part of economics or domestic polity, which, considering the kingdom as a large family, and the sovereign as the master of it, he clearly has a right to dispose and order as he pleases. Secondly, the regulation of weights and measures. These, for the advantage of the public, ought to be universally the same throughout the kingdom, being the general criterions which reduce all things to the same or an equivalent value. But, as weight and measure are things in their nature arbitrary and uncertain, it is therefore expedient that they be reduced to some fixed rule or standard, which standard it is impossible to fix by any written law or oral proclamation, for no man can, by words 5 and 6 Vict. c. 100, 6 and 7 Vic. 65, *2 inst. 220. Mayor of Macclesfield v. 13 and 14 Vict. c. 104. Chapman 12m, and W. 18. 31 and 32 Vict. c. 33, 35 and 36 Vic. c. Teliai's right of establishing markets 18. And fewer cannot be exercised to the priests 6 and 7 will. Roman 4. c. 71, Judice of iure est previously vested. 246. The royal prerogative. Only give another an adequate idea of a foot rule or a pound weight. It is therefore necessary to have recourse to some visible, palpable, material standard, by forming a comparison with which all weights and measures may be reduced to one uniform size. And the prerogative of fixing this standard our ancient law vested in the crown, as in Normandy it belonged to the Duke. This standard was originally kept at Winchester. And we find in the laws of King Edgar, nearly a century before the conquest, an injunction that the one measure, which was kept at Winchester, should be observed throughout the realm. Most nations have regulated the standard of measures of length by comparison with the parts of the human body, as the palm, the hand, the span, the foot, the cubit, the ell, ulna, or arm, the pace, and the fathom. But as these are of different dimensions and men of different proportions, our ancient historians inform us that a new standard of longitudinal measure was ascertained by King Henry I, who commanded that the ulna or ancient ell, which answers to the modern yard, should be made of the exact length of his own arm. And, one standard of measures of length being gained, all others are easily derived from thence. Those of greater length by multiplying, those of less by subdividing, that original standard. Thus, by the statute called Cum Judicio Ulnarum I Percarum, 5 yards and a half make a perch, and the yard is subdivided into 3 feet, and each foot into 12 inches, which inches will be each of the length of 3 grains of barley. Superficial measures are derived by squaring those of length, and measures of capacity by cubing them. The standard of weights was originally taken from corns of wheat, whence the lowest denomination of weights we have is still called a grain, 32 of which are directed, by the statute called Cum Judicio Menturarum, to compose a pennyweight, whereof 20 make an ounce, 12 ounces a pound, and so upwards. And upon these principles the first standards were made, which, being originally so fixed by the crown, their subsequent regulations have been generally made by the sovereign Parliament. Thus, under King Icard I and his Parliament holden at Westminster, A.D. 1197, it was ordained that there should be only one weight and one measure throughout the kingdom, and that the custody of the assize or standard of gr. Custom c. 16. Will. Malmsp. Enmia hen, I. Spelm. Cap. 8. 1 Thorpe, 271. Hen, I. Apud Wilkins, 299. 2 weights and measures. 247 weights and measures should be committed to certain persons in every city or borough from whence the ancient office of the king's almoner seems to have been derived, whose duty it was, for a certain fee, to measure all cloths made for sale, till the office was abolished by the statute 11 and 12 Will. Roman 3. c. 20. In King John's time this ordinance of King Richard was frequently dispensed with for money, which occasioned a provision to be made for enforcing it. In the great charters of King John and his son. These original standards were called Pontes Regis and Mentura Domini Regis and were directed by a variety of subsequent statutes to be kept in the exchequer, and all weights and measures to be made conformable thereto. But though this hath so often by authority of Parliament been enacted, yet it could never be effected, so forcible is custom with the multitude. The regulation of weights and measures having so frequently formed the subject of parliamentary enactment can no longer be referred to the prerogative. Upwards of 20 statutes, extending from the 14 of Edward Roman 3 were repealed by the Statute 5 Geo. Roman 4. c. 74, by which and the Statute 6 Geo. Roman 4. c. 12, 4 and 5 Will. Roman 4. c. 49 and 5 and 6 Will. Roman 4. c. 63, amended by 22 and 23 Vict. c. 56, the imperial standard yard, pound, gallon, and bushel, were fixed and rendered uniform throughout the United Kingdom. All contracts for sale by weight or measure, except when an express agreement is made to the contrary, being considered to refer to these standards. By the last-mentioned act all local and customary measures and also heaped measures are abolished, and contracts made with reference to them are declared void. But the standard yard and pound authorized by these statutes having been destroyed in the fire at the Houses of Parliament in 1834, it became necessary to construct new standards, which having been legalized, now, by the Statute 18 and 19 Vict. c. 72, constitute the standard measure and weight of the United Kingdom. All these standards, which were previously kept in the Office of the Exchequer, have now been transferred under the Act 29 and 30 Vict. c. 82, to the Board of Trade, whose duties in making periodical comparisons of the standards are defined by the statute. Thirdly, as money is the medium of commerce, it is the Royal Hove. Math. Paris. Asterisk Cowles Inticup. Tit. PMDM Regis. Hoved. AI. 1201. Flet. 2. 12. Y hen. In. C. 25. Asterisk as to slasha, CO 22 and 23 Vict. C. 66. Royal Prerogative. Prerogative as the arbiter of domestic commerce to give it authority or make it current. Money is a universal medium, or common standard, by comparison with which the value of all merchandise may be ascertained. Or it is a sign which represents the respective values of all commodities. Metals are well calculated for this sign, because they are durable, and are capable of many subdivisions, and a precious metal is still better calculated for this purpose, because it is the most portable. A metal is also the most proper for a common measure, because it can easily be reduced to the same standard in all nations. And every particular nation fixes on it its own impression, that the weight and standard wherein consists the intrinsic value, may both be known by inspection only. As the quantity of precious metals increases, that is, the more of them there is extracted from the mine, this universal medium or common sign will sink in value and grow less precious. The consequence is that more money must be given now for the same commodity than was given 100 years ago. And if any accident were to diminish the quantity of gold and silver, their value would proportionably rise. A horse that was formerly worth 10 pounds is now perhaps worth 50, and by any failure of current specie, the price may be reduced to what it was. Yet is the horse in reality neither dearer nor cheaper at one time than another. For, if the metal which constitutes the coin was formerly twice as scarce as at present, the commodity was then as dear at half the price as now it is at the whole. The coining of money is in all states the act of the sovereign power, for the reason just mentioned, that its value may be known on inspection. And with respect to coinage in general, there are three things to be considered therein: the materials, the impression, and the denomination. With regard to the materials, Sir Edward Coke lays it down registered that the money of England must either be of gold or silver. And none other was ever issued by the royal authority till 1672, when copper farthings and halfpence were coined by King Charles Roman II and ordered by proclamation to be current in all payments, under the value of sixpence, and not otherwise. But this copper coin is not upon the same footing with the other in many respects, particularly with regard to the offence of counterfeiting it. And as to the coin generally, it is enacted by the statute. 2 inst. Coin of the realm. 249 33 and 34 Vict. C. 10s. 4. That a tender of payment of money shall be a legal tender, of gold to any amount, of silver to an amount not exceeding 40 shillings, and of bronze to the amount of 1 shilling. Asterisk as to the impression, the stamping thereof is the unquestionable prerogative of the crown. For though divers bishops and monasteries had formerly the privilege of coining money, this was usually done by special grant from the crown, or by prescription which supposes one, and therefore was derived from, and not in derogation of, the royal prerogative. Besides that they had only the profit of the coinage, and not the power of instituting either the impression or denomination, but had usually the stamp sent them from the exchequer. The denomination, or value for which the coin is to pass current, is likewise said to be in the breast of the sovereign, and if any unusual pieces are coined, that value must be ascertained by proclamation. In order to fix the value, the weight, and the fineness of the metal are to be taken into consideration together. When a given weight of gold or silver is of a given fineness, it is then of the true standard asterisk and called esterling or sterling metal, a name for which there are various reasons given, but none of them entirely satisfactory. And of the sterling or esterling metal all the coin of the kingdom must be made by the statute 25 Edwa. Roman 3. c. 13. So that the royal prerogative seemed not to extend to the debasing or enhancing the value of the coin below or above the sterling value. The sovereign may also, by his proclamation, legitimate foreign coin, and make it current here, declaring at what value it shall be taken in payments. But this, I apprehend, ought to be by comparison with the standard of our own coin, otherwise the consent of Parliament will be necessary. The sovereign may also, it is said, at any time decry, or cry down, any coin of the kingdom, and make it no longer current, but considering the fi. By 3 and 4 will. Roman 4. c. 98. Illegal to be that adopted by those two editender may be made in Bank of England Mologis, that the name wa derived notes, for sums above £5. From tili esterlingi, or esterlings, as this standard has frequently varied. Those Saxons were anciently called husi kolox kol, diet, coins, as inhabited that district of Germany now to the standard, and the trial of the occupied by the Hunstowns and their picks, see the Coinage Act, 1870. Appendages, the earliest traders EU. Spelm. Bloss. 203, Dufresne, Roman 3. Modem Europe. See Camden Scott 165. The most plausible opinion seems Land, p. 11, Sir John Davis's. The royal prerogative. Frequent interference of Parliament with reference to it, the regulation of the coinage cannot now, I apprehend, be referred simply to the prerogative. 6. The sovereign, as parens patrum, is the general conservator of his people. 1. He is the guardian of all the infants in his kingdom, the duties of which office devolved, as we shall see in the 3rd volume of these Commentaries, upon the keeper of his conscience, the Lord Chancellor, and were exercised by him and his colleagues, the Master of the Rolls and the Vice-Chancellors in the High Court of Chancery, until its whole jurisdiction, powers and authorities were transferred to the High Court of Justice. 2. The sovereign has also the custody of idiots and lunatics. An idiot, or natural fool, is one that has had no understanding from his nativity, and therefore is by law presumed never likely to attain any. For which reason the custody of him and of his lands was formerly vested in the lord of the fee, but, by reason of the manifold abuses of this power by subjects, it was at last provided by common consent, that it should be given to the sovereign, as the general conservator of his people, in order to prevent the idiot from wasting his estate, and reducing himself and his heirs to poverty and distress. This prerogative of the Crown is declared in Parliament by Statute 17 Edwa. Roman 2. cc. 11 and 12, which direct, in affirmance of the common law, that the king shall have ward of the lands of natural fools, taking the profits without waste or destruction, and shall find them necessaries, and after the death of such idiots he shall render the estate to the heirs. In order to prevent such idiots from alienating their lands, and their heirs from being disinherited. By the old common law there is a writ de idiot inquirendo, to inquire whether a man be an idiot or not, which was tried by a jury of 12 men. And if they found him puris idiota, the profits of his lands and the custody of his person might be granted by the Crown to some subject who had interest enough to obtain them. This was long considered a hardship upon. Sir William Blackstone treats this Edwa. I. Prefixed to Maynard's Yearbook branch of the prerogative as a part of the of Edwa. Roman 2. Fall. 20:24. Eil Kevenu, having been originally this power, is still alluded to in a source of profit. Common say by that usual expression J4 Rep. 126, Memoran. Skak 20 oi begging VT, va.n eoaa, eo /. Custody of lunatics. 251 private families, and so long ago as in the 8 Jack, it was under the consideration of Parliament to vest this custody in the relations of the party, and to settle an equivalent on the Crow Avon in lieu of it, it being then proposed to share the same fate with the slavery of the feudal tenures, which were not long afterwards abolished. Yet few instances can be given of the oppressive exertion of it, since it seldom happened that a jury found a man an idiot a nativitate, but only non-compos mentis from some particular time, which had an operation very different in point of law. A lunatic or non-compos mentis is one who has had understanding, but by disease, grief, or other accident has lost the use of his reason. A lunatic is indeed properly one that has had lucid intervals, sometimes enjoying his senses and sometimes not, and that frequently depending, as many have imagined, upon the changes of the moon. But under the general name of non-compos mentis are comprised not only lunatics, but persons under frenzies, or who lose their intellects by disease, or such, in short, as are judged by the courts incapable of conducting their own affairs. To these also, as well as idiots, the sovereign is guardian, but to a very different purpose. For the law always imagines that these accidental misfortunes may be removed, and therefore only constitutes the crown a trustee for the unfortunate persons to protect their property, and to account to them for all profits received, if they recover, or after their decease to their representatives. And therefore it is declared by the statute before referred to, that the king shall provide for the custody and sustentation of lunatics, and preserve their lands and the profits of them for their use, when they come to their right mind, and the king shall take nothing to his o/v in use, and if the parties die in such a state, the residue shall be distributed for their souls by the advice of the ordinary, and of course, by the subsequent amendments of the law of administration, shall now go to their executors or administrators. On the first attack of lunacy or other occasional insanity, while there may be hopes of a speedy restitution of reason, it is usual to confine the unhappy objects in private custody under the direction of their nearest friends and relations, and the legislature, to prevent all abuses incident to such private custody, has thought proper to interpose its authority from time to time. 252. The EAL prerogative. Far. Licensing, regulating, and visiting private asylums, as well as those for the care and maintenance of pauper lunatics in county asylums, and of criminal lunatics. But where the insanity is of a permanent character, and it becomes necessary, in reference to the property of the lunatic and its care and management, to have the fact of lunacy legally determined by law, the judges to whom, by special authority from the sovereign, the custody of lunatics and idiots is entrusted, upon petition or information, will grant a commission, special or general, in nature of the writ de idiot, or do lunatico, e quirendo, directed to the masters in lunacy, to inquire into the party's state of mind, and if he be found non-compos, will commit the care of his person, with a suitable allowance for his maintenance, to some friend, who is then called his committee. However, to prevent sinister practices, the next heir is seldom permitted to be this committee of the person, because it is his interest that the party should die. But it has been said, there lies not the same objection against his next of kin, provided he be not his heir, for it is his interest to preserve the lunatic's life, in order to increase the personal estate by savings, which he or his family may hereafter be entitled to enjoy. The heir is generally made the manager or committee of the estate, it being clearly his interest by good management to keep it in condition, accountable however to the judges and to the non-compos himself, if he recovers, or otherwise to his administrators. In this care of idiots and lunatics the civil law agrees with ours, by assigning them tutors to protect their persons and curators to manage their estates. But in another instance the Yeoman law goes much beyond the English. For, if a man by notorious prodigality was in danger of wasting his estate, he was looked upon as non-compos, and committed to the care of curators or tutors by the praetor, and by the laws of Solon such prodigals were branded with perpetual infamy. But with us, when a man on an inquest of idiocy has been returned an unthrift and not an idiot, no farther proceedings have been had, and the propriety of the practice itself seems to be very questionable. 8 and 9 Vict. C. 100. 86, 32 and 3.3 Vkt. C. 91. 16 and 17 Vict. C. 97. FF. 27, 10, 6, 16. 23 and 24 Vict. C. 75. Potter Audic. B. 1 C. 26. 16 and 17 Vic. C. 70, 25 and 26 Vict. of lunatics. 253. It was doubtless an excellent method of benefiting the individual and of preserving estates and families, but it hardly seems calculated for the genius of a free nation, who claim and exercise the liberty of using their own property as they please. CO. Utertuo ut alienum non lastas is the only restriction our laws have given with regard to economical prudence, and the frequent circulation and transfer of lands and other property, which cannot be effected without extravagance somewhere, are perhaps not a little conducive towards keeping our mixed constitution in its due health and vigor. Free. In this same capacity as parens patrii, the sovereign is guardian of the public health, appointing the president of the local government board, to which is committed the general superintendence of all the local authorities throughout the country, who are charged with carrying into effect the provisions of the Public Health Act 1875. To this branch of the prerogative may be assigned the authority conferred on the Crown in Council by the Statute 38 Vict. c. 47, to regulate the construction and fittings of gunpowder stores, to prescribe the buildings and works from which they are to be separated, and the maximum amount of gunpowder to be kept therein. The same statute prohibits the manufacture or storing of gunpowder except at factories and magazines licensed by the local authorities, and lays down general rules for all such factories and magazines, and for proper storage of gunpowder by persons who retail it, for its sale in closed packages, and its carriage from place to place. It applies to every description of explosive, such as nitroglycerine, gun-cotton, blasting powder, fog signals, fireworks, and every description of ammunition, authorizes the appointment of inspectors by the Board of Trade, and formal investigations into accidents, permits the seizure and detention of explosives liable to forfeiture until inquiry, and imposes penalties on infringements of the Act, which are to be summarily recoverable before justices. 7. The sovereign is, lastly, considered by the laws of England as the head and supreme governor of the national church. To enter into the reasons upon which this prerogative is founded is matter rather of divinity than of law. I shall there. The Local Government Board Act, 1871. 254. The royal prerogative. 4. Only observe that by Statute 26 Henry Roman 8. c. 1. Recidingeth that the King's Majesty justly and rightfully is and ought to be the supreme head of the Church of England, and so had been recognized by the clergy of this kingdom in their convocation, it is enacted, that the King shall be reputed the only supreme head of the Church of England, and shall have annexed to the imperial crown of this realm, as well the title and style thereof, as all jurisdictions, authorities, and commodities to the said dignity of supreme head of the Church appertaining. And another statute to the same purport was made 1 Eliz. c. 1. In virtue of this authority the King convenes, prorogues, restrains, regulates, and dissolves all ecclesiastical synods or convocations. This was an inherent prerogative of the Crown, long before the time of Henry Roman 8, as appears by the Statute 8 Henry vi. c. 1, and the many authors, both lawyers and historians, vouched by Sir Edward Coke. So that the Statute 25 Hen. Roman 8. c. 19, which restrains the convocation from making or putting in execution any canons repugnant to the royal prerogative, or the laws, customs, and statutes of the realm, was merely declaratory of the old common law, that part of it only being new, which makes the royal assent actually necessary to the validity of every canon. The convocation, or ecclesiastical synod in England, differs considerably in its constitution from the synods of other Christian kingdoms, these consisting wholly of bishops, whereas with us the convocation is the miniature of a parliament, wherein the archbishop resides with regal state. The upper house of bishops represent the House of Lords, and the lower house, composed of representatives of the several dioceses at large, and of each particular chapter therein, resembles the House of Commons with its knights of the shire and burgesses. This constitution is said to be owing to the policy of Edward I. Colin, who thereby one and the same time let in the inferior clergy to the privileges of framing ecclesiastical canons, which before they had not, and also introduced a method of taxing ecclesiastical benefices by consent of convocation. From this prerogative, of being head of the Church, arises the sovereign's right of nomination to vacant bishoprics, and certain other ecclesiastical preferments, which will more properly be forinst. 322, 323. Gilb, Hist of Exch. c. 4. Halems. 12 Rep. 72. Const. His. V. Roman 3. Cly. Supreme Head of the Church. 255 Considered when we come to treat of the clergy. I shall only here observe that this is now done in consequence of the statute 25 Hen. EI. C. 20. In the sovereign and council is also vested the power of giving effect to any scheme or recommendation of the ecclesiastical commissioners. The order in council, for this purpose, when entered in the registry of the diocese, having, after publication in the Gazette, the effect of an act of Parliament. As the head of the Church, the sovereign is likewise the dernier resort in all ecclesiastical causes, an appeal lying ultimately to the crown and council. From the sentence of every ecclesiastical judge, which right was vested in the Crow/VN by statute 25 Hen. Roman 8. c. 19, as will more fully be shown hereafter. In 1835 2 commissions were issued, directing the persons named therein to consider the state of the dioceses of England and Wales with reference to the amount of their revenues and the distribution of episcopal duties, and also to consider the state of our cathedral and collegiate churches, with a view to the suggestion of such measures as might conduce to the efficacy of the Church, and further to devise the best mode of providing for the cure of souls with special reference to the residence of the clergy. These commissioners made 4 Reg KJRTS, and they also recommended Liat commissioners should be appointed by Parliament for the purpose of preparing and laying before the sovereign and council such schemes as should appear to them to be best adapted for carrying their recommendations into effect, and that the Crown should be empowered to make orders ratifying such schemes and having the full force of law. The Stat. 6 and 7 will. Roman 4. c. 77 was accordingly passed, appointing ecclesiastical commissioners, making them a body corporate, and giving them the powers mentioned in the Act. The recommendations contained in the 4 regulates of the original commissioners have since been carried out, with certain modifications and amendments, to which Leo sanction of Parliament was required and obtained. The chief features of the alterations thus effected are the equalization of the territorial extent of the dioceses, the creation of the new sees of Ripon and Manchester, and the union of the sees of Gloucester and Bristol. Leo revenues of the sees have been also equalized by augmenting the income of TO smaller out of the revenues of the larger. Cathedral and collegiate bodies have also been regulated. The powers of the ecclesiastical commissioners have been extended by several statutes and by the transfer to them of powers of the church-building commissioners. The constitution of the body may also considered improved by the appointment of church estates commissioners who are ex officio members of the ecclesiastical commission. The jurisdiction may by order in council be transferred to the High Court of Appeal. The Judicature Act 1873. 256. Chapter Roman 8. Of the Audiobook Revenue. Having, in the preceding chapter, considered at large those branches of the sovereign's prerogative which contribute to his royal dignity and constitute the executive power of the government, we proceed now to examine his fiscal prerogatives, or such as regard his revenue, which the British Constitution has vested in the royal person, in order to support his dignity and maintain his power, being a portion which each subject contributes of his property in order to secure the remainder. This revenue is either ordinary or extraordinary. The ordinary revenue is such as has either subsisted time out of mind in the Crown, or else has been granted by Parliament, by way of purchase or exchange for such of the sovereign's inherent hereditary revenues as were found inconvenient to the subject. When I say that it has existed time out of mind in the Crown, I do not mean that the sovereign is at present in the actual possession of the whole of this revenue. Much, nay the greatest part, of it is at this day in the hands of subjects, to whom it has been granted out from time to time by the kings of England, which has rendered the Crown in some measure dependent on the people for its ordinary support and subsistence. So that I must be obliged to recount, as part of the royal revenue, what lords of manors and other subjects frequently look upon to be their own absolute inherent rights, because they are and have been vested in them and their ancestors for ages, though in reality originally derived from the grants of our ancient princes. The first of the ordinary revenues of the Crown, which I shall take notice of, is of an ecclesiastical kind, as are also the 3 succeeding ones, this the custody of the temporalities. First fruits and tenths. 257 bishops, by which are meant all the lay revenues, lands, and tenements, in which is included his barony, which belong to an archbishop's or bishop's see. And these, upon the vacancy of the bishopric, are immediately the right of the sovereign, as a consequence of his prerogative in church matters, whereby he is considered as the founder of all archbishoprics and bishoprics to whom during the vacancy they revert. And for the same reason, before the dissolution of abbeys, the king had the custody of the temporalities of all such abbeys and priories as were of royal foundation, but not of those founded by subjects on the death of the abbot or prior. Another reason may also be given why the policy of the law has vested this custody in the crown, because as the successor is not known, the lands and possessions of the see would be liable to spoil and devastation, if no one had a property therein. Therefore the law has given the sovereign, not the temporalities themselves, but the custody of the temporalities till such time as a successor is appointed, with power of taking to himself all the intermediate profits, without any account to the successor, and with the right of presenting, which the crown very frequently exercises to such benefices and other preferments as fall within the time of vacation. This revenue is of so high a nature, that it could not be granted out to a subject before, or even after it accrued, until, by the statute 1 Edwa. Roman 3. Sin. 4c. 4 and b. The sovereign was enabled, after the vacancy, to lease the temporalities to the dean and chapter, saving to himself all advocens, escheats, and the like. Our ancient kings, and particularly William Rufus, were not only remarkable for keeping the bishoprics a long time vacant, for the sake of enjoying the temporalities, but also committed horrible waste on the woods and other parts of the estate, and, to crown all, would never, when the see was filled up, restore to the bishop his temporalities again, unless he purchased them at an exorbitant price. To remedy which, King Henry I granted a charter at the beginning of his reign, promising neither to sell, nor let to farm, nor take anything from the domains of the church till the successor was installed. And it was made one of the articles of the Great Charter, that no waste should be committed in the temporalities of bishoprics, neither should the custody of them be sold. The same is ordained by the Statute of Westminster I, and the Statute of 14 Edwa. Roman 3. Sen. 4c. 4 Stat. 17 Edwa. Roman 2. Sent. IC. 14. F. N. B. 32. Ray yield by 2G. And 27 Vict. C. 125. Why all? I. The royal revenue, which permitted, as we have seen, a lease to the dean and chapter, was still more explicit in prohibiting the other exactions. It was also a frequent abuse that the sovereign would, for trifling or no causes, seize the temporalities of bishops, even during their lives, into his own hands. But this also was guarded against by Statute 1 Edwa. Roman 3. Sin. 2c. 2. This revenue, which was formerly very considerable, is now, by a customary indulgence, almost reduced to nothing, for at present, as soon as the new bishop is consecrated and confirmed, he usually receives the restitution of his temporalities quite entire and untouched from the crown, and at the same time does homage to his sovereign, and then, and not sooner, he has a fee simple in his bishopric, and may maintain an action for the profits. Roman 2. The sovereign is entitled to a corrody, as the law calls it, out of every bishopric, that is to send one of his chaplains to be maintained by the bishop, or to have a pension allowed him till the bishop promotes him to a benefice. This is also in the nature of an acknowledgment to the king, as founder of the see, since he had formerly the same corrody or pension from every abbey or priory of royal foundation. It is, I apprehend, now fallen into total disuse, though Sir Matthew H. Ale says that it is due of common right, and that no prescription will discharge it. Roman 3. The sovereign also, as was formerly observed, is entitled to all the tithes, or the rent charge now substituted in lieu thereof, arising in extra-parochial places. Though perhaps it may be doubted how far this article, as well as the last, can be properly reckoned a part of the royal revenue, since a corrody supports only his chaplains, and these extra-parochial tithes are held under an implied trust, that he will distribute them for the good of the clergy in general. Roman 4. The next branch consists in the first fruits and tenths of all spiritual preferments in the kingdom, both of which I shall consider together. These were originally a part of the papal usurpations over the clergy of this kingdom, first introduced by Pandulf, the Pope's legate, during the reigns of King John and Henry III. First fruits and tenths. 259 in the See of Non-Vich, and afterwards attempted to be made universal by the Popes Clement V and John Roman 22 about the beginning of the 14th century. The first fruits, primatas or annats, were the first year's whole profits of the spiritual preferment, according to a rate or valor made under the direction of Pope Innocent Roman IV. By Walter, Bishop of Normch, in 38 Hen. Roman III, and afterwards advanced in value by commission from Pope Nicholas. Roman IV. A.D. 1292, 20 Edwa. I. Which valuation of Pope Nicholas is still preserved in the Exchequer. The tenths, or decimi, were the 10th part of the annual profit of each living by the same valuation, which was also claimed by the Holy See, under no better pretense than a strange misapplication of that precept of the Levitical law, which directs that the Levites should offer the 10th part of their tithes as a heave offering to the Lord, and give it to Aaron the high priest. But this claim of the Pope met with a vigorous resistance from the English Parliament, and a variety of acts were passed to prevent and restrain it, particularly the now repealed Statute 6 Hen. Roman 4. C. 1, which calls it a horrible mischief and damnable custom. But the clergy, blindly devoted to the will of a foreign master, still kept it on foot, sometimes more secretly, sometimes more openly and avowedly. So that in the reign of Henry Roman 8 it was computed that in the compass of 50 years 800,000 ducats had been sent to Rome for first fruits only, and, as the clergy expressed this willingness to contribute so much of their income to the head of the Church, it was thought proper, when in the same reign the papal power was abolished, and the king was declared the head of the Church of England, to annex this 3 inst. 154. This valuation forms it extended over the province of Canterone of the works published by the Barry, finished in 1291, and as to York also record commissioners. Mr. Justice in the following year, the whole LX in Coleridge has stated the historical under the direction of John Bishop of Origin of this branch of the Royal Revenue Winton, and Oliver Bishop of Lincoln, more exactly Colin in 1253, Pope Innocent in 1318, a third taxation, entitled Javur Roman 4. Granted all the first fruits and tenths taxatio was made, but this only extolled Henry Roman 3. For 3 years, which tended over some part of the province of occasioned a taxation in the following York, it became necessary chiefly in year, sometimes called the Norwich consequence of the Ciatislige invasion of taxation, and sometimes innocence the border counties, which rendered the valuation. In 1288, Nicholas Roman 4. Clergy of those districts unable to pay grantail the tenths to Edward I. For tenths and first fruits according to T.L.I. 6 years, and a new valuation was called higher valuation, and was made by Menst in the same year by the king's virtue of royal munjute directed to the precept, which valuation was, so far as Bishop of Carlisle. Coleridge's Byext. The Revenue to the Crown, which was done by Statute 26 Hen. Roman A. C. 3, confirmed by Statute 1 Eliz. C. 4, and a new Velar Bene Gesserim was then made, that commonly called the King's Booze, by which the clergy are at present rated. By these last mentioned statutes all vicarages under £10 a year, and all rectories under 10 marks, are discharged from the payment of first fruits, and if, in such livings as continue chargeable with this payment, the incumbent lives but half a year, he shall pay only 1/4 of his first fruits, if but 1 whole year, then half of them, if a year and a half, 3/4, and if 2 years, then the whole, and not otherwise. Likewise by the Statute 27 Hen. Roman A. C. 8, no tenths are to be paid for the first year, for then the first fruits are due. And by other statutes of Queen Anne, in the 5th and 6th years of her reign, if a benefice be under £50 per annum clear yearly value, it shall be discharged from the payment of first fruits and tenths. Thus the richer clergy, being, by the criminal bigotry of their predecessors, subjected at first to a foreign exaction, were afterwards, when that yoke was shaken off, liable to a like misapplication of their revenues, through the rapacious disposition of the then reigning monarch. Till at length the piety of Queen Anne restored to the Church what had been thus indirectly taken from it. This she did, not by remitting the tenths and first fruits entirely, but in a spirit of the truest equity, by applying these superfluities of the larger benefices to make up the deficiencies of the smaller. And to this end she granted her royal charter, which was confirmed by the statute to Anne. c. 11, whereby all the revenue of first fruits and tenths is vested in trustees for ever, to form a perpetual fund for the augmentation of poor livings. This is usually called Queen Anne's bounty, which has been still farther regulated by subsequent statutes. Registered v. The next branch of the ordinary revenue of the sovereign, *a transcript is given in Acton's Queen Anne's bounty, are consolidated Thesaurus and Bacon's Liber Regis, and regulated by the statute 1 and 2. See the reports of the Commissioners Vict. c. 20, and many statutes have appointed to inquire into the eccles since been passed in order if possible sias to seal revenues, 1831, as to the present to place the administration of this fund value of the church property on a proper footing. The offices of fur, gt fruits, tenths, and profits op military tenures. 261 which, as well as the subsequent branches, is of a lay or temporal nature, consists in the rents and profits of the demesne lands of the crown. These demesne lands, iri dominicales regis, being either the share reserved to the crown at the original distribution of landed property, or such as came to it afterwards by forfeitures or other means, were anciently very large and extensive, comprising divers manors, honors, and lordships, the tenants of which had very peculiar privileges, as will be shown in the second book of these Commentaries, when we speak of the tenure in ancient demesne. At present they are contracted within a very narrow compass, having been almost entirely granted away to private subjects. This has occasioned the Parliament frequently to interpose, and particularly after King William Roman III had greatly impoverished the Crow VN, an act passed * whereby all future grants or leases from the Crown for any longer term than 31 years or 3 lives are declared to be void, except with regard to houses which may be granted for 50 years. N. No reversionary lease can be made, so as to exceed together with the estate in being, the same term of 3 lives or 31 years. That is, where there is a subsisting lease, of which there are 20 years still to come, the Crown cannot grant a future interest, to commence after the expiration of the former, for any longer term than 11 years. The tenant must also be made liable to be punished for committing waste, and the U-section Yule rent must be reserved, or, where there has usually been no rent, 1/3 of the clear yearly value. The misfortune is, that this act was made too late, after almost every valuable possession of the Croven had been granted away. The management of this royal property is now, by the statute 14 and 15 Vict. c. 42, vested in certain commissioners styled Commissioners of Her Majesty's Woods, Forests, and Land Revenues, but that part of the demesnes of the Crown, which consists of parks and places to which the public has access, is managed by the Commissioners of Her Majesty's Works and Public Buildings. Vi. Hither might have been referred the advantages which used to arise to the sovereign from the profits of his military. 1n. Sin. 1 c. 7. See now 1 and 2 * c 14 and 15 Vict. cc. 42 and 46, and Vict. c. 95, 25 and 26 Vict. c. 37. 35 and 36 Vict. c. 15. C 15 and 16 Vict. c. 62, 16 and 17. The /work or / are vested in the board Vict. c. 76, and 29 and 30 Vict. 62. Of trade by 29 and 30 Vict. c. 262 The royal tenures. Tenures to which most lands in the kingdom were subject, till the statute 12 Car. Roman 2. c. 24, which in great measure abolished them all. Hither also might have been referred the profitable prerogative of purveyance and preemption, which was a right enjoyed by the crown of buying up provisions and other necessaries, by the intervention of the royal purveyors, for the use of the royal household, at an appraised valuation in preference to all others, and even without consent of the owner, and also of forcibly impressing the carriages and horses of the subject to do the sovereign's business on the public roads in the conveyance of timber, baggage, and the like, however inconvenient to the proprietor, upon paying him a settled price. A prerogative which prevailed pretty generally throughout Europe during the scarcity of gold and silver and the high valuation of money consequential thereupon. In those early times the king's household, as well as those of inferior lords, were supported by specific renders of corn and other victuals from the tenants of the respective demesnes. And there was also a continual market kept at the palace gate to furnish viands for the royal use. And this answered all purposes in those ages of simplicity, so long as the king's court continued in any certain place. But when it removed from one part of the kingdom to another, as was formerly very frequently done, it was found necessary to send purveyors beforehand to get together a sufficient quantity of provisions and other necessaries for the household, and, lest the unusual demand should raise them to an exorbitant price, the powers before mentioned were vested in these purveyors, who, in process of time, very greatly abused their authority, and became a great oppression to the subject, though of little advantage to the crown, ready money in open market, when the royal residence was more permanent and specie began to be plenty, being found upon experience to be the best prudenter of any. Having fallen into disuse during the suspension of monarchy, King Charles at his restoration consented, by the same statute, 12 Car. Roman 2. c. 24 to resign entirely these branches of his revenue and power, and the Parliament, in part of recompense, settled on him, his heirs and successors for ever, an excise on all beer and ale sold in the kingdom, and a proportionable sum for certain other liquors. So that this hereditary excise, the nature of which shall be farther explained in the subsequent part of this chapter, now forms the sixth branch of the sovereign's ordinary revenue. NP Omtior Sen Courts of Justice 263 Roman 7. A seventh branch might also be computed to have arisen from toin licenses, or the rents payable to the crown by such persons as are licensed to sell wine by retail throughout England, except in a few privileged places. These were first settled on the crown by the statute 12 Car. Roman 2. c. 25, and, together with the hereditary excise, made up the equivalent in value for the loss sustained by the prerogative in the abolition of the military tenures, and the right of preemption, and purveyance, but this revenue was abolished by the statute 30 Geo. Roman 2. c. 19, and an annual sum of upwards of 7,000 per annum, issuing out of the stamp duties imposed on wine licenses, was settled on the crown in its stead. Similar licenses have, however, been recently revived as a source of revenue by the statute 23 Vict. c. 27. Roman 8. An eighth branch of the ordinary revenue of the sovereign is usually reckoned to consist in the profits arising from his forests. Forests are waste grounds belonging to the crown, replenished with all manner of beasts of chase or venery, which are under the royal protection, for the sucking of his royal recreation and delight. And to that end, and for preservation of the game, there are particular laws, privileges, courts, and offices belonging to the forests, all which will be, in their turns, explained in the subsequent books of these commentaries. What we are now to consider are only the profits arising to the crown from hence, which consist principally in amercements or fines levied for offences against the forest laws. But as few, if any, courts of this kind for levying amercements have been held since 1632, and as, from the accounts given of the proceedings in that court by our histories and law books, nobody would now wish to see them again revived, it is needless, at least in this place, to pursue this inquiry any farther. Roman 9. The profits arising from the sovereign's ordinary courts of justice make a ninth branch of his revenue. And these consist not only in fines imposed upon offenders, forfeitures of recognizances, and amercements levied upon defaulters, but also in certain fees due to the crown in a variety of legal matters, as for setting the Great Seal to charters, original writs, and other Roger Nortley in his Life of Lord after the Restoration, but I have met Keeper North, Mencius and Eyre, or Eider, with no report of its proceedings to have been held south of Trent soon. The royal revenue. Forensic proceedings and formerly. For permitting fines to be levied of land in order to bar entails, or otherwise to ensure their title. As none of these can be done without the immediate intervention of the sovereign, by himself or his officers, the law allows him certain perquisites and profits as a recompense for the trouble he undertakes for the public. These, in process of time, were almost all granted out to private persons, or else appropriated to certain particular uses, so that very little of them was ever returned into the exchequer. All grants of them were, by the statute 1 Ann. Sen. 2 C. 7 to endure for no longer time than the prince's life who granted them, and as the custom of making such grants has long been in desuetude, there are few if any now outstanding. The officers of the public courts of justice are now almost universally paid by salary out of the consolidated fund, and the fees on proceedings in the courts levied by means of stamps. X. A 10th branch of the royal revenue, the right to mines, has its origin from the sovereign's prerogative of coinage in order to supply him with materials, and therefore those mines, which are properly royal, and to which the crown is entitled when found, are only those of silver and gold. By the old common law, if gold or silver be found in mines of base metal, according to the opinion of some, the whole was a royal mine, and belonged to the crown, though others held that it only did so if the quantity of gold or silver was of greater value than the quantity of base metal. But now by the statutes 1 W. and M. Sen. 1 C. 35 W. and M. C. 6 and 55 Go. Roman 3. C. 134. This difference is made immaterial, it being enacted, that no mines of copper, tin, iron, or lead, shall be looked upon as royal mines, notwithstanding gold or silver may be extracted from them in any quantities, but that the king, or persons claiming royal mines under his authority, may have the ore other than tin ore in the counties of Devon and Cornwall, paying for the same a price stated in the Act. This was an extremely reasonable law, for now private owners are not discouraged from working mines, through a fear that they may be claimed as royal ones, neither does the sovereign depart from the just rights of his revenue, since he may have all the precious metals contained. T.Y. late Earl of Ellenborough had his office of Chief Clerk of the Court of 7,700 c. per annum, as compensation for Queen's Bench. Shipwrecks. 265 v. In the ore, paying no more for it than the value of the base metal which it is supposed to be, to which base metal the landowner is by reason and law entitled. Roman 11. A branch of the sovereign's ordinary revenue, said to be grounded on the consideration of his guarding and protecting the seas from pirates and robbers, is the right to royal fish, which are whale and sturgeon, and these, when either thrown ashore or caught near the coast, are the property of the crown, on account of their superior excellence. Indeed, our ancestors seem to have entertained a very high notion of the importance of this right, it being the prerogatives of the kings of Denmark and the dukes of Normandy. And from one of these it was probably derived to our princes. It is expressly claimed and allowed in the statute de Fr. Saragiver Regis, and the most ancient treatises of law now extant make mention of it degrees, though they seem to have made a distinction between whale and sturgeon, as was incidentally observed in a former chapter. Roman 12. Another maritime revenue, and founded partly upon the same reason, is that of shipwrecks, which are also declared to be the sovereign's property by the same statute, and were so long before at the common law. It is worthy observation how greatly the laws of wrecks has been altered, and the rigor of it gradually softened in favor of the distressed proprietors. Wreck, by the ancient common law, was where any ship was lost at sea, and the goods or cargo were thrown upon the land, in which case these goods, so wrecked, were judged to belong to the king, for it was held that, by the loss of the ship, all property was gone out of the original owner. But this was undoubtedly adding sorrow to sorrow, and was consonant neither to reason nor humanity. Wherefore it was first ordained by King Henry I, that if any person escaped alive out of the ship it should be no wreck, degrees, and afterwards King Henry Roman II by his charter declared, that if on the coasts of either England, Poitou, Oleron, or Gascony, any ship should be distressed, and Stern, de jure sulanum, 1, 2 c. 8 h. 24 eva. I. 37 prefixed to Maynard's gr. Custom. Cap. 17. Edition of Tila Yearbook of Edwa. Roman 2. 17 Edwa. Roman 2. C. 13. P. Pelm. Cod. Uped Wilkins, 305. Degrees by Acton 1. Free C. 3. Britter I. C. 17. 26 May, AU. 1174. 1 Beimers Flya 1. 1 C. 45, 46. Memorand. Scat. Fodera, 36. J. 266 The Eel Revenue. / either man or beast should escape or be fruitful either in alive. The goods should remain to the owners if they claimed them within 3 months, but otherwise should be esteemed a wreck, and should belong to the king, or other lord of the franchise. This was again confirmed with improvements by King Eikard I, who, in the 2nd year of his reign *, not only established these concessions by ordaining that the owner, if he was shipwrecked and escaped, omni res suas ligeras et queras hd bearet, but also that, if he perished, his children, or in default of them his brethren and sisters should retain the property, and, in default of brother and sister, then the good should remain to the king, and the law, as laid down by Bracton in the reign of Henry Roman III, seems still to have improved in its equity. For then, if not only a dog, for instance, escaped, by which the owner might be discovered, but if any certain mark were set on the goods, by which they might be known again, it was held to be no wreck. And this is certainly most agreeable to reason, the rational claim of the crown being only founded on this, that the true owner cannot be ascertained. Afterwards, in the Statute of Westminster the first *, the time of limitation of claims, given by the Charter of Henry Roman II, is extended to a year and a day, according to the usage of Normandy, and it enacts that if a man, a dog, or a cat escape alive, the vessel shall not be adjudged a wreck. These animals, as in Bracton, are only put for examples, for it is now held that not only if any live thing escape, but if proof can be made of the property of any of the goods or lading which come to shore, they shall not be forfeited as wreck. The statute further ordains that the sheriff of the county shall be bound to keep the goods a year and a day, as in France, for 1 year, agreeably to the maritime laws of Oleron, and in Holland for a year and a half, that if any man can prove a property in them, either in his own right or by right of representation, they shall be restored to him without delay, but if no such property be proved within that time, they then shall be the king's. If the goods are of a perishable nature, the sheriff may sell them 1 cog of in Rick. I. Brack. 1. 3c. 3. In like manner Constantine the Great, *3 Edwa. IC. 4. Repealed 26 and 27, finding that by the imperial law the vict. C. 125. Revenue of Rex was given to the gr. Custom. C. 17. Prince's Treasury or Fiscus restrained it by Hamilton v. Davis 5 Burt. 2732. An edict, and ordered them to remain to. Section 28. The owners. Ca. 1151. Shipwrecks. 267, and the money shall be liable in their stead. This revenue of wrecks is frequently granted out to lords of manors, as a royal franchise, and if any one be thus entitled to wrecks in his own land, and the goods of the crown are wrecked thereon, the sovereign may claim them at any time, even after the year and day. It is to be observed that, in order to constitute a legal ivric JC, the goods must come to land. If they continue at sea, the law distinguishes them by the barbarous and uncouth appellations of jetsam, flotsam, and ligan. Jetsam is where goods are cast into the sea, and there sink and remain under water. Flotsam is where they continue swimming on the surface of the waves. Ligan is where they are sunk in the sea, but tied to a cork or buoy, in order to be found again. These also belong to the crown, if no owner appears to seek them, but if any owner appears, he is entitled to recover the possession. For even if they be cast overboard, without any mark or buoy, in order to lighten the ship, the owner is not by this act of necessity construed to have renounced his property. Much less can things liegen be supposed to be abandoned, since the owner has done all in his power to assert and retain his property. These three are therefore counted so far a distinct thing from the former, that by the royal grant to a man of rex, things jetsam, flotsam, and liegen will not pass. Rex, in their legal acceptation, are at present not very frequent, for if any goods come to land, it rarely happens, since the improvement of commerce, navigation, and correspondence, that the owner is not able to assert his property within the year and day limited by law, and in order to preserve this property entire for him, and if possible to prevent wrecks at all, our laws have made many very humane regulations, in a spirit quite opposite to those savage laws which formerly prevailed in all the northern regions of Europe, permitting the inhabitants to seize on whatever they could get as lawful prize, or as an author of their own expresses it, in naufragorum miseria I calamitate. Tanquam vivi ures ad piartetem cur. For by the statute of 27 Edwa, Roman 3. c. 13, if any ship be lost on the shore, and the goods come to land, which cannot, says the statute, be called wreck, they shall be presently delivered to the merchants, paying only a reasonable reward to those that saved and preserved them. Asterisk coyestable case, 5 Bep. 106. Staken. Decidior suam. 1. The royal eve fu, which is entitled salvage. Also by them on law, if any persons, other than the sheriff, take any goods so cast on shore, which are not legal wreck, that owners might have a commission to inquire and find them out, and compel them to make restitution. And asterisk now by 17 and 18 Vict. c. 5. Analogous provisions having been made by 12 An. Sin. 2c. 18, asterisk and subsequent statutes, in order to assist the distressed and prevent the scandalous illegal practices on some of our seacoasts. Power is given to officers appointed by the Board of Trade termed receivers of rec JCS, to summon such number of men as they think necessary to assist them, and also to demand the use of wagons, carts, and horses with a view to the preservation of ships stranded or in distress, and their cargoes, and the lives of persons belonging to them, under a penalty, in persons refusing, of 100. And, in case of assistance given, salvage shall be paid by the owners to be assessed, asterisk in certain cases, by 2 neighboring justices, in some in the county court, and in others by the High Court of Justice. All persons that secrete any goods or cargo washed on shore, whether they be the owners or not, incur a penalty not exceeding 100. And whoever plunders or steals any part of a distressed or wrecked ship, or of its cargo, is liable to be kept in penal servitude for 14 years, or to be imprisoned as a felon. Asterisk lastly by the statute 24 and 25 Vict. c. 97 s. 47. Whoever exhibits any false light or signal with intent to bring any ship or vessel into danger, or maliciously does anything tending to the immediate loss or destruction of any vessel in distress, is also guilty of felony, and may be kept in penal servitude for life. Many other salutary regulations are made for the more effectually preserving ships of any nation in distress. Roman 13. To the same origin may in part be referred the revenue of treasure trove, derived from the French word trover, to find, called in Latin thesaurus inventus, which is where any money, or coin, gold, silver, plate, or bullion, is found hidden in the earth. F. N. B. 112 ff. 47 9 3. The laws also of the 24 and 25 Vict. c. 96 s. 64. Visigoths and the most early Neapolitan by the civil law, to destroy persons' constitutions, punished with the utmost shipwrecked, or prevent their saving the severity all those who neglected to assist ship, is capital. And to steal even any ship in distress, or plundered any plank from a vessel in distress, or goods cast on shore. Lindenbrog. Ka. Wrecked, makes the party liable to LL. Ante. 146, 715. Answer for the whole ship and cargo. Azure Trove. 269 or other private GX the owner thereof being unknown, in which case the tray S exclamation F belongs to the crown, but if he that hid it be known, or afterwards found out, the owner, and not the sovereign, is entitled to it. Also it be found in the sea, or upon the earth, it does not belong to the king, but the finder, if no owner appears, asterisk, so that it seems it is the hiding and not the abandoning of it, that gives the crown a property. Blackstone defining it, in the words of the civilians, to be veti vis depositio pecunii. This difference clearly arises from the different intentions which the law implies in the owner. A man that hides his treasure in a secret place evidently does not mean to relinquish his property, but reserves a right of claiming it again when he sees occasion. And if he dies, and the secret also dies with him, the law gives it to the sovereign and part of his royal revenue. But a man that scatters his treasure into the sea, or upon the public surface of the earth, is construed to have absolutely abandoned his property, and returned it into the common stock without any intention of reclaiming it, and therefore it belongs as in a state of nature to the first occupant or finder, unless the owner appear and assert his right, which then proves that the loss was by accident, and not with an intent to renounce his property. Formerly, all treasure trove belonged to the finder, as was also the rule of the civil law. Afterwards it was judged expedient for the purposes of the state, and particularly for the coinage, to allow part of what was so found to the crown, which part was assigned to be all hidden treasure, such as is casually lost and unclaimed, and also such as is designedly abandoned, still remaining the right of the fortunate finder. And that the prince shall be entitled to this hidden treasure is now grown to be, according to Grotius, jus commune et cuvisici gentium. For it is not only observed, he adds, in England, but in Germany, France, Spain, and Denmark. The finding of deposited treasure was much more frequent, and the treasures themselves more considerable, in the infancy of our constitution, than at present. Asterisk armory v. Delamery. A chimney had been in the socket, when the jewel sweeper's boy recovered the yallow of Teli was handed to the goldsmith for exam if finest diamond, W. Lee would fit the nation, and to ascertain what it was. Socket of a jewel which the boy had see one Smith's leading cases. Found in the street, from a goldsmith who asterisk de jure, be at p. 1, 2 c. 8 section 7, detained from him the diamond which 270 the royal revenue, f when the Iamens and other inhabii asterisk. My the respective countries which composed their empire, CPVB driven out by the northern nations, they concealed their money underground, with a view of resorting to it again when the heat of the eruption should be over, and the invaders driven back to their deserts. But as this never happened, the treasures were never claimed, and on the death of the owners the secret also died along with them. The conquering generals, being aware of the value of these hidden mines, made it highly penal to secrete them from the public service. In England, therefore, as among the feudists registered the punishment of such as concealed from the crown the finding of hidden treasure was formerly no less than death, but now it is only fine and imprisonment. Roman 14. Waifs, bona waviata, are goods stolen and waived or thrown away by the thief in his flight for fear of being apprehended. These are given to the crown by the law, as a punishment upon the owner for not himscape pursuing the felon, and taking away his goods from him. And therefore if the party robbed do his diligence immediately to follow and apprehend the thief, which is called making fresh suit, or do convict him afterwards, or procure evidence to convict him, he shall have his goods again, for waived goods do not belong to the sovereign till seized by somebody for his use, and if the party robbed can seize them first, though at the distance of 20 years, the crown shall never have them. If the goods are hid by the thief, or left anywhere by him, so that he had not them about with him when he fled, and therefore did not throw them away in his flight, these also are not bona waviata, but the owner may have them again when he pleases asterisk, and the goods of a foreign merchant, though stolen and thrown away in flight, shall never be waifs, the reason whereof may be, not only for the encouragement of trade, but also because there is no willful default in the foreign merchant's not pursuing the thief, he being generally a stranger to our laws, our usages, and our language. Roman 15. Estrays are such valuable animals as are found wandering in any manor or lordship, and no man knows the owner of them, in which case the law gives them to the sovereign as the glend. 1. 1 c. 2. Grawl. J. 16, 40. Asterisk constables Q and N. 5 EP. 109. E. Fitzley. Ab T. Estray. 1. 8 bolster. Est pays. 271 via our general owner, and LJTB amount of the soil, in recompense for the damage which Tiakai have done therein, and they now most commonly belong to the lord of the manor by special grant from the crown. But, in order to vest an absolute property in the sovereign, or his grantees, they must be proclaimed in the church and 2 market towns next adjoining to the place where they are found, and then, if no man claims them, after proclamation and a year and a day past, they belong to the sovereign or his substitute without redemption, even though the owner were a minor, or under any other legal incapacity. A provision similar to which obtained in the old Gothic constitution, with regard to all things that were found which were to be thrice proclaimed, primum quorum comitus et maturibus obiae stained in proximo, vi old vel pago posternua quorum ecclesiad vel judido. And the space of a year was allowed for the owner to reclaim his property. If the owner claims them within the year and day, he must pay the charges of finding, keeping, and proclaiming them. The crown or lord has no property till the year and day past. For if a lord keeps an estray 3/4 of a year, and within the year it strays again, and another lord gets it, the other lord cannot take it again. Any beasts may be estrays that are by nature tame or reclaimable, and in which there is a valuable property, as sheep, oxen, swine, and horses, which we in general call cattle, and so Fleta defines them, JAU 8 vagons, QTWD nullis pati, sequitur vel advocat. For animals upon which the law sets no value, as a dog or cat, and animals /eras neuri, as a bear or wolf, cannot be considered as estrays. So swans may be estrays, but not any other fowl, whence they are said to be royal fowl. The reason of which distinction seems to be, that cattle and swans being of a reclaimed nature, the owner's property in them is not lost merely by their temporary escape, and they also, from their intrinsic value, are a sufficient pledge for the expense of the lord of the franchise in keeping them the year and day. For he that takes an estray is bound, so long as he keeps it, to find it in provisions, and preserve it from damage, and may not use it by way of labor, but is liable to an action. Stiern, de jure Gotha. 1. Free C. 5. 2 WM. BL. 1117. Nicholson v. Pleitman. Dalt. SH. 79. A rule which does not to hen. BL. 254. Apply when any one takes care of. L. 1. C. 43. Annelier's property, not being entitled. Kav Storu 7 Rep. 17. J to it as an estray. Binsta T. Buck. The eel revenue? For so doing, yet he may milk a CR the like, for that tends to the preservation, and is for the .s fit of the animal. Besides the particular reasons before given why the king should have the several revenues of royal fish, shipwreck JCS, treasure trove, waifs, and estrays, there is also one general reason which holds for them all, and that is because they are hona vacantia, or goods in which no one else can claim a property. And therefore by the law of nature they belonged to the first occupant or finder, and so continued under the imperial law. But in settling the modern constitutions of most of the governments of Europe, it was thought proper to prevent that strife and contention, which the mere title of occupancy is apt to create and continue, and to provide for the support of public authority in a manner the least burdensome to individuals, that these rights should be annexed to the supreme power by the positive laws of the state. And so it came to pass that, as Bracton expresses it, et sequus annullius in bonus sunt, et olim furent inventoris de jure naturali, jam office enter prinipes de jure gentium da. L. 1c. 12. Trademark Sir William Blackstone mentions here, as another branch of the ordinary revenue of the crown, forfeitures of lands and goods for offences, bona confiscata, as they are called by the civilians, because they belonged to the fiscus or imperial treasury, or as our lawyers termed them, fors facta, that is, such whereof the property is gone away, or departed from the owner. But, as we shall see in the fourth part of these commentaries, when we come to treat of crimes and misdemeanors, there is no longer any forfeiture for offences. There was formerly, however, one species of forfeiture which arose from a misfortune rather than the crime of the owner, which calls for passing notice. This was a deodand, by which was meant whatever personal chattel was the immediate occasion of the death of any reasonable creature, which was forfeited to the crown, to be applied to pious uses and distributed via alms by his high almoner, though formerly destined to the purchase of masses. It seems to have been originally designed as an expiation for the souls of such as were snatched away by sudden death, and for that purpose ought properly to have been given to Holy Church. In the same manner as the apparel of a stranger who was found dead was applied to purchase masses for till good of his soul. And this may account for that rule of law, that no deodand was due where an infant under the age of discretion was killed by a fall from a cart, or horse, or the like, not being in motion, whereas, if an adult person fell from thence and was killed, the thing was certainly forfeited. The reason given by Sir Matthew Hale seems very inadequate, viz. Because an infant is not able to take care of himself, for why should the owner save his forfeiture on account of the imbecility of the child, which ought rather to have made him more cautious to prevent any accident of mischief? The true ground of this rule seems rather to have been that the child, by reason of its want of discretion, was presumed incapable of actual sin, and therefore needed no deodand to purchase propitiatory masses. W&T. Forfeitures. 273 Roman 16. The last BRG of the ordinary revenue of the crown arises from escheats, JFNDS, which happen upon the defect of heirs to succeed to the inheritance, whereupon they in general revert to invest in the sovereign, who is esteemed, in the eye of the law, the original proprietor of all the lands of the kingdom. But the discussion of this topic more properly belongs to the second book of these Commentaries, wherein we shall particularly consider the manner in which lands may be acquired or lost by escheat. This may suffice for a short view of the sovereign's ordinary revenue, or the proper patrimony of the crown, which was very but every adult, who died in actual sin, beatued in need of such atonement, according to the humane views of the founders of the English law. Thus stood the law if a person were killed by a fall from a thing standing still, but if a horse, or ox, or other animal of his own motion killed as well an infant as an adult, or if a cart ran over him, they were in either case forfeited as deodands, which was getwindad upon this additional reason, that such misfortunes were in part owing to the negligence of the owner, and therefore he was properly punished by such forfeiture. A like punishment is in like oases inflicted by the Mosaic law. If an ox gore a mow tilait he die, tilait ox shall be stoned, and his flesh shall not be eaten. And, among the Athenians, whatever was the cause of a man's death, by falling upon him, was exterminated or ousted out of the dominions of the republic. Thus, too, by our ancient law, a well in which a person was drowned was ordered to be filled up, under the inspection of the coroner, for a thing not in motion was the occasion of a man's death. That part only which was the immediate cause was forfeited, as if a man was climbing up the wheel of a cart and was killed by falling from it, the wheel alone was a deodan. But wherever the thing was in motion, not only that part which immediately gave the wound, as the wheel which ran over his body, but all things which moved vol. I whitly it and helped to make the wound more dangerous, as the cart and loading which increased the pressure of the wheel were forfeited. It mattered not whether the owner were concerned in the killing or not, for, if a man killed another with my sword, the sword was forfeited as an accursed thing, and therefore, in all indictments for homicide the instrument of death and the value were formally presented and found by the grand jury, us that the stroke was given by a certain penknife, value 6 immense, that the sovereign or his grantee miglet claimed the deodand, for it was no de ex land, unless it were presented as such by a jury of 12 men. No deodans were due for accidents happening upon the high seas, that being out of the jurisdiction of the common law, but if a man fell from a boat or ship in fresh water, and was drowned, it was said, tilait the vessel and cargoer, in strictness of law, a deotlan. But juries very frequently took upon themselves to mitigate those forfeitures, by finding only some trifling thing, or part of an entire thing, to have been the occasion of the death. And in such cases, although the finding of the jury was hardly warranted by law, the courts generally refused to interfere on behalf of the Lord of T franchise to assist so inequitable a claim. Juries and judges having thus alike condemned the practice as repugnant to the feelings of mankind, deodans were formally abolished by Tli Stat. 9 and 10 Vict. C. 62. Large formerly, and capable of being, if said to a magnitude, truly formidable. For there are very few lights in the kingdom that have not, at some period or other since the Norman conquest, been vested in the hands of the sovereign by forfeiture, escheat, or otherwise. But fortunately for the liberty of the subject, this hereditary landed revenue, by a series of improvident management, is sunk almost to nothing, and the casual profits, arising from the other branches of the census regales, are likewise almost all of them alienated from the crown, in order to supply the deficiencies of which, we are now obliged to have recourse to new methods of raising money, unknown to our early ancestors, which methods constitute the extraordinary revenue of the crown. For the public patrimony being got into the hands of private subjects, it is but reasonable that private contributions should supply the public service, which, though it may perhaps fall harder upon some individuals, whose ancestors have had no share in the general plunder, than upon others, yet taking the nation throughout, it amounts to nearly the same, provided the gain by the extraordinary should appear to be no greater than the loss by the ordinary revenue. And, perhaps, if every gentleman in the kingdom was stripped of such of his lands as were formerly the property of the crown, was to be again subject to the inconveniences of purveyance and preemption, the oppression of forest laws, and the slavery of feudal tenures, and was to resign to the crown all his royal franchises of waifs, wrecks, estrays, treasure-trove, mines, forfeitures, and the like, he would find himself a greater loser than by paying his quota to such taxes as are necessary to the support of the government. The thing therefore to be wished and aimed at in a land of liberty is by no means the total abolition of taxes, which would draw after it very pernicious consequences, and the very supposition of which is the height of political absurdity. For as the true idea of government and magistracy will be found to consist in this, that some few men are deputed by many others to preside over public affairs, so that individuals may the better be enabled to attend to their private concerns, it is necessary that those individuals should be bound to contribute a portion of their private gains, in order to support that government, and reward that magistracy which protects them in the enjoyment of their respective properties. But the things to be aimed at are wisdom and moderation, not only in granting, but also in the method of raising the necessary supplies, by tenths and fifteenths. 275 striving to do both in a manner as may be most conducive to the national welfare, till at the same time most consistent with economy and the liberty of the subject, who, when properly taxed, contributes only, as was before observed, some part of his property, in order to enjoy the rest. These extraordinary grants are usually called by the synonymous names of aids, subsidies, and supplies, and are granted, as we have formerly seen, by the Commons of Great Britain and Ireland, in Parliament assembled, who, when they have voted a supply to the Crown, and settled the quantum of that supply, usually resolve themselves into what is called a Committee of Ways and Means to consider the ways and means of raising the supply so voted, and in this committee every member, though it is looked upon as the peculiar province of the Chancellor of the Exchequer, may propose such scheme of taxation as he thinks will be least detrimental to the public. The resolutions of this committee, when approved by a vote of the House, are in general esteemed to be, as it were, final and conclusive. For, though the supply cannot be actually raised upon the subject till directed by an act of the whole Parliament, yet no moneyed man will scruple to advance to the government any quantity of ready cash, on the credit of a bare vote of the House of Commons, though no law be yet passed to establish it. The taxes which are thus raised upon the subject are the land tax, which, in its modem shape, superseded for time all the former methods of rating either property or persons in respect of their property, whether by tenths or fifteenths, subsidies on lands, hittages, scuitages, or talliages, a short explanation of which will however greatly assist us in understanding our ancient laws and history. Tenths and fifteenths were temporary aids issuing out of personal property, and granted to the Crown by Parliament. They were formerly the real 10th or 15th part of all the movables belonging to the subject, when such movables, or personal estates, were a very different and a much less considerable thing than what they usually are at this day. Tenths are said to have been first granted under Henry II, who took advantage of the fashionable zeal for crusades to introduce this new taxation. 276 The royal revenue in order to defray the expense of a petition to Palestine, which he really or seemingly had cited against Saladin, emperor of the Saracens, whence it was originally denominated the Saladin tenth, but afterwards 15ths were more usually granted than tenths. Originally the amount of these taxes was uncertain, being levied by assessments new made at every fresh grant of the commons, a commission for which is preserved by Matthew Paris. But it was at length reduced to a certainty in the 8th year of Edward Roman III when, by virtue of the king's commission, new taxations were made of every township, borough, and city in the kingdom, and recorded in the exchequer. Which rate was, at the time, the 15th part of the value of every township, the whole amounting to about 29,000. And therefore it still kept up the name of a 15th, when, by the alteration of the value of money and the increase of personal property, things came to be in a very different situation. So that when, of later years, the commons granted the crown a 15th, every parish in England immediately knew the proportion of it, that is, the same identical sum that was assessed by the same aid in the 8th of Edward Roman III. And then raised it by a rate among themselves, and returned it into the royal exchequer. The other ancient levies were in the nature of a modern land tax, for we may trace up the origin of that charge as high as to the introduction of our military tenures, when every tenant of a knight's fee was bound, if called upon, to attend the king in his army for 40 days in every year. But this personal attendance growing troublesome in many respects, the tenants found means of compounding for it, by first sending others in their stead, and in process of time by making a pecuniary satisfaction to the crown in lieu of it. This pecuniary satisfaction at last came to be levied by assessment, at so much for every knight's fee, under the name of scutages, which appear to have been levied for the first time in the 5th year of Henry II, on account of his expedition to Toulouse, and were then mere arbitrary compositions, as the king and the subject could agree. But this precedent being afterwards abused into a means of oppression, in levying scutages on the landholders by the royal authority only whenever our kings went to war, in order to hire mercenary troops and pay their contingent expenses, it became thereupon a matter of national hoved. A.D. 1188, cart. 1, 719. A.D. 1232. Subsidies. 277 Complaint, and King Fn was obliged to promise in his Magna Charta that no scutagi *I had be imposed without the consent of the Common Council of the realm. This clause was indeed omitted in the charters of Henry Roman III, where we only find it stipulated that scutages should be taken as they were used to be in the time of King Henry II. Yet afterwards, by a variety of statutes under Henry I and his grandson, it was provided that the king shall not take any aids or tasks, any talliage or tax, but by the common assent of the great men and commons in Parliament. Of the same nature with scutages upon knights' fees were the assessments of hittage upon all other lands and of talliage upon cities and boroughs. But they all gradually fell into disuse upon the introduction of subsidies, about the time of King Richard Roman II and King Henry Roman IV. These were a tax, not immediately imposed upon property, but upon persons in respect of their reputed estates, after the nominal rate affords, in the pound for lands and dues, 8d. for goods, and for those of aliens in a double proportion. But this assessment was also made according to an ancient valuation, wherein the computation was so very moderate, and the rental of the kingdom was supposed to be so exceeding low, that one subsidy of this sort did not amount to more than 70,000 z. It was anciently the rule never to grant more than one subsidy and 2/15ths at a time, but this rule was broken through for the first time on a very pressing occasion, the Spanish invasion in 1588, when the Parliament gave Queen Elizabeth 2 subsidies and 4/15ths. Afterwards, as money sunk in value, more subsidies were given, and we have an instance in the first Parliament of 1640, of the kings desiring 12 subsidies of the commons to be levied in 3 years, which was looked upon as a startling proposal. Though Lord Clarendon says that the Speaker, Sir Jean Glanville, made it manifest to the House how very inconsiderable a sum 12 subsidies amounted to, by telling them he had computed what he was to pay for them himself, and when he named the sum, he being known to be possessed of a great estate, it seemed not worth any farther deliberation. The grant of scutages, talliages, or subsidies by the commons did not extend to spiritual preferments, those being usually taxed at the same time by the clergy themselves in convocation. Which grants of the clergy were confirmed in Parliament? Other. 278. The royal revenue. Why, as they were illegal, and not binding, as the same noble writer observes of the subsidies granted by LJXC convocation, which continued sitting after the dissolution of the first Parliament in 1640. A subsidy granted by the clergy was after the rate of 4s in the pound according to the valuation of their livings in the King's books, and amounted, as Sir Edward Coke tells us, to about 20,000 z. While this custom continued, convocations were wont to sit as frequently as parliaments. But the last subsidies, thus given by the clergy, were those confirmed by Statute 15 Car. Roman 2. c. 10, since which another method of taxation has generally prevailed, which takes in the clergy as well as the laity, in recompense for which the beneficed clergy have from that period been allowed to vote at the election of knights of the shire, and thenceforward also the practice of getting ecclesiastical subsidies has fallen into total disuse. The lay subsidy was usually raised by commissioners appointed by the crown or the great officers of state, and therefore in the beginning of the civil wars between Charles I and his parliament, the latter having no other sufficient revenue to support themselves and their measures, introduced the practice of laying weekly and monthly assessments of a specific sum upon the several counties of the kingdom, to be levied by a pound rate on lands and personal estates, which were occasionally continued during the whole usurpation, sometimes at the rate of 120,000 z. a month, sometimes at inferior rates. From this time forwards we hear no more of subsidies, but occasional assessments were granted as the national emergencies required. These periodical assessments, the subsidies which preceded them, and the more ancient scutage, hitage, and talliage, were to all intents and purposes a land tax, and the assessments were sometimes expressly called so. Yet a popular opinion has prevailed that the land tax was first introduced in the reign of King William Roman III, because in the year 1692 a new assessment or valuation of estates p1 of these bills of assessment, in 1670, when 800,000 z. was raised by 1,656, is preserved in Scoble's Collectway of Subsidy, which was the last time Tian, 400, of raising supplies in that manner, that after the Restoration the ancient monthly assessments now established by method of granting subsidies, instead custom being raised by commissioners of such monthly assessments, was twice, named by Parliament, and producing and twice only, renewed, viz. In 1663, more certain revenue. BL. Com. Vol. I. When 4 subsidies were granted by the P. 313. Temporality, and 4 by the clergy. N. Cora. Durin. 26 June. 9 Dec. 1678. Customs. 279 was made throughout the kingdom, which, though by no means a perfect one, had this etiquette, that a supply of 107 was equal to is in the pound of the value of the estates given in, and according to this enhanced valuation from the year 1693 to *1798, a period of more than a century, the land tax continued an annual charge upon the subject, above half the time at 48 in the pound, sometimes at 3s, sometimes at 2s twice, but without any total intermission. Finally, by the Statute 38 Geo. Roman 3. c. 60, which was amended by several subsequent acts, the land tax was made perpetual and fixed at 4s in the pound, but subject to redemption in most cases by the owner of the property charged buying so much stock in the government funds as yields a dividend, exceeding by a 10th part the amount of the land tax. The terms of redemption have, however, been recently reduced where it has not been redeemed. The method of raising it is by charging a particular sum upon each county, according to the valuation given in AD 1692. And this sum is assessed and raised upon individuals, their personal estates, as well as real, being liable thereto, by commissioners appointed by Act of Parliament from time to time being the principal landholders of the county, and their officers. Roman 2. The customs, or the duties, toll, tribute, or tariff, payable upon merchandise exported and imported. The considerations upon which this revenue, or the more ancient part of it, which arose from exports, was vested in the king, were said to be two. 1. Because he gave the subject leave to depart the kingdom, and to carry his goods along with him. 2. Because the king was bound of common right to maintain and keep up the ports and havens, and to protect the merchants from pirates. Some have imagined they are called with us customs, because they were the inheritance of the king by immemorial usage and the common law, and not granted him by any statute. But Sir Edward Coke has clearly shown that the king's first claim to them was by grant of Parliament 3 Edwa. Though the record thereof is not now extant, and indeed this is in express words confessed by statute 25 Edwa. C. 7, wherein the king promises to take no customs from merchants without the common assent of the realm, in the years 1732 and 1733. The redemption and purchase C. 16 and 16 and 17 Vict. C. 74. As to the 17 Vict O. 90. Application of the moneys arising from 37 Vict. C. 18. 280 the royal revenue, saving to us and our heirs the customs on wool, skins, and leather, formerly granted to us by the commonalty aforesaid. These were formerly called the hereditary customs of the crown, and were due on the exportation only of the said 3 commodities, and of none other, which were styled the staple commodities of the kingdom, because they were obliged to be brought to those ports where the king's staple was established in order to be there first rated, and then exported. They were denominated in the barbarous Latin of our ancient records, customa, not insududines, which is the language of our law whenever it means merely usages. The duties on wool, sheepskins, or woolfulls and leather exported were called customa antiqua sive magna, and were payable by every merchant, as well native as stranger, with this difference, that merchant strangers pay an additional toll, viz. half as much again as was paid by natives. The customa parva et nova were an impost of ZD, in the pound, due from merchant strangers only, for all commodities as well imported as exported, which was usually called the alien's duty, and was first granted in 31 Edwa. But these ancient hereditary customs, especially those on wool and woolfulls, came to be of little account when the nation became sensible of the advantages of a home manufacture, and prohibited the exportation of wool by statute 11 Edwa. Roman 3. C. 1, and the alien's duty was eventually abolished by the statute 24 Geo. Roman 3. Ses. 2c. 16. There is also another very ancient hereditary duty belonging to the crown, called the prisage, or huddlerage of wines, which is considerably older than the customs, being taken notice of in the Great Roll of the Exchequer, 8 I. Still extant. Prisage was a right of taking 2 tons of wine from every ship, English or foreign, importing into England 20 tons or more, 1 before and 1 behind the mast, which by charter of Edward I. was exchanged into a duty of 2s for every ton imported by merchant strangers, and called butlerage, because paid to the king's butler. This appellation seems to be de apra, 1689. Part of the duties of prerived from the French word caustum, or sage, and butlerage were granted by custom, which signifies toll or tribute, Charles Roman II, to his natural son by Barbara, and owes its own etymology to the word Villiers, the ancestor of the present du const, which signifies price, or as we have of Grafton, for purchasing which a con adopted it, cost. Tract was entered into by the Treasury. Dev. 8. To bolster. 254. Stat. Of understat. 43 Geo. Roman 3. C. 156. By which Esther. 16 Edwa. Roman 2. Com. Jurin. 27 an annuity of 6,870 Z. Was to be secured. Other customs payable upon exports and imports were distinguished into subsidies, tonnage, poundage, and other imposts. Subsidies were such as were imposed by Parliament upon any of the staple commodities before mentioned, over and above the customa antiqua et magna. Tonnage was a duty upon all wines imported, over and above the prisage and butlerage aforesaid, Poundage was a duty imposed ad valorem at the rate of \2d in the pound on all other merchandise whatsoever, and the other imposts were such as were occasionally laid on by Parliament as circumstances and times required. These distinctions are now in a manner forgotten, except by the awful beasers immediately concerned in this department, their produce being in effect all blended together under the one denomination of the customs. By these we understand, at present, a duty or subsidy paid by the merchant at the quay upon all imported as well as exported commodities by the authority of Parliament, unless where, for particular national reasons, certain rewards, bounties, or drawbacks are allowed for particular exports and imports. Those of tonnage and poundage in particular were at first granted as the old statutes, and particularly 1 c. 19 express it, for the defense of the realm, and the keeping in safeguard of the seas, and for the intercourse of merchandise safely to come into and pass out of the same. They were at first usually granted only for a stated term of years, as for 2 years and 5 ric. Roman 2. But in Henry VI's time, they were granted him for life by a statute in the 31st year of his reign, and again to Edward Roman 4 for the term of his life also, since which time they were regularly granted to all his successors for life, sometimes at the first, sometimes at other subsequent parliaments till the reign of Charles I, when, as Lord Clarendon tells us, his ministers were not sufficiently solicitous for a renewal of this legal grant. And yet these imposts were imprudently and unconstitutionally levied and taken, without consent of Parliament, for 15 years together, which was one of the causes of those unhappy discontents, justifiable at first in too many instances, but which to the Duke and his heirs, which in the 19 and 20 Vict. c. 43 was passed. The default of such heirs reverted to the Treasury of Ireland was, by 46 Geo. Roman 3. Crown. This agreement was confirmed o. 94, empowered to purchase the duty by 46 Geo. Roman 3. c. 79. The Duke of Presage from the Earl of Ormond, and Mefton has also an annuity on the post-Presage and Buttleridge in Ireland were awful bow of 3,384 f, for the redemption of which abolished by 51 Dio. Roman 3. c. 51. The royal revenue degenerated at last into civil war. Upon the Eastoration this duty was granted to King Charles II for life, and so it was to his 2 immediate successors, but by 3 several statutes, 9 c. 6, 1 Geo. I. c. 12, and 3 Geo. I. c. 7 they were made perpetual and mortgaged for the debt of the public. The customs thus imposed by Parliament are chiefly contained in 2 books of rates, set forth by parliamentary authority, one signed by Sir Harbottle Grimston, Speaker of the House of Commons in Charles II's time, and the other an additional one signed by Sir Spencer Compton, Speaker in the reign of George I. Various additional duties were imposed from time to time, causing great embarrassments as well to the collectors as to the merchants and persons on whom they were levied. Until in 1787, by the Statute 27 Dio. Roman 3. p. 13, the first Customs Consolidation Act, the collection of these duties was improved by abolishing all those then subsisting, and substituting in their stead a single duty on each article. Subsequent alterations called for further consolidation at various periods, the last of which and the principal statute now in force on this subject is the Customs Tariff Act, 1855. This statute has, however, been amended by various subsequent acts, the most important of which is the statute passed to give effect to the recent treaty with France, the effect of all of which, taken together, has been to reduce to a very small number indeed the articles on which duties are now levied. These customs are then, we see, a tax immediately paid by the merchant, although ultimately by the consumer. And yet these are the duties felt least by the people, and, if prudently managed, the people hardly consider that they pay them at all. For the merchant is easy, being sensible he does not pay them for himself, and the consumer, who really pays them, confounds them with the price of the commodity. In the same manner, as Tacitus tells us, that the Emperor Nero gained the reputation of abolishing the tax on the sale of slaves, though he only transferred it from the buyer to the seller, so that it was, as he expresses it, remissum magi specie quam Roman 6, quae cum venditor. J. pendir duberator in partem praeteam ptoribus accresci hat. But this inconvenience attends it on the other hand, that these imposts, if too heavy, are a check and cramp upon trade, and see the statutes 12 Car, Roman 2, c. 4 and 11 Geo. IC. 7. Excise duties. 283 especially when the value of the commodity bears little or no proportion to the quantity of the duty imposed. This in consequence gives rise also to smuggling, which then becomes a very lucrative employment. And its natural and most reasonable punishment, viz. Confiscation of the commodity, is in such cases quite ineffectual. The intrinsic value of the goods, which is all that the smuggler has paid, and therefore all that he can lose, being very inconsiderable when compared with his prospective advantage in evading the duty. Recourse must therefore be had to extraordinary penalties to prevent it, the tendency of which, as has been pointed out by Montesquieu, is to destroy all proportion of punishment. There is also another ill consequence attending high imposts on merchandise, formerly not frequently considered, but indisputably certain, that the earlier any tax is laid on a commodity, the heavier it falls upon the consumer in the end, for every trader through whose hands it passes must have a profit, not only upon the raw material, and his own labor and time in preparing it, but also upon the very tax itself, which he advances to the government. Otherwise he loses the use and interest of the money which he so advances. This disadvantage was ultimately felt to be so considerable as to lead to the introduction of the system of warehousing goods in bond, first suggested in this country by Sir Robert Walpole, by which payment of the duty may be, and is in practice, deferred by the importer of the goods until he has effected his sales, and the articles are withdrawn for the purposes of consumption and use. Roman 3. The excise duties have long been considered the most economical way of taxing the subject, the charges of levying, collecting, and managing them being considerably less in proportion than in other branches of the revenue. But the rigor and arbitrary proceedings of the excise laws seem hardly compatible with the temper of a free nation, for the frauds that might be committed in this branch of the revenue, unless a strict watch is kept, make it necessary, wherever it is established, to give the officers a power of entering and searching the houses of such as deal in excisable commodities, at any hour of the day, and in many cases, of the night likewise. And the proceedings in case of transgressions are so summary and sudden, that a man may be convicted in 2 days. Time in the penalty of many. The royal revenue. £1,000 by 2 commissioners or justices of the peace. To the total exclusion of the trial by jury and disregard of the common law, for which reason, though Lord Clarendon tells us that to his knowledge the Earl of Bedford, who was made Lord Treasurer by King Charles I to oblige his Parliament, intended to have set up the excise in England, yet it never made a part of that unfortunate prince's revenue, being first introduced on the model of the Dutch prototype by the Parliament itself after its rupture with the Crown. Yet such was the opinion of its general unpopularity that when in 1642 aspersions were cast by malignant persons upon the House of Commons that they intended to introduce excises, the House, for its vindication therein did declare that these rumors were false and scandalous, and that their authors should be bended and brought to condign punishment. However, its original establishment was in 1643, and its progress was gradual, being at first laid upon those persons and commodities where it was supposed the hardship would be the least perceivable, viz. The makers and vendors of beer, ale, cider, and perry, and the Royalists at Oxford soon followed the example of their brethren at Westminster by imposing a similar duty, both sides protesting that it should be continued no longer than to the end of the war, and then be utterly abolished. But the Parliament at Westminster soon after imposed it on flesh, wine, tobacco, sugar, and such a multitude of other commodities, that it might fairly be denominated general, in pursuance of the plan laid down by Prynne, who seems to have been the father of the excise in his letter to Sir John Hotham *, signifying that they had proceeded in the excise to many particulars and intended to go on farther, but that it would be necessary to use the people to it by little and little. And afterwards, when the nation had been hissed, b. 3. A member of Parliament till 7 Nov. 1648. Come, Jaum, 8 Uc. 1642, and published in 1654. A protestation asterisk the translator and insinuator of against the illegal, detestable, and oft petavious chronological history informs condemn tax and extortion of excises, that it was first moved for 28 mar. In general, it is probably therefore a 1643, by Prin. And it appears from mistake of the printer for Pym, who the Journals of the Commons, that on was intended for Chancellor of the expat day the House resolved itself into a checker under the Earl of Bedford. Committee to consider of raising money. Lord Clar. B. 7, in consequence of which the excise was 30 May, 1643, Dugdale of the afterwards voted. But Prin was not troubles 120. Accustomed to it for a series of years, the succeeding champions of liberty boldly and openly declared the impost of excise to be the most easy and indifferent levy that could be laid upon the people, asterisk, and accordingly continued it until the Eastoration. Upon King Charles's return, it having then been long established, and its produce well known, some part of it was given to the Crown in 12 car. Roman II, by way of purchase, as was before observed, for the feudal tenures and other oppressive parts of the hereditary revenue. But, from its first origin to the present time, its very name has been odious to the people of England. It has nevertheless been imposed on abundance of other commodities in the reigns of King William Roman III and every succeeding prince, to support the enormous expenses occasioned by our wars on the continent. Thus brandies and other spirits are now excised at the distillery, and malt liquors brewed for sale at the brewery. For coaches and other wheel carriages the occupier is excised, asterisk for horses and dogs the owner, and for armorial bearings the person using them whether he hath right so to do or not. To these we may add malt asterisk and sugar used in brewing. For all which the duty is paid by the manufacturer. Registered many of the excise duties which are generally designated assessed taxes are levied not on the articles themselves, but on the person dealing therein, or on persons exercising particular trades. We may instance the duties paid in the shape of annual licenses by auctioneers, persons letting horses to hire, ale and beer house keepers, dealers in game and distillers and dealers in spirits and foreign wines. The duties payable on the use of hair powder, on stage and hackney carriages, and in respect of railway passengers, are also included under the excise duties. Or 14 Aug. 1640, c. 50, Scobel, has led to the repeal of the duties 72, Stat. 1656, c. 19, Scobel, 453. Formerly levied on the manufacture of the malt tax was originally on glass and bricks, on soap, candles and annual tax, and was first raised in 1097. Sugar, printed silks, linen and paper, it began at 60. But latterly amounted to leather and skins and starch, were 2a. id. In the bushel. It was m.id per formerly subject to duties, in common perpetual by the statute 3 Geo. Roman 4. c. 18, with gold and silver wire and plate, and but is now in effect an annual excise. With lands and goods sold by auction. The list of articles now subject to the duty upon salt, created in the first excise, does not, however, include many year of Queen Anne, was at first tempt that were liable to duty in the time of Prairie, by a statute of Geo. Roman II. It was Sir William Blackstone, the adopt made perpetual, and it so remained till tion of sounder principles of taxation abolished in the reign of Geo. Roman IV. Then those which formerly prevail. 286 The royal revenue. Roman IV. A fourth very considerable branch of the revenue is levied with greater cheerful ease, the J-Post office duties paid for the carriage of letters. As we have traced the origin of the excise to the Parliament of 1643, so it is but justice to observe that this useful invention owes its first legislative establishment to the same assembly. It is true, there existed postmasters in much earlier times, but I apprehend their business was confined to the furnishing of post-horses to persons who were desirous to travel expeditiously, and to the dispatching of extraordinary packets upon special occasions. King James I originally erected a post office under the control of one Matthew de Quester or de Iaquester, for the conveyance of letters to and from foreign parts, which office was afterwards claimed by Lord Stanhope, but was confirmed and continued to William Frizel and Thomas Witherings by King Charles I AD 1632 for the better accommodation of the English merchants. In 1635, the same prince erected a letter office for England and Scotland under the direction of the same Thomas Witherings, and settled certain rates of postage, but this extended only to a few of the principal roads. The times of carriage were uncertain, and the postmasters on each road were required to furnish the mail with horses at the rate of 2 a mile. Witherings was superseded for abuses in the execution of both his offices in 1640, and they were sequestered into the hands of Philip Burlamaqui to be exercised under the care and oversight of the principal Secretary of State. On the breaking out of the Civil War, great confusions and interruptions were necessarily occasioned in the conduct of the letter office, and about that time the outline of the present more extended and regular plan seems to have been conceived by Mr. Edward Prideaux, who was appointed Attorney General to the Commonwealth after the death of King Charles. He was chairman of a committee in 1642 for considering what rates should be set upon inland letters, and afterwards appointed postmaster by an ordinance of both the Houses, in the execution of which office he first established a wheelie conveyance of letters into all parts of the nation, thereby saving to the public the charge of maintaining postmasters to the amount of 7,000 z per annum, and, his own emoluments being probably very considerable, the Common Council of London endeavoured to erect another post office in opposition to his, till checked by a resolution of the House of Commons, declaring that the office of from the Post Office 287 Postmaster is and ought to be in the sole power and disposal of the Parliament. This office was afterwards farmed by one Manley, in 1654, but in 1657, a regular post office was erected by the authority of the Protector and his Parliament, upon nearly the same model as has been ever since adopted, and with the same rates of postage as continued till the reign of Queen Anne. After the Restoration, a similar office, with some improvements, was established by Statute 12 Car. Roman II. c. 35, but the rates of letters were altered, and some farther regulations added by many subsequent statutes, by which penalties were enacted, in order to confine the carriage of letters to the public office only, except in some few cases, a provision which is absolutely necessary, for nothing but an exclusive right can support an office of this sort. Many rival independent offices would only serve to ruin one another. The privilege of letters coming free of postage to and from members of Parliament was claimed by the House of Commons in 1660 when the first legal settlement of the present post office was made, but afterwards dropped upon a private assurance from the Crown that this privilege should be allowed the members, and accordingly a warrant was constantly issued to the Postmaster General, directing the allowance thereof to the extent of 2 ounces in weight, till at length it was expressly confirmed by Statute 4 Geo. Roman III. c. 24. As commerce and education increased, however, the charge made by the government for conveying and distributing letters was felt to be unnecessarily high, and at the same time to lead to numerous petty frauds and evasions of the statutes relating to the post office. The result of a long inquiry and full discussion in Parliament was the establishment, in 1840, of the existing system of a uniform rate, beginning at 1 penny and increasing according to weight, the privilege of members of Parliament to frank letters being at the same time abolished. Facilities have since. The preamble of the Ordinance of Under the Inspection of Government is Cromwell states that establishing one still continued, for, by a warrant from General Post Office, besides the benefit one of the principal Secretaries of State, to commerce, and the convenience of letters may be detained and opened, conveying public dispatches, will be 9 N. c. 10 S. 40. Christian, the best means to discover and prevent C2 and 3 Vict. c. 52. And subsimony dangerous and wicked designs quent statutes. Newspapers which against the Commonwealth, and it were formerly liable to a stamp duty, would seem that the policy of having and were carried free, are now charged the correspondents of the kingdom with postage in lieu of the stamp duty. The royal revenue being given for the transmission of printed periodical publications, books and patterns at still lower rates with reference to the weight carried. A fifth branch of the revenue consists in the stamp duties, which are a tax imposed upon all parchment and paper whereon private instruments of almost any nature whatsoever are written, * on all proceedings in the courts of justice, on probates of wills and letters of administration, and on various licenses, other than those mentioned under the head of excise duties, as marriage licenses, and licenses to practice and exercise various callings, such as that of a solicitor, and on admission to offices and degrees. These imposts are very various, according to the nature of the thing stamped, rising gradually from a penny to many pounds. This is also a tax, which, though in some instances it may be heavily felt, by greatly increasing the expense of all mercantile as well as legal proceedings, yet, if moderately imposed, is of service to the public in general, by authenticating instruments and rendering it much more difficult than formerly to forge deeds of any standing, since a man that would forge a deed of King William's time must know and be able to counterfeit THFE stamp of that date also. In some countries the duty is laid on the contract itself, and not on the instrument in which it is contained, but this tends to draw the subject into 1,000 nice disquisitions and disputes concerning the nature of his contract, and whether taxable or not. Our general method answers the purposes of the state as well, and consults the ease of the subject much better. The first institution of the stamp duties was by Statute 5 and 6 Wm. and M. C. 21, and they have since, in many instances, been increased to 10 times their original. Sir William Blackstone was a venue as an indemnity to the government opinion that there could not be for the cost of conveying and distributised a more eligible method than this, in letters. The electric telegraphs have of raising money upon the subject, for been transferred to the post office, and therein both the government and the it is anticipated will in time increase its people find a mutual benefit. The revenue. A similar observation may be government acquires a large revenue, made with reference to the post office, and the people do their business with savings banks, which grant annuities to greater ease, expedition, and cheapness a limited extent, and also to the money than they would be able to do if no such order department, tax, and of course no such office existed. Other than private local courts be. The notion of modern times, however, longing to corporations and other public is that the postal charges should become bodies, as to which see judicial statistics. Cited not so much as a source of republished annually. Succession duties 289 amount. While, on the other hand, the duties on many instruments and documents have been in some cases wholly repealed, and in others considerably reduced. VI. A sixth and very important branch of the revenue consists in the legacy and succession duties. For many years persons succeeding to personal property, including leaseholds, whether they took by will as executors or legatees, or merely as administrators or next of kin, or charged heavy duties, varying, however, according to the relationship and the value of the property bequeathed to them, or to which they succeeded. This duty was payable besides the ad valorem duty, which was and still is levied in the first instance, on the grant of probate or letters of administration, according to the estimated sworn value of the personal property of the deceased, and which falls within the category of the stamp duties. The legacy duty, as it is generally termed, is chargeable after the estate of the deceased has been realized and administered, on the property distributed among the legatees or next of kin, as the case may be, and varies in amount according to the consanguinity of the next of kin, or the absence of any relationship between the legatee and the testator. The exemption of real estate from this species of taxation was long complained of, as creating an undue preference in favor of the holders of landed property, and this exemption has accordingly been removed. Succession duties are now payable on every succession to property, whether real or personal, other than that on which a legacy duty is payable, according to the value and the relationship of the parties to the predecessor. This value is ascertained by considering the interest of the successor as of the value of an annuity equal to the annual value of the property, estimated as the Act directs, and the duty may be paid by certain installments, or at once, according to the wish of the party liable thereto. Roman 7. A seventh branch is the inhabited house duty. As early as the Conquest, mention is made in Domesday Book of fumage or fewage, backlash tokerly called smoke farthings, which were paid by custom to the king for every chimney in the house. And we read that Edward the Black Prince, soon after his successes in France, in imitation of the English custom, imposed a tax of a florin upon 16 and 17 vict. c. 51. Vol. I.U. The royal revenue. Every hearth in his French dominions. But the first parliamentary establishment of it in England was by Statute 13 and 14 Car. Roman 2. c. 10, whereby a hereditary revenue of 2s for every hearth in all houses paying to church and poor was granted to the king for ever, and, by subsequent statutes for the more regular assessment of this tax, the constable and 2 other substantial inhabitants of the parish, to be appointed yearly, or the surveyor appointed by the crown, together with such constable or other public officer, were, once in every year, empowered to view the inside of every house in the parish. But, upon the Revolution, by Statute 1 Wm. and Empson 1 c. 10, hearth money was declared to be not only a great oppression to the poorer sort, but a badge of slavery upon the whole people, exposing every man's house to be entered into and searched at pleasure by persons unknown to him, and therefore to erect a lasting monument of their Majesties' goodness in every house in the kingdom. The duty of hearth money was taken away and abolished. This monument of goodness remains among us to this day, but the prospect of it was somewhat darkened, when in 6 years afterwards by Statute 7 Wm. Roman 3. c. 18, a tax was laid upon all houses, except cottages, of 2s, subsequently advanced to 3s per annum, and a tax also upon all windows if they exceeded 9 in such house. These rates were from time to time varied and extended, until, by Stat. 3 and 4 Will. 39, house tax was abolished, the duty on windows remaining. Finally, by the Statute 14 and 15 Vict. c. 30, the duties on windows were abolished, but in lieu thereof a tax was imposed not on hearths, but what amounts to the same thing, on inhabited houses. Roman 8. The 8th branch of the revenue is a duty for every male servant retained, or employed in the several capacities specifically mentioned in the Acts of Parliament, and which almost amount to an universality except such as are employed in husbandry, trade, or manufactures. Roman 9. The next tax is one of comparatively recent introduction, and although at present imposed from year to year only bids fair to become perpetual in point of fact, this the property and income tax. An income tax was imposed in 1797, during the war with France, and continued until 1802, and was again revived in 1803, and continued until 1816, when it was as it was thought. Spelm, Glostate, Fewage. National debt. 291 finally repealed. The present tax was imposed in 1842 for 3 years. At the rate of ID, in the pound on the property and income of all persons in Great Britain possessed of 150z a year and upwards. It now applies with certain modifications to incomes of £100, and varies almost annually in amount. *X. The 10th and last branch of the extraordinary perpetual revenue is the duty upon offices and pensions, consisting in an annual payment, over and above all other duties, out of all salaries, fees, and perquisites of offices and pensions payable by the Crown, exceeding the value of LOOZ per annum. This highly popular taxation was imposed by Statute 31 Geo. Roman 2. c. 22, * and was made perpetual by the Statute 6 and 7 Will. Roman 4. c. 97. * It may be observed that the public revenues of Great Britain and Ireland were by Statute 56 Geo. Roman 3. c. 98, consolidated into one fund, and that most of the duties above enumerated are now under the management of the Board of Commissioners of Inland Revenue, recently substituted for the separate boards of excise and stamps and taxes, and that the charges of their collection and management are provided by annual votes of Parliament. The clear net produce of these several branches of the revenue, after all charges of collecting and management paid, amounts at present annually to upwards of 70 millions sterling. How these immense sums are appropriated is next to be considered. And this is, first, to the payment of the interest of the national debt. In order to take a clear and comprehensive view of the nature of this national debt, it must first be premised that after the Revolution, when our new connections with Europe introduced a new system of foreign politics, the expenses of the nation, not only in settling the new establishment, but in maintaining long wars as principles on the continent for the security of the Dutch barrier, reducing the French monarchy, settling the Spanish succession, supporting the House of Austria, maintaining the liberties of the Germanic body, and other purposes, increased to an unusual degree, insomuch that it was not thought advisable to raise all the expenses of any one year by taxes to be levied. 5 and 6 Vic. C. 35. Penditure of the United Kingdom IA. 38 Vic. C. 23. Annually presented to both houses of a report on the revenue and pound ex-Parliament. U2. The royal revenue. Within that year, lest the unaccustomed weight of them should create murmurs among the people, it was therefore the policy of the times to anticipate the revenues of their posterity, by borrowing immense sums for the current service of the state, and to lay no more taxes upon the subject than would suffice to pay the annual interest of the sums so borrowed, by this means converting the principal debt into a new species of property, transferable from one man to another, at any time, in any quantity, a system which seems to have had its origin in the state of Florence A.D. 1344, which government then owed about 60,000 sterling, and being unable to pay it, formed the principal into an aggregate sum, called metaphorically amount or hank, the shares whereof were transferable like our stocks, with interest at 5%, the prices varying according to the exigencies of the state. This policy of the English Parliament laid the foundation of what is called the national debt, for a few long annuities created in the reign of Charles Roman II will hardly deserve that name, and the example then set was so closely followed during the long wars in the reign of Queen Anne, and since, by the 7 Years' War, the war with America and with France after the Revolution, and more recently by the Cushion War, that the capital of the national debt, funded and unfunded, now amounts to upwards of 700 millions. To pay the interest of which, and the charges of management, the extraordinary revenues just now enumerated are in the first place mortgaged and made perpetual by Parliament. Perpetual, I say, but still redeemable by the same authority that imposed them, which, if at any time it can pay off the capital, will abolish those taxes which are raised to discharge the interest. By this means the quantity of property in the kingdom is greatly increased in idea, compared with former times, yet if we coolly consider it, not at all increased in reality. We may boast of large fortunes and quantities of money in the funds. But where does this money exist? It exists only in name, in paper, in public faith, in parliamentary security. And that is, the funded debt consists of generally to meet emergencies, but unperpetual but redeemable annuities, and the authority of a statute. C. 29 Vict of terminable annuities, all created by C. 25, and 36 and 37 Vict. C. 54. The Parliament and charged on the consuliformer may be considered the permanent dated fund. The unfunded debt consists at, the latter being in its nature of exchequer bonds and bills issued temporary. Undoubtedly sufficient for the creditors of the public to rely on. But then what is the pledge which the public faith has pawned for the security of these debts? The land, the trade, and the personal industry of the subject, from which the money must arise that supplies the several taxes. In these, therefore, and these only, the property of the public creditors does really and intrinsically exist. And of course the land, the trade, and the personal industry of individuals are diminished in their true value just so much as they are pledged to answer. If A. Dot's income amounts to LOZ per annum, and he is so far indebted to B, that he pays him 50 Z per annum for his interest, 1/2 of the value of A. Dot's property is transferred to B the creditor. The creditor's property exists in the demand which he has upon the debtor and nowhere else, and the debtor is only a trustee to his creditor for 1/2 of the value of his income. In short, the property of a creditor of the public consists in a certain portion of the national taxes. By how much therefore he is the richer, by so much the nation which pays these taxes is the poorer. Asterisk thus much is. Sir William Blackstone here adds, the only advantage that can result to a nation from public debts is the increase of circulation by multiplying the cash of the kingdom and creating a new species of currency, assignable at any time and in any quantity, always, therefore, ready to be employed in any beneficial undertaking, by means of this its transferable quality, and yet producing some profit even when it lies idle and unemployable. A certain proportion of debt seems, therefore, to Ijo highly useful to a trading people, but what that proportion is it is not for me to determine. It is a very erroneous notion indeed to suppose that the property of the kingdom is increased by national debt, contracted in consequence of the expenses of war. On the contrary, the principle of the debt is the exact amount of the property which the nation has lost from its capital forever. The American war cost the natum 116 million sterling, and the effect is precisely t libani as if so much of its wealth and treasure in corn, cattle, cloth, ammunition, coin, and he had been collected together and thrown into the sea, ixide asterisk the loss accruing from the destruction of many of its most productive hands. When this property is consumed, it never can be retrieved, till industry and care may acquire and accumulate new stores. Such a supply, by no mode of taxation that has yet been devised, could be collected at once, without exhausting the patience and endurance of T-li people. But by the method of funding, T-subjects are induced to suppose that their suffering consists only in the payment of the yearly interest of this immense waste. T-li ruin is completed before the interest commences, for that is earned by the nation to the nation, and returns back to its former channel and circulation, like the liffles in a tennis court. However they may be tossed from one side to the other, their sum and quantity, within the court, continue the same. The extravagance of individuals naturally suggested the system of funding the public debts. \vin a man cannot satisfy the immediate demands of his CRTX litter. It is an obvious expedient to give him a promio BSRY note to pay him at a future day. Indisputably certain that the present magnitude of our national encumbrances is productive of the greatest inconveniences. For, first, the enormous taxes for the payment of the interest of this debt are a hurt both to trade and manufactures, by raising the price as well of the artificer's subsistence as of the raw material, and of course, in a much greater proportion, the price of the commodity itself. Nay, the very increase of paper circulation itself, when extended beyond what is requisite for commerce or foreign exchange, has a natural tendency to increase the price of provisions as well as of all other merchandise. For as its effect is to multiply the cash of the kingdom, and this to such an extent that much must remain unemployed, that cash, which is the universal measure of the respective values of all other commodities, must necessarily sink in its own value, and everything grow comparatively dearer. Secondly, if part of this debt be owing to foreigners, they draw out of the kingdom annually a considerable quantity of specie for the interest. Thirdly, if the whole be owing to subjects only, it is then charging the active and industrious subject, who pays his share of the taxes to maintain the indolent and idle creditor who receives them. Lastly, and principally, it weakens the internal strength of a state, by anticipating with interest for the time, and if this debt is contracted, and the money spent, an assignable note, so that the creditor the mischief is done, the discharge of an be enabled to persuade annatly to the debt can add nothing, or a little corn advance him the principal and to stand comparatively, immediately to the stock or due his place, it is exactly similar to the capital of the nation. But yet these debts or securities of government, except important consequences may be expected that, in general, they are not payable from it, viz. From the abolition of taxes any day night time. All debts, when know upon a melancholy catalogue of the effects remain, both in public and private, necessary articles of life taxes which are certain evidence of the waste and take from those who have nothing to consumption of so much property, which spare, the price of labor would be nothing can restore, though frugality lowered, manufactures would flourish and industry may alleviate the future with renewed vigor, the minds of the consequences. When a debt is contracted, people would be cheered, and nation a man is not richer for paying it, if he would again have credit and spirit to owes £100, and pays its most formidable enemies, and to take crest for it, he is in no degree richer by repel and resent both injury and insult, calling in £100 from all the nations of Europe have learnt which he receives the same interest, and from such dear-bought experience that therewith discharges the debt. But for poverty and misery are the inevitable babely. If he does so, he will feel himself consequences of war, as to give us reason more comfortable and independent, and to hope that the lives and property of will find his credit. Higher ill-eary occasions mankind will not, in future, be dissipated choicks'll oblige him to borrow in future. With the profusion and wantonness of so it is with governments, when the former times, Question. Consolidated Fund 295 those resources which should be reserved to defend it in case of necessity. The interest we now pay for our debts would be nearly sufficient to maintain any war that any national motives could require. And if our ancestors in King William's time had annually paid, so long as their exigencies lasted, even a less sum than we now annually raise upon their account, they would in the time of war have borne no greater burdens than they have bequeathed to and settled upon their posterity in time of peace, and might have been eased the instant the exigence was over. The respective produces of the several taxes before mentioned were originally separate and distinct funds, being securities for the sums advanced on each several tax and for them only. But it became necessary, in order to avoid confusion, to reduce the number of these separate funds by uniting and blending them together. In this way 3 separate funds were formed, the aggregate fund and the general fund, so called from such union and addition, and the South Sea Fund, being the produce of the taxes appropriated to pay the interest of such part of the national debt as was advanced by that company and its annuit MTS. Asterisk in 1786 by the Statute 27 Geo. Roman 3. C. 98. These 3 funds were united into the Consolidated Fund, and by 56 GTK. Il C. 98. The Consolidated Fund, or revenue of Great Britain was combined with that of Ireland, forming the Consolidated Fund of the United Kingdom, pledged for the payment of the interest of the consolidated national debt of the United Kingdom. The customs, excises, and other taxes, which are to support these funds, depending on contingencies, UXN exports, MJRTS, and consumptions, must necessarily be of a very uncertain amount. But though some of them have proved unproductive, and others deficient, the sum total has always been considerably more than was sufficient to answer the annual charge to them. The 8 yearly lesses therefore of the then existing 3 great national funds, the aggregate, general, and South Sea funds, over and above the interest and annuities charged upon them, were directed by Statute 3 Geo. I. C. 7 to be carried together, and to attend the disposition of Parliament, and were usually denominated the sinking fund, because originally destined to sink and lower the national debt. Asterisk in 1786, when, as we have asterisk. It must be recollected that when W. Lyot it at present amounts to, but Sir William Ulextow thus wrote, the neatliquor where wars conducted on so largo national debt was not a 6th part of or so expensive a scale. The royal revenue. Scene. The revenue of the kingdom was consolidated. The sum of 1 million was directed to be annually set apart from the income of the country towards the extinction of the debt. But although no objection existed to this scheme as long as the annual revenue exceeded the expenditure, it became absurd when, in subsequent years, it was necessary to borrow the sum so reserved. And in 1824 the plan of keeping up a nominal sinking fund, when in reality no surplus existed, was abandoned. In 1829, however, was passed the Statute 10 Geo. Roman 4. C. 37, which directs 1/4 part of the actual annual surplus revenue, when there is such a surplus, to be applied for the future in reduction of the national debt, and appoints a body of commissioners to see this done. But the powers of this board are practically exercised by the Chancellor of the Exchequer, assisted by the Governor and Deputy Governor of the Bank of England. This is now called the Old Sinking Fund, to distinguish it from the new sinking FTMD, created by the Statute 38 and 39 Vict. C. 45, whereby such portion of the permanent annual charge for the national debt, which is fixed for the future at 28 millions, as is not required for paying the annual charges thereon, which are also defined by the statute, is to be devoted to the gradual reduction of the national debt. Substantial relief from this pressure on the industry of the country has arisen from lowering the rate of interest and the conversion from time to time of portions of the perpetual annuities, which is the form of the funded debt, into terminable annuities expiring at fixed periods. This course, if resorted to, when occasion offers, should ultimately effect a considerable reduction both in the amount of the debt and the annual payments on account of it. Unfortunately, our finance ministers have for many years past despaired of being able to materially reduce our indebtedness, and their policy has accordingly been rather to regulate the amount of taxation by the sum actually required for the public service and the interest of the debt, than to raise money for the payment of the principal. Before any part of the annual revenue can be applied to diminish the principal of the public debt, it stands mortgaged by Parliament to raise an annual sum for the maintenance of the royal household and the civil list. For this purpose, in the reigns of the Hanoverian kings, the produce of certain branches of the excise and customs, the post office, the duty on wine, civil lists, 297 licenses, the revenues of the crown lands, the profits arising from courts of justice, which articles included all the hereditary revenues of the crown, and also a clear annuity of 120,000 z. in money, were settled on the king for life for the support of his majesty's household and the honor and dignity of the crown. And as the amount of these several branches was uncertain, if they did not rise annually to 800,000 z, the Parliament engaged to make up the deficiency. But soon after the accession of George III, the hereditary and other revenues were carried into and made a part of the aggregate fund, and the aggregate fund was charged with the payment of the whole annuity to the crown of 800,000, subsequently increased to upwards of 1 million. A similar course was adopted on the accession of George IV, William IV, and Her present Majesty, this appropriation only enduring for the life of the sovereign in the spirit of the Statute of Anne St. 1 c. 7 s. 7 extended by the 1 and 2 Vict. c. 95 s. 4, which provides that the hereditary revenues of the crown shall not be alienable for any term longer than the life of the king or queen making the grant. Hereby the revenues themselves, being put under the same care and management as the other branches of the public patrimony, produce more and are better collected than they otherwise would, and the public is consequently a gainer, and upon the whole it is doubtless much better for the crown, and also for the people, to have the revenue settled upon the modern footing rather than the ancient. For the crown, because it is more certain, and collected with greater ease. For the people, because they are now delivered from the feudal hardships and other odious branches of the prerogative. The expenses formerly defrayed by the civil list were those that in any shape relate to civil government, as the expenses of the royal household, the revenues allotted to the judges, all salaries to officers of state, and every of the sovereign's servants, the appointments to foreign ambassadors, the maintenance of the royal family, the sovereign's private expenses, or privy purse, and other very numerous outgoings, as secret service money, pensions, and other bounties, which sometimes have so far exceeded the revenues appointed for that purpose, that application has been made to Parliament to discharge the debts contracted on the civil list. The civil list is indeed properly the whole of the sovereigns. 298 The royal revenue. Revenue in his own distinct capacity, the rest being rather the revenue of the public or its creditors, though collected and distributed again in the name and by the officers of the crown. It now standing in the same place as the hereditary income did formerly, and, as that has gradually diminished, the parliamentary appointments HFQ increased. The whole revenue of Queen Elizabeth did not amount to more than 600,000 a year, that of King Charles I was 800,000, and the revenue voted for King Charles Roman II was 1,200,000, though complaints were made that it did not amount to so much. But it must be observed that under these sums were included all manner of public expenses, among which Lord Clarendon in his speech to the Parliament computed that the charge of the Navy and land forces amounted annually to 800,000, which was 10 times more than before the former troubles. The same revenue, subject to the same charges, was settled on King James Roman II. But by the increase of trade and more frugal management, it amounted on an average to $1.5 million per annum, besides other additional customs granted by Parliament, which produced an annual revenue of 400,000, out of which his fleet and army were maintained at the yearly expense of 1,100,000. After the Revolution, when the Parliament took into its own hands the annual support of the forces both maritime and military, a civil list revenue was settled on the new king and queen, amounting, with the hereditary duties, to 700,000 per annum, and the same was continued to Queen Anne and King George I. That of King George Roman II we have seen, was nominally augmented to 800,000, and in fact was considerably more. While that of his successor, George III, reached 1,030,000, besides sums voted by Parliament for the discharge of debts. In the reigns of William IV and of Her present Majesty, various payments previously charged on the civil list have been made directly chargeable on the consolidated fund, in consequence of which a sum under 400,000 a year at present suffices for the maintenance of the royal family, and for the payment of such other sums as are still charged on the civil list. This finishes our inquiries into the fiscal prerogatives of the sovereign, or his revenue, both ordinary and extraordinary. We have therefore now chalked out all the principal outlines of this vast title of the law, the Supreme Executive Magistrate, considered in his several capacities and points of view. But before we Royal Prerogative 299 entirely dismiss this subject, it may not be improper to take a short comparative review of the power of the sovereign, or prerogative of the crown, as it stood in former days, and as it stands at present. And we cannot but observe that most of the laws for ascertaining, limiting, and restraining this prerogative have been made within the compass of little more than *2 centuries. Passed from the petition of right in 3 car I to the present time, so that the powers of the crown are now to all appearance greatly curtailed and diminished since the reign of King James I, particularly by the abolition of the Star Chamber and High Commission courts in the reign of Charles I, and by the disclaiming of martial law and the power of levying taxes on the subject by the same prince, by the disuse of the forest laws, and by the many excellent provisions enacted under Charles II, especially the abolition of military tenures, purveyance, and preemption, the Habeas Corpus Act, and the acts to prevent the discontinuance of parliaments for above 3 years, and since the Revolution, by the strong and emphatic words in which our liberties are asserted in the Bill of Rights and Acts of Settlement, by the Act for Triennial, since turned into septennial, elections, by the exclusion of certain officers from the House of Commons, by rendering the seats of the judges permanent, and their salaries liberal and independent, and by restraining the royal pardon from obstructing parliamentary impeachments. Besides all this, if we consider how the crown is impoverished and stripped of all its ancient revenues, so that it must greatly rely on the liberality of Parliament for its necessary support and maintenance, we may perhaps be led to think that the balance is inclined pretty strongly to the popular scale, and that the executive magistrate has neither indigence nor power enough left to form that check upon the Lords and Commons, which the founders of our Constitution intended. But, on the other hand, it is to be considered that every prince, in the first Parliament after his accession, has by long usage a truly royal addition to his hereditary revenue settled upon him for his life, and has never any occasion to apply to Parliament for supplies, but upon some public necessity of the whole realm. This restores to him the constitutional independence which at his first accession seems, it must be owned, to be wanting. And then, with regard to power, we may find perhaps that the hands of government are at least sufficiently the royal prerogative strengthened, and that an English monarchy is now in no danger of being overborne by either the nobility or the people. The instruments of power are not perhaps so open and avowed as they formerly were, and therefore are the less liable to jealous and invidious reflections, but they are not the weaker upon that account. In short, our national debt and taxes, besides the inconveniences before mentioned, have also in their natural consequences thrown such a weight of power into the executive scale of government as we cannot think was intended by our patriot ancestors, who gloriously struggled for the abolition of the then formidable parts of the prerogative, and by an unaccountable want of foresight established this system in their stead. The entire collection and management of so vast a revenue, being placed in the hands of the Crown, have given rise to such a multitude of new officers created by and removable at the royal pleasure, that they have extended the influence of government to every corner of the nation. Witness the commissioners and the multitude of dependents on the customs in every port of the kingdom, the commissioners of excise, surveyors and collectors of the assessed income and land taxes and their numerous subalterns in every inland district, the postmasters and their servants, planted in every town and upon every public road, and the commissioners of the stamps and their distributors, which are full as scattered and full as numerous, all which are either mediately or immediately appointed by the Crown, and removable at pleasure without any reason assigned. These, it requires but little penetration to see, must give the power, on which they depend for subsistence, an influence most amazingly extensive. To this may be added the frequent opportunities of conferring particular obligations, by preference in money transactions, which will greatly increase this influence, and that over those persons whose attachment, on account of their wealth, is frequently the most desirable. All this is the natural though perhaps the unforeseen consequence of erecting our funds of credit, and to support them establishing our present perpetual taxes, the whole of which is entirely new since the Castration in 1660, and by far the greatest part since the Evolution in 1688. And the same may be said with regard to the officers in our numerous army, and the places which the army has created. All which put together give the executive power so persuasive an energy with respect to the persons themselves, and so prevailing. Patronage and influence. 301 in interest with their friends and families, as will amply make amends for the loss of external prerogative. But, though this profusion of offices should have no effect on individuals, there is still another branch of power, and that is, not the influence only, but the force of a disciplined army. Paid indeed ultimately by the people, but immediately by the Crown. Raised by the Crown, officered by the Crown, commanded by the Crown. They are kept on foot, it is true, only from year to year, and that by the power of Parliament. But during that year they must, by the nature of our Constitution, if raised at all, be at the absolute disposal of the Crown. And there need be few words to demonstrate how great a trust is thereby reposed in the Prince by his people, a trust that is more than equivalent to 1,000 little troublesome prerogatives. Upon the whole, therefore, I think it is clear that, whatever may have become of the nominal, the real power of the Crown has not been too far weakened by any transactions during the last *2 centuries. Much is indeed given up, but much is also acquired. The stem commands of prerogative have yielded to the milder voice of influence. The slavish and exploded doctrine of non-resistance has given way to a military establishment by law. And to the disuse of parliaments has succeeded a parliamentary trust of an immense perpetual revenue. When our national debts shall be lessened, when the posture of foreign affairs will suffer our army to be thinned and regulated, and when our taxes shall be gradually reduced, this adventitious power of the Crown will slowly and imperceptibly diminish, as it slowly and imperceptibly rose. But till that shall happen, it will be our especial duty, as good subjects and good Englishmen, to reverence the Crown, and yet guard against corrupt and servile influence from those who are entrusted with its authority, to be loyal, yet free, obedient, and yet independent, and, above everything, to hope that we may long, very long, continue to be governed by a sovereign who has ever manifested the highest veneration for our free constitution, and will therefore never harbor a thought, or adopt a persuasion, in any the remotest degree detrimental to public liberty. A. Chapter Roman 9. Of subordinate magistrates. In a former chapter we distinguished magistrates into two kinds. Supreme, or those in whom the sovereign power of the state resides, and subordinate, or those who act in an inferior secondary sphere. We have hitherto considered the former kind only, namely, the supreme legislative power or Parliament, and the supreme executive power, which is the sovereign, and are now to proceed to inquire into the rights and duties of the principal subordinate magistrates. And herein we are not to investigate the powers and duties of the great officers of state, the Lord Treasurer, Lord Chamberlain, the principal secretaries, or the like, because I do not know that they are in that capacity in any considerable degree the object of our laws, or have any very important share of magistracy conferred upon them, except that the secretaries of state are allowed in certain cases the power of commitment in order to bring offenders to trial. Neither shall I here treat of the office and authority of the Lord Chancellor, or the other judges of the superior courts of justice, because they will find a more proper place in the third part of these commentaries. Nor shall I enter into any minute disquisitions with regard to the rights and dignities of mayors and aldermen, or other magistrates of particular corporations, because these are mere private and strictly municipal rights, depending upon the domestic constitution of their respective franchises, although controlled by general legislative provisions. But the magistrates and officers, whose rights and duties it will be proper in this chapter to consider, are such as are generally in use and have a jurisdiction and authority dispersedly throughout the kingdom, which are principally sheriffs, coroners, justices of the sheriff, 303 peace, constables, surveyors of highways, and overseers and guardians of the poor, in treating of all which I shall inquire into, first, their antiquity and origin, next, the manner in which they are appointed and may be removed, and lastly, their rights and duties. And first of sheriffes. The sheriff is an officer of very great antiquity in this kingdom, his name being derived from two Saxon words sired jerifa, the reeve, bailiff, or officer of the shire. He is called in Latin viscomes, to whom the custody of the shire is said to have been committed at the first division of this kingdom into counties. But the earls, in process of time, by reason of their high employments and attendance on the person of the sovereign, not being able to transact the business of the county, were delivered of that burden, reserving to themselves the honor, but the labor was laid on the sheriff. So that now the sheriff does all the sovereign's business in the county, and though he be still called viscomes, yet he is entirely dependent of, and not subject to, the earl. The * crown, by warrant under the hand of the clerk of the Privy Council * committing custodiam comitatus to the sheriff, and him alone. Sheriffs were formerly chosen by the inhabitants of the several counties, in confirmation of which it was ordained by Statute 28 Edwa. I.C. 8 that the people should have election of sheriffs in every shire, where the shrievalty is not of inheritance. For anciently in some counties the sheriffs were hereditary, as I apprehend they were in Scotland till the Statute 20 Geo. Roman 2. c. 43 abolished heritable jurisdictions in that kingdom, and so continued in the county of Westmoreland until very recently *. The city of London having also the inheritance of the shrievalty of Middlesex vested in their body by charter. The reason of these popular elections is assigned in the same statute, c. 13. That the commons might choose such as would not be a burden to them. And herein appears plainly a strong trace of the democratic part of our Constitution, in which form of government it is an indispensable requisite that the people should choose their own magistrates. This election was in all probability not absolutely vested in the commons, but required the royal approbation, for in the Gothic constitution, the judges of the county courts, which office * was formerly executed by our 3 and 4 will. Roman 4. c. 99 8. Free. 13 and 14 Vict. c. 30. Subordinate magistrates. Sheriff were elected by the people, but confirmed by the king, and the form of their election was thus managed. The people, or in causa territorii, chose 12 electors, and they nominated 3 persons ex qui his rex unum confirmabat. But with us in England, these popular elections growing tumultuous, were put an end to by the Statute 9 Edwa. Roman 2. Cent. 2, which enacted that the sheriff should from thenceforth be assigned by the chancellor, treasurer, and the judges as being persons in whom the same trust might with confidence be reposed. By Statutes 14 Edwa. Roman 3. c. 7, 23 hen. vi. c. 8 and 21 hen. Roman 8. c. 20, the chancellor, treasurer, president of the king's council, *e/justices, and chief baron, are to make this election, and that on the morrow of All Souls in the Exchequer. The Statute of Cambridge 12 Kick. Roman 2. c. 2 ordains that the chancellor, treasurer, keeper of the privy seal, steward of the king's house, the king's chamberlain, clerk of the rolls, the justices of the one bench and the other barons of the exchequer, and all other that shall be called to ordain, name, or make justices of the peace, sheriffs, and other officers of the king, shall be sworn to act indifferently, and to appoint no man that sooth either privily or openly to be put in office, but such only as they shall judge to be the best and most sufficient. And the custom now is and has been at least ever since the time of Fortescue, who was Chief Justice and Chancellor to Henry VI, that all the judges, together with the other great officers and privy councillors, meet in the exchequer, formerly on the morrow of All Souls, but now the morrow of St. Martin yearly, and then and there the judges propose 3 persons to be reported, if approved of, to the sovereign, who afterwards pricks, that is appoints one of them to be sheriff. This custom of the judges proposing 3 persons seems borrowed from the Gothic constitution before mentioned, with this difference, that among the Goths the nominers were first elected by the people themselves. And this usage of ours, at its first introduction, I am apt to believe was founded upon some statute, though not now to be found among our printed laws, first, because it is materially different from the direction of all the statutes before mentioned, which it is hard to conceive that the judges would have countenanced by their concurrence, or that Fortescue would have inserted in his book, unless by the authority of some statute, and also because the statute is expressly Stern. De jure Goth. 1 C. Free. 24 Geo. Roman 2. C. 48. The sheriff. 305 referred to in the record, which Sir Edward Coke tells us he transcribed from the Council Book of 33 Arc. 34 Hen. VI, and which is in substance as follows. The king had of his own authority appointed a man sheriff of Lincolnshire, which office he refused to take upon him, whereupon the opinions of the judges were taken, what should be done in this behalf. And the 2 chief justices, Sir John Fortescue and Sir John Pricott, delivered the unanimous opinion of them all, that the king did an error when he made a person sheriff that was not chosen, and presented to him according to the statute, that the person refusing was liable to no fine for disobedience, as if he had been one of the 3 persons chosen according to the tenor of the statute, that they would advise the king to have recourse to the 3 persons that were chosen according to the statute, or that some other thrifty man be entreated to occupy the office for this year, and that, the next year, to eschew such inconveniences, the order of the statute in this behalf may be observed. But notwithstanding this unanimous resolution of all the judges of England, thus entered in the Council Book, and the Statute 34 and 35 Hen. Roman 8. C. 26 S. 61, which expressly recognized this to be the law of the land, some of our Vitator 8 have affirmed that the king, by his prerogative, may name whom he pleases to be sheriff, whether chosen by the judges or no. This is grounded on a very particular case in the 5th year of Queen Elizabeth, when, by reason of the plague, there was no Michaelmas term kept at Westminster, so that the judges could not meet there in crastino animarum to nominate the sheriffs, whereupon the Queen named them herself, without such previous assembly, upjointing for the most part one of the 2 remaining on the last year's list. And this case, thus circumstanced, is the only authority in our books for the making these extraordinary sheriffs. It is true, the reporter adds, that it was held that T. Queen, by her prerogative, might make a sheriff without election of the judges, non obstant aliquo statuto in contrarium, but the doctrine of non ostantes, which sets the prerogative above the laws, was effectually demolished by the Bill of Rights at the Revolution, and abdicated Westminster Hall when James Roman II abdicated the kingdom. Registered, however, it must be acknowledged that the practice of occasionally naming what are called pocket asterisk Charles I before summoning Tivila and Ding Patriot sheriffs, in order to prolong Parliament, appointed 7 of the vent their being returned to Parliament. Vol. I. X. Sheriffs, by the sole authority of the Crown, has uniformly continued to the present time, although this has only occurred occasionally as on the death of a sheriff during his year of office. Sheriffs, by virtue of several old statutes, are to continue in their office no longer than 1 year. And yet it has been said that a sheriff may be appointed durante bene placido, or during the king's pleasure. Therefore, till a new sheriff be named, his office cannot be determined, unless by his own death, or the demise of the crown, in which last case it was usual for the successor to send a new writ to the old sheriff, but now by statute 1 Ann. Sen. 1 C. 8. All officers appointed by the preceding sovereign may hold their offices for 6 months after the demise of the crown, unless sooner displaced by the successor. We may further observe that by statute 1 Rich. Roman 2. C. 11. No man that has served the office of sheriff for 1 year can be compelled to serve the same again within 3 years after. We shall find it is of the utmost importance to have the sheriff appointed according to law when we consider his power and duty. These are either as a judge, as the keeper of the peace, as a ministerial officer of the superior courts of justice, or as the bailiff of the sovereign. In his judicial capacity he formally heard and determined all cases of 40 shillings value and under in his county court, and he has still a ministerial power of a judicial nature in divers other civil cases, as on writs of inquiry to assess damages in undefended suits, and in assessing the compensation to be paid to the owners for lands taken for making railways and other public works, duties invariably performed by the under-sheriff or an assessor selected for the occasion. The sheriff likewise decides the elections of coroners and of verderers, and returns such as he shall determine to be duly elected. As the keeper of the peace, both by common law and special commission, he is the first man in the county, and superior in rank to any nobleman therein, during his office. He may apprehend and commit to prison all persons who break the peace, or attempt to break it, and may bind any one in a recognizance to keep the peace. He may, and is bound, ex officio, to pursue and take all traitors, murderers, felons, and other misdoers and commit them to jail for safe custody. He is also to defend his county against any of the Queen's enemies when they come into the land, and for this purpose, as well as for keeping the peace and pursuing. Under sheriff. 307 felons, he may command all the people of his county to attend him, which is called the posse comitatus or power of the county, and this summons every person above 15 years old and under the degree of a peer, is by statute 2 Hen. VC. 8. Bound to attend upon warning, under pain of fine and imprisonment. But though the sheriff is thus the principal conservator of the peace in his county, yet by the express directions of the Great Charter, he together with the constable, coroner, and certain other officers of the sovereign, are forbidden to hold any pleas of the crown, or, in other words, to try any criminal offense. For it would be highly unbecoming that the executioners of justice should be also the judges, should impose as well as levy fines and amercements, should one day condemn a man to death and personally execute him the next, neither by 1 Mar. Sin. 2 C. 8. May he act as an ordinary justice of the peace during the time of his office, for this would be equally inconsistent, he being in many respects the servant of the justices. In his ministerial capacity, the sheriff is bound to execute all process issuing from the superior courts of justice. In civil causes, where the defendant is committed, on the ground of being about to leave England, he is to execute the judge's order, and to take the defendant to prison. When the cause comes to trial, he must summon and return the jury. When it is determined, he must see the judgment of the court carried into execution. In criminal matters, he also has power to arrest and imprison. He returns the jury, and he executes the sentence of the court, when it extends to death. As the bailiff of the sovereign, it is his business to preserve the rights of the crown within his bailiwick, for so his country is frequently called in the writs, a word introduced by the princes of the Norman line, in imitation of the French, whose territory was formerly divided into bailiwicks, as that of England into counties. He must cease to the sovereigns use all lands devolved to the crown by escheat, must levy all fines and must seize and keep all waifs, wrecks, estrays, and the like, unless they be granted to some subject. To execute these various offices, the sheriff has under him inferior officers, viz. Under-sheriffs and bailiffs who must neither buy, sell, nor farm their offices on forfeiture of 500 z. Jailers were formerly the servants their conduct. The business of Teli of the sheriff, and he was responsible for jailers to keep safely all such persons ex-2. Subordinate magistrates. The under-sheriff, who must be nominated by the sheriff within 1 month after his own appointment, usually performs all the duties of the office, a very few only excepted, where the personal presence of the High Sheriff is necessary. Formerly, no under-sheriff could abide in his office above 1 year, and if he did, by statute 23 Hen. Vi. c. 8, he forfeited 200z, a very large penalty in those early days. So, formerly no under-sheriff or sheriff's officer could practice as an attorney during the time he continued in office. But these regulations were evaded by practicing in the names of other attorneys and putting in sham deputies by way of nominal under-sheriffs. And both restrictions are accordingly now removed. Bailiffs or sheriff's officers are either bailiffs of hundreds or special bailiffs. Bailiffs of hundreds are officers appointed over those respective districts by the sheriffs to collect fines therein, to summon juries, to attend the judges and justices at the assizes and quarter sessions, and also to execute writs and process in the several hundreds. But as these are generally plain men, and not thoroughly skillful in this latter part of their office, that of serving writs and making executions, it is now usual to join special bailiffs with them, who are generally mean persons employed by the sheriffs on account only of their adroitness and dexterity in hunting and seizing their prey, the sheriff being answerable for the misdemeanors of these bailiffs when acting under his authority. They are therefore usually bound in an obligation with sureties for the due execution of their office, and thence are called bound bailiffs, which the common people have corrupted into a much more homely appellation, as are committed to them by lawful persons in their custody, or restrained warrant. If they suffered any such to and guarded against by statute 32 Geo. Escape, the sheriff must have answered Roman 2. c. 28, which act, with numerous others, for it to the sovereign, if it has been superseded by the Prison Act criminal matter, or in a civil case to 1865, regulating jails according to the party injured. And to this end the class of persons or offenders confined in sheriff must by statutes of Edward Roman 2. Them, and providing for the appointment and Edward Roman 3. Have land sufficient of visiting justices and inspectors of within the county to answer the king prisons. And his people. All prisoners are now the sheriff must also by statute however deemed to be in like custody of 3 and 4 will. Roman 4. c. 42 appoint a sufficient the jailer, who is appointed by the deputy, having an office within a mile of justices. The abuses of jailers and the inner temple hall for the receipt of sheriff's officers toward the unfortunate writs, granting of warrants. The coroner. 309 The vast expense which custom had introduced in serving the office of High Sheriff was grown such a burden to the subject that it was enacted, B.J. Statute 13 and 14 Car. Roman 2. c. 21, made perpetual by 1 Jack. Roman 2. c. 17, that no sheriff except of London, Westmoreland, and towns which are counties of themselves should keep any table at the assizes except for his own family, or give any presents to the judges or their servants, or have more than 40 men in livery. Yet, for the sake of safety and decency, he must not have less than 20 men in England and 12 in Wales, upon forfeiture in any of these cases, of 200z, unless the justices afford him the assistance of the police force of the county, so as to render such attendance unnecessary. Roman 2. The coroner's is also a very ancient office at the common law. He is called coroner carinator, because he has principally to do with pleas of the crown, or such wherein the sovereign is more immediately concerned. And in this light the Lord Chief Justice of the Queen's Bench Division of the High Court of Justice is the principal coroner in the kingdom, and may, if he pleases, exercise the jurisdiction of a coroner in any part of the realm. But there are also particular coroners for every county of England. The number of them originally was 4, sometimes 6, and sometimes fewer. But most counties are now divided into districts for this purpose. And although coroners elected for such districts are coroners for the whole county, yet they hold inquests, unless in cases of emergency, only in their own districts. This officer is of equal antiquity with the sheriff, and was ordained together with him to keep the peace, when the earls gave up the wardship of the county. He is still chosen by the freeholders of the county. As by the policy of our ancient laws the sheriffs and conservators of the peace, and all other officers were, who were concerned in matters that affected the liberty of the people, and as verters of the force still are, whose business it is to stand between the prerogative and the subject in the execution of the forest laws. For this purpose there is a writ at common law, de coronator eligendo, in which it is expressly commanded the sheriff, quod talem eligi facial, qui indium et ciet, et velit et posset, officio iui intendir. And in order to effect this the more surely, it was enacted by the statute of Westminster I. 3 Edw. I see. 10. That none, but lawful * 22 and 23 vict. C. 32 s. 18. 7 and 8 vic. C. 92, 23 and 24 vict. And discreet knights should be chosen, and there was an instance in the 25 Edwa. Roman 3. Of a man being removed from this office because he was only a merchant, but subsequently it was thought sufficient if a man had lands enough to be made a knight whether he were really knighted or not, for the coroner ought to have an estate sufficient to maintain the dignity of his office, and answer any fines that may be set upon him for his misbehavior, and if he is not enough to answer, his fine shall be levied on the county, as the punishment for electing an insufficient officer. Upwards of a century ago, through the culpable neglect of gentlemen of property, this office was suffered to fall into disrepute, so that, although anciently no coroners would condescend to be paid for serving their country, and they were by the statute of Westminster I. expressly forbidden to take a reward, under pain of a great forfeiture to the crown, yet, at the time we speak of, they only desired to be chosen for the sake of the perquisites. For many years past, however, the office has usually been held by solicitors of standing and respectability, and the coroners are now paid by a salary and not by the objectionable remuneration of fees. In boroughs which have a separate court of quarter sessions, the town council appoints and pays the coroner for the borough. In other boroughs the coroner of the county has jurisdiction. The coroner is chosen for life, but may be removed either by being made sheriff, which is an office incompatible with the other, or by writ de coronator exonerando for cause to be therein assigned, as that he is engaged in other business, is incapacitated by years or sickness, has not a sufficient estate in the county, or lives in an inconvenient part of it, by the statutes 25 Geo. Roman 2. C. 29 and 23 and 24 vict. C. 116 s. 6. Extortion, neglect, inability, or misbehavior are also made causes of removal. The office and power of a coroner are also, like those of the sheriff, either judicial or ministerial, but principally judicial. This is in a great measure ascertained by Statute 4 Edw. Ida officio coronatoris, and consists, first, in inquiring, when any person is slain, or dies suddenly, or in prison, concerning the manner of his death. And this must be super visum corporis. For if the J. fixed at quarter sessions, subject to 7 will. Roman 4, and 1 vict. C. 68. Appeal to T. Lilium Secretary, 23 and 24 vict. 5 and 6 will. Roman 4, C. 76. C. 116 and paid out of the county rate. In reward 30 L. J. Chenk, 775. Body be not found, the coroner cannot sit. He must also sit at the very place where the death happened. But he has jurisdiction, although the cause of death happened out of his county or district, and his inquiry is made by a jury of 12 at least, from 4, 5, or 6 of the neighboring towns, over whom he is to preside. He may require the attendance of medical witnesses or assessors, and order a post-mortem examination of the body. And if any be found guilty by this inquest of murder or other homicide, he is to commit them to prison for farther trial. He must certify this inquisition, under his own seal and the seals of his jurors, together with the evidence thereon, to the Queen's Bench Division of the High Court of Justice or the next assizes. Another branch of his awful see is to inquire concerning shipwrecks and certify whether wreck or not, and who is in possession of the goods. Concerning treasure trove, he is also to inquire who are the finders and where it is, and whether any one be suspected of having found and concealed a treasure. And that may be well perceived, saith the old statute of Edwa. I where one liveth riotously, haunting taverns, and hath done so of long time. Whereupon he might be attached, and held to bail, upon this suspicion only. The coroner may also, subject, however, to the Lord Chancellor's approval, appoint a fit and proper person to act for him, as deputy in the holding of inquests, and at any time revoke such appointment. The ministerial office of the coroner is only as the sheriffalty as substitute. For when just exception can be taken to the sheriff, for suspicion of partiality, as that he is interested in the suit, or of kindred to either plaintiff or defendant, the process must be then awarded to the coroner instead of the sheriff, for execution of the king's writs. Roman 3. The next species of subordinate magistrates that we have to consider are justices of the peace, the principal of whom is the custos reflorum, or keeper of the records of the county. The C. Vict. C. 12. 22 Vict. C. 33. 6 and 7 YU. Roman 4. C. 89, 7 Will. Roman 4. P. Stat. 33 Hen. Roman A. C. 12, 1 and 2 and 1 Vict. C. 68, PH. And M. C. 13. Degrees unless ho thinks fit to accept bail, 17 Geo. Roman 4. C. 64 S. 4. Which he may do in cases of manslaughter. 6 and 7 Vict. C. Subordinate magistrates. Common law has ever had a special care and regard for the conservation of the peace, for peace is the very end and foundation of civil society. And, therefore, before the present constitution of justices was invented, there were peculiar officers appointed by the common law for the maintenance of the public peace. Of these some had, and still have, this power annexed to other offices which they hold. Others had it merely by itself, and were thence named custodes or inservators pads. Those that were so virtui officii still continue, but the latter sort are superseded by the modern justices. The Queen is, by her office and dignity royal, the principal conservator of the peace within all her dominions, and may give authority to any other to see the peace kept, and to punish such as break it. Hence it is usually called the Queen's or King's peace. The Lord Chancellor or Keeper, the Lord Treasurer, the Lord High Steward of England, the Lord Marshal, the Lord High Constable of England, when any such officers are in being, and all the justices of the Queen's Bench. Division. By virtue of their offices and the Master of the Rolls, by prescription, are general conservators of the peace throughout the whole kingdom, and may commit all breakers of it, or bind them in recognizances to keep it. The other judges are only so in their own courts. The coroner is also a conservator of the peace within his own county, as is also the sheriff, and both of them may take a recognizance or security for the peace. Constables, tithing men, and the like, are also conservators of the peace within their own jurisdictions, and may apprehend all breakers of the peace and commit them, till they find sureties for their keeping it. Those that were, without any office, simply and merely conservators of the peace, either claimed that power by prescription or were bound to exercise it by the tenure of their lands, or, lastly, were chosen by the freeholders in full county court before the sheriff, the writ for their election directing them to be chosen. De proherius et patentarius comitatus sui in custodes pads. But when Queen Isabel, the wife of Edward Roman II, had contrived to depose her husband by a forced resignation of the crown, and had set up his son, Edward Roman III, in his place, this being a thing then without example in England, it was feared would much alarm the people, especially as the old king was living, though hurried about from castle to castle, till at last he met with an untimely Justices of the Peace. 818 Death. To prevent therefore any risings, or other disturbance of the peace, the new king sent writs to all the sheriffs in England, the form of which is preserved by Thomas Walsingham *, giving a plausible account of the manner of his obtaining the crown, to wit, that it was done ipsius patris bene piacifo, and withal commanding each sheriff that the peace be kept throughout his bailiwick, on pain and peril of disinheritance and loss of life and limb. And in a few weeks after the date of these tits, it was ordained in Parliament * that, for the better maintaining and keeping of the peace in every county, good men and lawful, which were no maintainers to evil, or barrators in the country, should be asned to keep the peace. And in this manner, and upon this occasion, was the election of the conservators of the peace taken from the people and given to the crown, this assignment being construed to be by the king's commission. But still they were called only conservators, wardens, or keepers of the peace, till the statute 34 Edward Roman 3. c. 1 gave them the power of trying felonies, and then they acquired the more honorable appellation of justices. These justices are appointed by special commission under the Great Seal, the form of which was settled by all the judges, A.D. 1590. This appoints them all, jointly and separately, to keep the peace, and any two or more of them to inquire of and determine felonies and outlier misdemeanors, in which number some particular justices, or one of them, are directed to be always included, and no business to be done without their presence, the words of the commission running thus: Husiorum aliquum vestrum A. V. C. D. and C. Annum S. volumus. Whence the persons so named are usually called justices of the quorum, and formerly it was customary to appoint only a select number of justices eminent for their skill and discretion to be of the quorum, but now the practice is to advance almost all of them to that dignity, naming them all over again in the quorum clause except * the one last named, but no exception is allowable, for not expressing in the form of warrants, and C. that the justice who issued them is of the quorum, when hist. A.D. 1327. 26 Geo. Roman 2. C. 27, 7 Geo. Roman 3. C. 21. 1 Edwa. Roman 3. 6 T. 2. C. 16. The TF tat. 4 Geo. Roman 4. C. 27. Allowanax. 4 Edwa. Roman 3. C. 2. 18 Edwa. Hi. Sin. 2. That in all cases where JHE number of O. 2. Justices in any city, town, or other place *C appendix to 4th report of the is limited, and only one or more of such judicature commission, 1874. Justices is or are of the quorum, all X. Subordinate magistrates. Any justice intends to act under this commission, he either sues out a writ of dedimus otium from the clerk of the crown and chancery, empowering certain persons therein named to administer the usual oaths to him, which done, he is at liberty to act, or else takes the prescribed oaths at a court of quarter sessions. Touching the number and qualifications of these justices, it was ordained by statute 18 Edwa. Roman 3. C. 2. That one or three of the best reputation in each county shall be assigned to be keepers of the peace. But these being found rather too few for that purpose, it was provided by statute 34 Edwa. Roman 3. C. 1. That one lord, and 3 or 4 of the most worthy men in the county, with some learned in the law, shall be made justices in every county. But afterwards the number of justices, through the ambition of private persons, became so large, that it was thought necessary by statute 12 Kitch. Roman 2. C. 10 and 14 Ike. Roman 2. C. 11 to restrain them, at first to 6, and afterwards to 8 only. But this rule is now disregarded, and the cause seems to be that the growing number of statute laws committed from time to time to the charge of justices of the peace have occasioned also, and very reasonably, their increase to a larger number. And as to their qualifications, the statutes just cited direct them to be of the best reputation, and most worthy men in the county. And the statute 13 Ike. Roman 2. Sin. 1 C. 7 orders them to be of the most sufficient knights, esquires, and gentlemen of the law. Also by statute 2 Hen. V. Sin. 1 C. 4 and Sin. 2 C. 1. They must be resident in their several counties. But a justice for 2 adjoining counties may nevertheless act for one while residing or being in the other. And because, contrary to the old statutes above mentioned, men of small substance had crept into the commission, whose poverty made them both covetous and contemptible, it was enacted by statute 18 Hen. The I. C. 11 that no justice should be put in commission if he had not lands to the value of 201 per annum, and the rate of money being greatly altered since that time, it was enacted by statutes 5 Geo. Roman 2, c. 18, and 18 Geo. Roman 2, c. 20, that every justice, acting for a county, except such privileged persons as are therein excepted, shall have LOZ per annum clear of all deductions or orders NC. Of any two or more of such. The Promissory Oaths Act, 1868. Justices shall be valid, though neither of 11 and 12 vict. C. 42 S. 5. Them shall happen to be of the quorum of the peace. 315 a reversion or remainder with reserved rents amounting to Sul per annum, and if he acts without such qualification he shall forfeit 100. This qualification asterisk, which may be from property in any county of England or Wales, is almost an equivalent to the 20 z per annum required in Henry VI's time. The occupier for 2 years of a dwelling house assessed at LOZ per annum to the inhabited house duty, and who shall for these 2 years have been rated to all rates and taxes in respect thereof, is also qualified to be justice for the county, riding, or division in which the premises are situated. Asterisk of one or other of these qualifications, the justice must now make oath. Finally, it was provided by the Act 5 Geo. Roman 2, which is reenacted in substance by the Statute 6 and 7 Vict. C. 73. That no practicing attorney, solicitor, or proctor shall be capable of acting as a justice of the peace. Asterisk as the awful BCE of these justices is conferred by the Crown, so it subsists only during the pleasure of the sovereign, and is determinable, 1. By the demise of the Crown, that is, in 6 months after. Asterisk, but if the same justice is put in commission by the successor, he shall not be obliged to swear to his qualification afresh, nor by reason of any new commission, to take the oaths more than once in the same reign. 2. By express writ under the Great Seal, discharging any particular person from being any longer justice. 3. By superseding the commission by writ of supersedias, which suspends the power of all the justices, but does not totally destroy it, seeing it may be revived again by another writ, called a precedendo. 4. By a new commission, which virtually, though silently, discharges all the former justices that are not included therein, for 2 commissions cannot subsist at once. 5. By accession of the office of sheriff or coroner. Registered formerly it was thought that if a man was named in any commission of the peace, and had afterwards a new dignity conferred upon him, that this determined his office, he no longer answering the description of the commission. But now it is provided, that notwithstanding a new title of dignity, the justice on whom it is conferred shall still continue a justice. 6. Any justice who is adjudged bankrupt or compounds. 38 and 39 Vict. C. 54. Sinks by charter, omission, or other. The Statute 6 and 7 Vict. C. 73, conwise. Tains a proviso that it shall not extend. Stat. 1n. C. A. To any city or town being a county of. Stat. 1 Geo. Roman 3. C. 13. Itself, or to any city, town, cinque port, asterisk stat. 7 Geo. Roman 3. C. 9. Or liberty, having justices of the peace asterisk. Stat. 1 Mar. Sin. 2 C. A. Within the respective limits and pre. Stat. 1 Edwa. VI. C. 7. Subordinate magistrates. With his creditors under the Bankruptcy Act 1869, is incapable of acting until he has been newly assigned as a justice. The power, office, and duty of a justice of the peace depend on his commission, and on the several statutes which have created objects of his jurisdiction. His commission, first, empowers him singly to conserve the peace, and thereby gives him all the power of the ancient conservators at the common law, in suppressing riots and affrays, in taking securities for the peace, and in apprehending and committing felons and other inferior criminals. It also empowers any two or more to hear and determine all felonies and other offenses, which is the ground of their jurisdiction at sessions, of which more will be said in its proper place. And as to the powers given to one, two, or more justices by the several statutes which from time to time have heaped upon them such an infinite variety of business, that few care to undertake, and fewer understand, the office. They are such, and of so great importance to the public, that the country is greatly obliged to any worthy magistrate, that, without sinister views of his own, will engage in this troublesome service. And therefore, if a well-meaning justice makes any undesigned slip in his practice, great lenity and indulgence are shown to him in the courts of law, and there are many statutes made to protect him in the upright discharge of his office which, among other privileges, prohibit such justices from being sued for any oversight, without notice beforehand, and stop all suits begun, on tender made of sufficient amends. But, on the other hand, any malicious or tyrannical abuse of their office is usually severely punished, and all persons who recover a verdict against a justice, for any willful or malicious injury, are entitled to full costs of suit as between solicitor and client. It is impossible, upon our present plan, to enter minutely into the particulars of the accumulated authority thus committed to the charge of these magistrates. I must therefore refer myself at present to such subsequent part of these commentaries as will in their turns comprise almost every object of the justice's jurisdiction. 32 and 33 Vict. C. 62 S. 22. Mr. Lambard's Iron Archa and Dr. Asterisk. Stat. 7 Jack. I. C. 5. 21 Jack. I. C. 12. Burns Justice of the Peace, wherein Leo 24 Geo. Roman 2. C. 44. 11 and 12 Vict. C. 44. Will find everything relative to this sub. Sir William Blackstone here. Reject, both in ancient and modern practice, commends to the student the perusal of collected with great care and accuracy. Constable. 317 I shall next consider some officers of lower rank than those which have gone before, and of more confined jurisdiction, but still such as are universally in use through every part of the kingdom. Roman 4. Fourthly, then, of the constable. The word constable is frequently said to be derived from the Saxon coning staple, and to signify the support of the king. But as we borrowed the name as well as the office of constable from the French, I am rather inclined to deduce it, with Sir Henry Spelman and Dr. Cowell, from that language, wherein it is plainly derived from the Latin constabuli, an officer well known in the empire. So called because, like the Great Constable of France as well as the Lord High Constable of England, he was to regulate all matters of chivalry, tilts, tournaments, and feats of arms which were performed on horseback. This great office of Lord High Constable has been disused in England, except only upon great and solemn occasions, as the King's coronation and the like, ever since the attainder of Stafford Duke of Buckingham, under King Henry Roman VIII. As in France it was suppressed about a century after by an edict of Louis Roman VIII. But from this office, this lower constableship was at first drawn and fetched, and is as it were a very finger of that hand, for the statute of Winchester, 13 Edwa. I. C. 6, which asterisk is the first legislative provision respecting them, directs that, for the better keeping of the peace, 2 constables in every 100 and franchise shall inspect all matters relating to arms and armor. The constables asterisk we are now speaking of asterisk are of 2 sorts, high constables and petty constables. The /ormer, who were first ordained by the statute of Winchester, as before mentioned, are appointed at the court leets of the franchise or 100 over which they preside, or, in default of that, by the justices asterisk at a special sessions under the statute 7 and 8 Vict. C. 33. The petty constables are inferior officers in every town and parish subordinate to the high constable of the 100, first instituted about the reign of Edward Roman III. These petty constables have 2 offices and disposed in a most clear and judy although a valuable work of reference, Aegis method. Asterisk the former work, by no means adapted, in its present form ever valuable as an authority, is practo the perusal of students. Tickly obsolete, while Bum's Justice, Plelip's Life of Pole, Roman 2, 111. Subordinate magistrates. united in them. The one ancient, the other modern. Their ancient ORC is that of head borough, tithing man, or borsholder, of whom we formerly spoke, and who are as ancient as the time of King Alfred. Their more modern office is that of constable merely, which was appointed, as was observed, so lately as the reign of Edward Roman III in order to assist the High Constable. And in general, the ancient head boroughs, tithing men, and borsholders were made use of to serve as petty constables, though not so generally, but that in many places they were distinct officers from the constables. Formerly, they were all chosen by the jury at the court leet, or if no court leet was held, were appointed by 2 justices of the peace. But high constables, as well as parish constables if appointed at all, are now chosen by the justices at a petty sessions, holden yearly for that purpose, from lists of qualified persons made out by the overseers. Degrees the general duty of all constables, both high and petty, as well as of the other officers, is to keep the peace in their several districts, and to that purpose they are armed with very large powers of arresting and imprisoning, of breaking open houses, and the like. Of the extent of which powers, considering what manner of men are for the most part put into these offices, it is perhaps very well that they are generally kept in ignorance. The more especially that a protection, similar to that of fee are dead to magistrates unintentionally exceeding their authority, is extended to them. One of their principal duties, arising from the Statute of Winchester, which appoints them, is to keep watch and ward in their respective jurisdictions. Wardguard, or custodia, is chiefly applied to the daytime, in order to apprehend rioters and robbers on the highways, the manner of doing which is left to the discretion of the justices of the peace and the constable, the 100 being however answerable for all robberies committed therein by daylight, for having kept negligent guard. Watch degrees is properly applicable to the night only, and it begins at the time when ward ends, and ends when that begins. For by the Statute of Winchester, in walled towns the gates shall be closed from sunset to sunrising, and watch shall be kept. In every borough and town, especially in 14 car. Roman 2. C. 12. 13 and 14 vict. C. 20. 32 and 33 vict. C. 47. Degrees called among our Teutonic ancestors. 35 and 36 vict. C. 92. Whacked or whackta. Capitular. Ludov.pi. C. 5 and 6 vic. C. 109. 7 and 8 vic. C. 52. Police force. 309 in the summer season, to apprehend all rogues, vagabonds and night walkers, and make them give an account of themselves. The constable may appoint watchmen at his discretion, regulated by the custom of the place, and these being his deputies have for the time being the authority of their principal. Besides these parish constables appointed annually, power is given to justices of the peace upon information that disturbances exist or are apprehended, to appoint and swear in special constables from among the persons qualified to fill the office of parish constable. And any one of the secretaries of state may, on the representation of the justices, order persons to be sworn in, though exempt by law from so serving. These ancient officers have, however, been almost entirely superseded by the modern police force now established throughout the kingdom. The old watchmen had been found, in towns and populous places, to be utterly inefficient, whether in the prevention or detection of crime, long before a system of police was established in the metropolis towards the close of the reign of George IV. The advantages to the community, which resulted from what was considered by many a dangerous innovation and destructive of the liberty of the subject, were so great, that similar peace officers were not long afterwards appointed, on the same system, in various large towns, either by the authority of special acts of Parliament, or with the aid of the Towns Police Act, 1847, or under the provisions of the Lighting and Watching Act, 3 and 4 Will, Roman 4. C. 90, or in the case of boroughs under the Statute 5 and 6 Will, Roman 4. C. 76. Towns and populous places having been thus provided with efficient peace officers, the parish constables were shortly found to be quite unequal to the duties assigned to them in the preservation of the peace and the suppression of crime, and power was accordingly given to the justices of the peace to obtain from the Secretary of State authority to appoint, subject to his approval, a chief constable for their counties or for each parliamentary division thereof, such chief constable then appointing, subject to the approval of the justices in petty sessions, the other constables, and a superintendent to be at the head of the PC 1 and 2 will. Roman 4. Of 41, and 6. 10 and 11 Vict. C. 89. Wool. Roman 4. CC. 43 and 76. 2 and S Vict. C. 93. 3 and 4 Vict. C. 88. 10 Geo. Roman 4. C. 44. 19 and 20 Vict. C. 69. 21 and 22 Vict. C. 68. 320 subordinate magistrates. Constables in each division, the whole, when sworn in, having all the powers, privileges, and duties which any constable duly appointed has within his constablewake, either at common law or by virtue of any statute. The discretion thus left to the justices was, after several years' experience and considerable opposition in the legislature, taken away by the statute 19 and 20 Vict. C. 69. And the justices of every county, in which a constabulary had not then been established, were directed to provide for it a sufficient police force within a limited period after the passing of the Act. Asterisk by these and other statutes provision has been made for the distribution, in certain cases, of the police force according to the requirements of particular districts, and for the consolidation of the police of boroughs with those of the county, and the conferring on the officers of each of coextensive powers. The justices are also required to report to one of the secretaries of state the number of offenses said to be committed, the number of persons apprehended, and other matters relating to the state of crime within their jurisdiction, and power is given to the Crown to appoint inspectors, with authority to visit and inquire into the state and efficiency of the police. The force thus established is paid by means of a police rate made by the justices and levied with the county rate. Towards these expenses, however, the commissioners of the Treasury are empowered to contribute a sum, not exceeding 1/4 of the charge for the pay and clothing of the force, upon the certificate of one of the Secretaries of State, that the police of any county or borough has been maintained in a state of efficiency in point of numbers and discipline for the previous year. V. We are next to consider the surveyors of the highways. Every parish is bound of common right to keep the high roads that go through it in good and sufficient repair, unless, by reason of the tenure of lands or otherwise, this care is consigned to some particular private person. From this burden no man was exempt by our ancient laws, whatever other immunities he might enjoy. This being part of the trinoda niecetas to which every man's estate was subject, vis expeditio contra hostem, artium e instructio, et ponium reparatio. The care of the roads for a long time was 19 and 20 Vict. C. 69, 20 Vict. C. 2. Only is expressed, yet that of roads also 22 and 23 Vic. C. 32. Must be understood, as in the Roman. Thougly the reparation of Bridgo's L:(I\v ad matrutions reparationesque. Surveyors of highways. 321 left to parishes, that of bridges being in great measure devolved upon the county at large, by statute 22 Hen. Roman A. C. 5. And if the parish neglected these repairs, they might be indicted for such their neglect. But it was not incumbent on any particular officer to call the parish together and set them upon this work till, by the statute 2 and 3 ph. and M.C. 8, surveyors of the highways were ordered to be chosen in every parish. These surveyors were originally, according to the statute of Philip and Mary, to be appointed by the constable and churchwardens of the parish. But they are generally chosen by the inhabitants, and if the inhabitants omit to elect, the justices must appoint them, under the regulations prescribed by the statute 5 and 6 will. Roman 4. C. 50. These surveyors were superseded by highway boards, assigned to highway districts and composed of way wardens selected, like the surveyors, from the various parishes of the district, who have in their turn been superseded by the urban authorities constituted by the Public Health Act 1875. Their office and duty consists in putting in execution a variety of laws for the repairs of the public highways, that is, of ways leading from one town to another, all which asterisk laws were consolidated and amended by the above-mentioned Statute 5 and 6 will. Roman 4. c. 50. Under that Act, which has been amended by various statutes, the surveyors and those now executing the duties of that office have full powers to get materials and contract for getting and conveying them, and also to remove and compel the removal of nuisances, the cutting of trees, and the opening of ditches and drains, and the impounding of cattle straying on the roads. Cartways are required to be 20 feet wide, horseways 8 feet, and footways 3 feet. Various regulations are to be observed by persons driving along the roads, and penalties are imposed for their infraction, and also on local authorities guilty of negligence or breach of duty. Provision is likewise made for stopping up and diverting highways where unnecessary or inconvenient, as well as for compelling their repair. To provide for the expense of the maintenance of the highways, the surveyors are empowered to levy a rate in the same manner and on the itineram et pontium, nullum genua homi. Since amended by various statutes, num nuuic dignitatis ac venerations. 25 and 26 vic. c. Sci. 26 and 27 vic. c. Marius, Isera portet. 0. 11, 74, 4, 61, 27 and 28 vic. c. 101. Vol. I. Y. Subordinate magistrates. Same persons and property as in the case of rates for the relief of the poor. As for turnpikes, which are now pretty generally introduced in aid of such rates, and the law relating to them, these depend principally on the particular powers granted in the several road acts and upon some general provisions which are extended to all turnpike roads in the kingdom by statute. 3 Geo. Roman 4. c. 126. Amended by many subsequent acts. Vi. I proceed, lastly, to consider the overseers and guardians of the poor, their origin, appointment, and duty. The poor of England, till the time of Henry Roman VIII, subsisted entirely upon private benevolence and the charity of well-disposed Christians. For though it appears by the mirror that by the common law the poor were to be sustained by parsons, rectors of the church, and the parishioners, so that none of them die for default of sustenance, and though by the statute 12 Ike, Roman 2. c. 7 and 19 Hen. Roman 7. c. 12, the poor are directed to abide in the cities or towns wherein they were born, or such wherein they had dwelt for 3 years, which seems to be the first rudiments of parish settlements, yet till the statute 27 Hen. Roman A. c. 25, I find no compulsory method chalked out for this purpose, but the poor seem to have been left to such relief as the humanity of their neighbors would afford them. The monasteries were, in particular, their principal resource, and among other bad effects which attended the monastic institutions, it was not perhaps one of the least, though frequently esteemed quite otherwise, that they supported and fed a very numerous and very idle poor, whose sustenance depended upon what was daily distributed in alms at the gates of the religious houses. But, upon the total dissolution of these, the inconvenience of thus encouraging the poor in habits of indolence and beggary was quickly felt throughout the kingdom, and abundance of statutes were made in the reign of King Henry VIII and his children for providing for the poor and impotent, which, the preambles to some of them recite, had of late years greatly increased. These poor were principally of 2 sorts: sick and impotent, and therefore unable to work, idle and sturdy, and therefore able, but not willing to exercise any honest employment. To provide in some measure for both of these, in and about the metropolis, Edward VI founded 3 royal hospitals, Christ's and St. Thomas's, for the relief of the impotent through infancy or sickness, and Bridewell, for the punishment. Overseers and guardians of the poor. 323 and employment of the vigorous and idle. But these were far from being sufficient for the care of the poor throughout the kingdom at large, and therefore, after many other fruitless experiments, by statute 43 Eliz. c. 2, overseers of the poor were appointed in every parish. By the statute last mentioned, these overseers were to be nominated yearly in Easter week, or within 1 month after, by 2 justices dwelling near the parish. But the appointments are now to be made within 14 days after the 25th day of March in each year. And the overseers must be substantial householders, and so expressed to be in the appointment of the justices. Their office and duty, according to the same statute, were principally these. First, to raise competent sums for the necessary relief of the poor, impotent, old, blind, and such other being poor and not able to work. And secondly, to pro-backslashide work for such as are able, and cannot otherwise get employment. For these joint purposes they are empowered to make and levy rates upon the several inhabitants of the parish, by the same Act of Parliament, which has been farther explained and enforced by several subsequent statutes. The 2 great objects of this statute seem to have been, 1. To relieve the impotent poor, and them only. 2. To find employment for such as are able to work, and this principally by providing stocks of raw materials to be worked up at their separate homes instead of accumulating all the poor in one common workhouse. Counties, IDO. Roman 3. 0. Borough were regularly furashad with employ 12 and evict. C. 8, 15 and evict. E. 84. Meant, and allowed the whole profits of Sir William Blackstone condemns their laux a spirit of busy cheerfulness the workiacy. System of his day as would srs diffuse itself through every ractical which put the sober and delicatage, work would become easy and gent upon a level, in point of their habitual, when absolutely necessary for earnings, with those who were dissolute daily subsistence, and the peasant and idle, depressed the laudable Emile would go through his task without a tion of domestic industry and neatness, murmur, if assured that Ho and his'n destroyed all endearing family children when incapable of work through connections, the only felicity of the infancy, age, or infirmity, would then, indigent. If none were relieved, Canan then only be entitled to support Tins the learned commentator, but from his opulent neighbors. It is those who are incapable to get their scarcely necessary to remark that this livings, and that in proportion to their theory of worklius a relief differs as in capacity. If no children were removed much from the practice of poor law from their parents, but such as our administration in the present day, as it brought up in rags and idleness, and was opposed to the principles of the every poor man and his family statute of Elizabeth. 324 Subordinate magistrates. Its only defect was confining the management of the poor to small parochial districts, which are frequently incapable of furnishing proper work or providing an able director. However, the laborious poor were then at liberty to seek employment wherever it was to be had, none being obliged to reside in the places of their settlement, but such as were unable or unwilling to work, and those places of settlement being only such where they were born, or had made their abode, originally for 3 years, and afterwards, in the case of vagabonds, for 1 year only. After the Easteration a very different plan was adopted, which rendered the employment of the poor more difficult, by authorizing the subdivision of parishes, greatly increased their number, by confining them all to their respective districts, gave birth to the intricacy of our poor laws, by multiplying and rendering more easy the methods of gaining settlements, and, in consequence, created an infinity of expensive lawsuits between contending neighborhoods concerning those settlements and removals. By the Statute 13 and 14 Car. Roman 2. c. 12, a legal settlement was declared to be gained by birth, or by inhabitancy, apprenticeship, or service for 40 days, within which period all intruders were made removable from any parish by 2 justices of the peace, unless they settled in a tenement of the annual value of 10. The frauds naturally consequent upon this provision, which gave a settlement by so short a residence, produced the statute 1 Jac. Roman 2. c. 17, which directed notice in writing to be delivered to the parish officers before a settlement could be gained by such residence. Subsequent provisions allowed other circumstances of notoriety to be equivalent to such notice given, and those circumstances were from time to time altered, enlarged or restrained, whenever the experience of new inconveniences arising daily from new regulations suggested the necessity of a remedy. And the doctrine of certificates was invented, by way of counterpoise to restrain a man and his family from acquiring a new settlement by any length of residence whatever, unless in 2 particular excepted cases, which made parishes very cautious of giving such certificates, and of course confined the poor at home, where frequently no adequate employment could be had. By the Statute 22 Geo. Roman 3. c. 83, commonly known as Gilbert's Act, parishes within a certain limit were enabled to unite with others in order to provide poorhouses for the reception of paupers, over whom a governor was to be appointed. Regulations. Poor laws. 325 were made for these poorhouses being duly visited, and a guardian being appointed for each parish adopting the Act. Power was given to the visitors and guardians to make contracts for providing the poor in the poorhouses with diet and clothing, commonly termed farming the poor. The adoption of this act was not compulsory, and it is now in operation in a very few places only. Asterisk by the Statute 35 Geo. Roman 3. c. 101. Repealing so much of 13 and 14 Car. Roman 2. CL2. As enabled justices to remove persons likely to become chargeable, no person was to be removable until he became actually chargeable, and power was given to suspend the removal of sick persons. The statute also provided that no person should thereafter gain a settlement by delivery and publication of a written notice, nor by paying taxes for a tenement of less than 10 yearly value. The Statute 59 Geo. Roman 3. c. 12, commonly called Sturgisborn's Act, next enabled parishes to establish select vestries to build or enlarge workhouses where none, or an insufficient one, existed before, and to provide land for the employment of the poor, not exceeding 20 acres in extent. The owners, instead of the occupiers of certain houses, were at the same time made rateable, and power was given to remove chargeable poor born in Scotland, Ireland, and in the Isle of Man, Jersey, and Guernsey, although they had not committed any act of vagrancy. Another statute of the same session, 59 Geo. Roman 3. 0. 50, enacted that no settlement should be acquired by renting any tenement except a house or land in the parish, of the annual value of LOZ hired and rented for a year. This act was soon afterwards repealed by the Statute 6 Geo. Roman 4. c. 57, but the latter act, as amended by one will. Roman 4. c. 18, reenacts, with various restrictions to prevent the numerous frauds on parishes which had been effected in the meantime, the provision of the statute of George III. Asterisk under this complicated system, the gravest abuses crept into the administration of the poor laws. The philanthropic but erroneous views of the local authorities led in many cases to a profuse amended by 49 Geo. Roman 3. c. 124. By 8 and 9 Vict. c. 117, 24 and 25 Vict. O. Extended to 50 acres by 1 and 2 Wool. 76, 25 and 26 Vict. c. 113, and 26 and 27 Roman 4. c. 42. c. Allow 1 and 2 Wool Roman 4. c. Vict. c. 89, which enable guardians of 59. 2 will. Roman 4. c. 42, and 5 and 6 will L unions to obtain orders of justices for the Roman 4. c. 69. Removal of such paupers, at the common asterisk the removal of this class of poor to charge of the union or parish, as the case the place of their birth is now regulated may be. 326 subordinate magistrates. And indiscriminate expenditure, and from this there resulted a marked demoralization of the laboring classes of the district. The amount annually expended in the relief of the poor became, in consequence, such a serious burden on the rest of the community, that it was found necessary not only to reconstruct the machinery for its distribution, but to revise the principles of our previous legislation. This was effected in 1834 by the Statute 4 and 5 Will. Roman 4. c. 76, generally known as the Poor Law Amendment Act. A board of 3 commissioners was thereby established for a period of 5 years, and the administration of relief to the poor throughout the kingdom, according to the existing laws, was made subject to their direction and control. They were authorized to issue general rules, orders, and regulations, subject to disallowance by the Crown and Council, for the management of paupers, the government of workhouses, the maintenance, education, and apprenticing of the children of poor persons, and the guidance and control of all guardians, vestries, and parish officers in the relief of the poor. They were also empowered to unite adjacent parishes into one union, each parish being, however, separately chargeable with the expense of its own poor, the share of expenses incurred for the common benefit being ascertained by means of triennial averages. On the formation of such a union, the government of the workhouses and the administration of relief was vested in a horde of guardians, elected by the ratepayers, of which the justices of the peace acting for the county were ex officio members. Besides assistant commissioners, who were chosen by the commissioners, the statute directed the appointment, by the boards of guardians, of relieving officers to superintend and assist in the administration of the relief and employment of the destitute poor, the salaries of these officers, and the duration of their appointment, being under the control of the commissioners. The duties of overseers, although still onerous with regard to the collection and application of the poor rates and the keeping of the accounts, were, on the other hand, relieved by the transfer of their primary duty, which was the relief of the poor, to the guardians of the union. They were, in short, deprived of the power of giving relief or allowances to paupers except in cases of sudden and urgent necessity, when they were required to give relief in kind, but not in money. The practice which had long obtained and been found. The Poor Laws. 327 productive of much evil, of giving outdoor relief to the able-bodied poor, that is, to persons who were wholly or partially employed, was put an end to, and the entire administration of outdoor relief subjected to the regulations of the board, unless under special circumstances and in cases of emergency, which were to be forthwith reported to the commissioners. Asterisk under this statute, it is to be noticed, relief to the wife is deemed relief to the husband, and relief to the child relief to the parent. Husbands are made liable to maintain children of their wives born before marriage, and mothers of illegitimate children, so long as they are unmarried, or widows to maintain such children until they attain the age of 16. Relief given to a man or his family may be considered as a loan, for which the guardians may sue in the county court, or recover by an order of the justices, who are for that purpose empowered to attach the wages of a husband or father in the hands of masters or employers. The guardian and overseers, it may be added, are authorized to raise money on security of the rates for the purpose of enabling the or to emigrate. Asterisk with respect to the settlement of the poor, it was enacted that no settlement should be thereafter acquired by hiring and service, or by residence under the same, or by serving in office or by apprenticeship in the sea service, that no settlement should be acquired or completed by occupying a tenement, unless the occupier should have been assessed to and paid the poor rate for 1 whole year, and that no settlement gained by virtue of any possession of any estate or interest in any parish should be retained for any longer time than the person acquiring it should inhabit within 10 miles thereof. It was also enacted that thenceforth persons should not be removed until after 21 days. Notice of chargeability. Subsequent statutes provided for the more equitable assessment of property and the collection of the poor rates, for the purchase of property, and the advance of loans in relation to workhouses and other matters connected with the poor, for compelling putative fathers to maintain their illegitimate children on the application of the mother to justices in petty sessions without the intervention of the overseers or guardians, and for the abolition of compulsory apprenticeships, and the regulation of the respective duties of poor apprentices and their masters. Other statutes prescribed the mode of voting, election of guardians, and provided for the management and care of pauper lunatics, the election, and the duties when elected, of auditors, and the proper regulation of schools. The removal of persons born out of but becoming chargeable in England was provided for by other enactments, which made persons removable from any parish or place where they had resided for 5 years without receiving parochial relief, and also prevented the cruel hardship of the immediate removal of poor widows on the death of their husbands. By more recent statutes, the cost of the relief of the irremovable poor and of wayfarers, wanderers, and foundlings is made a charge on the common fund of the Union, instead of the rates of the parish where the pauper resides. The powers conferred on the Poor Law Commissioners were in the meantime continued by various statutes down to the year 1847, when it was found advisable to reconstruct the board, certain of the great officers of state being appointed commissioners ex officio, and presided over by one style, the President J., to whom all the powers and duties of the former body were transferred, power being given to them to appoint inspectors in lieu of assistant commissioners, and other provisions made at the same time for ensuring the due visitation of workhouses. This statute, although only passed for 5 years, was continued from time to time, the commissioners acting under the designation of T. Jaipur Lave Board, until superseded, under the Statute 34 and 35 Vict. C. 70, by the local Government Board, by which body all the powers of the Commission for administering the laws for the relief of the poor are now exercised. The procedure in respect of orders of removal and appeals from such orders had in the meantime been remodeled, and the necessary forms placed out of the reach of many technical and vexatious objections which formerly disgraced this branch of practice in poor law administration. The maintenance of the poor in houses other than workhouses has been provided for and controlled, the law as to the burial of poor persons amended, and regulations made with respect to the education of the poor, power being given to guardians so to grant relief, that certain poor persons may provide education for their children out of the workhouse. These and a host of other provisions, although of undoubted benefit to society, have left the law relating to the relief of the poor in such a state of complexity as to render Law of Settlement 329 their speedy consolidation a work rather of necessity than of mere convenience. The existing Law of Settlements may be reduced to the following general heads, or a settlement in a parish may be acquired, 1. By birth, for wherever a child is first known to be, that is always prima facie the place of settlement, until some other can be shown. This was also generally the place of settlement of a bastard child, for a bastard, having in the eye of the law no father, could not be referred to his settlement, as other children might. But now every illegitimate child, born after the 14th August, 1834, follows the settlement of the mother until it attains the age of 16, or it acquires a settlement in its own right. If it does not acquire a settlement in its own right, it then reverts to his birth settlement. The place of birth is also prima facie the settlement * of legitimate children. Yet it is not conclusively so, for there are, 2, settlements by parentage, being the settlement of one's father or mother. All legitimate children being really settled in the parish where their parents are settled until they get a new settlement for themselves. A new settlement may be acquired several ways, as 3. By marriage. For a woman, marrying a man that is settled in another parish, changes her own settlement, the law not permitting the separation of husband and wife. But if the man has no settlement, hers is suspended during his life if he remains in England and is able to maintain her, but in his absence or after his death, she may be removed to her old settlement. So also during his inability she may be removed with his consent, but not without. These 2 species of settlements, namely by birth and by marriage, are termed derivative settlements. The other methods of acquiring settlements in any parish are all reducible, * under the Statute 13 and 14 Car. Roman 2. C. 12 S. 1. To this one of 40 days residence therein, * while irremovable. These methods of acquiring a settlement are now coupled with a number of requirements imposed by subsequent statutes. 4. Renting for a year a tenement of the yearly value of £10 and residing 40 days in the parish, gained a settlement, by * force. It is impossible to give more than an account venture to refer the reader. The outline of the laws for the relief of the may, however, add here that these acts pour. The statutes in force on this have been collected in 2 volumes and subject are nearly 300 in number, and carefully annotated, by Mr. W. C. Glenn. Them, therefore, the editor will on know of the local government board. Subordinate magistrates. Of the statute of Charles Roman 2. Upon the principle of having substance enough to gain credit for such a house. Now, however, the tenement must consist of a separate and distinct building, or of land actually occupied, and rent actually paid for the year, and in addition, the occupier must be assessed to and pay the poor rate in respect of the tenement. 5. Being charged to and paying the public taxes and levies of the parish, excepting those for scavengers, highways, and the duties on houses and windows. Coupled with 40 days' residence, gained a settlement under the Statute 3W, and MC 11s. 6. But now such a settlement must be accompanied by all the requirements necessary to gain a settlement by renting a tenement, except that the occupation of such tenement, to gain a settlement by payment of taxes, need not be for a whole year, a partial occupation being sufficient. 6. Being bound in a treatise, gives the servant and apprentice a settlement without notice, in that place wherein he serves the last 40 days. This is meant to encourage application to trades, and going out to reputable service. No settlement, however, can now be acquired by being apprenticed to the sea service, or to a householder exercising the trade of the seas as a fisherman or otherwise. Lastly, the having an estate of one's own and residing thereon 40 days, however small the value may be, in case it be acquired by act of law or of a third person, as by descent, gift, devise, and c. is a sufficient settlement. But if a man acquire by his own act, as by purchase in its popular sense in consideration of money paid, then unless the consideration advanced haunt fide be 30, it is no settlement for any longer time than the person shall inhabit thereon. He is in no case removable from his own property, but he shall not, by any trifling or fraudulent purchase of his own, acquire a permanent and lasting settlement. And there is this peculiarity about settlements by estate, that no person retains any settlement gained by virtue of any possession of any estate or interest in any parish, for any longer or further time than he inhabits within 10 miles thereof, in case he ceases to inhabit within such distance, and thereafter becomes chargeable, he is liable to be removed to the parish wherein previously to such inhabitancy he was legally settled, or in case he has subsequently to such inhabitancy gained a legal settlement in some other parish, then he is removable to such other parish. Such are the several modes in which a settlement can now be. Poor laws. 331 acquired. Settlements acquired, however, under statutes subsequently repealed or altered, remain in force for the purpose of determining the places to which paupers are removable, when they have not acquired any subsequent settlement. Persons not so settled, on becoming chargeable, may be removed to their own parishes or unions on complaint of the guardians by an order of 2 justices of the peace. On the expiration of 21 days after notice of chargeability, and a copy of the order of removal and a statement of the grounds of removal have been sent to the guardians of the opposing parish or union, if within such period a copy of the depositions shall be applied for, in which case the pauper is not removable until after a further period of 14 days, unless the opposing parish or union appeals to the sessions, in which case the pauper cannot be removed until after the determination of the appeal. This right of removal is further subject to the important provision already noticed, namely, that no person shall be removed, nor shall any warrant be granted for the removal of any person from any parish in which such person shall have resided, without receiving parochial relief, for 1 year next before the application for the warrant, and whenever any person has a wife or children having no other settlement than his or her own, such while and children are removable whenever he or she is removable, and are not removable when he or she is not removable. So no woman, residing in any parish with her husband at the time of his death, is removable for 12 calendar months next after his death, if she so long continues a widow. These are the general heads of the laws relating to the poor. Under the statute of Elizabeth, the inextant and the old, the blind and the poor, were supported by the parish in which they became destitute or disabled, and so remained until, under the Act of Charles Roman II, they were made chargeable to the parishes in which they had obtained parochial settlements. This liability, the source of endless litigation and expense to the parishes, continued until a new class of paupers was created by the Statute 9 and 10 Vict. c. 66, which was passed to restrain the removal of those who had resided for 5 years in a parish without receiving relief, or who became chargeable through temporary sickness. In consequence of this act, large numbers who had settlements elsewhere suddenly became chargeable to parishes already over 332 subordinate magistrates, burthened with their own poor, to remedy which and provide, at the same time, a more equal adjustment of the burthen. A temporary statute, known as Bodkin's Act, was passed, the effect of which was to throw the relief of this class of poor on the common fund of the unions in which they were resident. This provision was reenacted by the Statute 11 and 12 Vict. c. 110 s. 3, and continued by subsequent acts until the Statute 24 and 25 Vict. C. 55 S. 8 made the charge of this class of poor on the Common Fund of Unions perpetual. Subsequently, the Union Chargeability Act 28 and 29 Vict. C. 79 repealed so much of the Statute 4 and 5 Will. Roman 4. C. 76 as required parishes and unions to defray expenses of their own poor, and now the cost of the relief of all paupers is borne by the common fund of the union in which the pauper resides or is settled. An important alteration was made by the Statute 24 and 25 Vict. C. 55 in the mode of apportioning the liability for the common fund to the respective parishes in the union. By the 4 and 5 Will. Roman 4. C. 76 S. 28. The common fund was to be apportioned according to the average annual expenditure of the parishes for the relief of the poor thereof for the 3 years preceding, so that the parishes most burthened with poor had most to contribute towards the common charges. This system of levying most from those who were least able to pay was put an end to by enacting that parishes comprised in unions should henceforth contribute to the common fund thereof, according to the annual value of the rateable property in each, which annual rateable value is to be taken from the last approved valuation lists. The effect has been to alter to some extent the incidence of pauper taxation, for as considerably more than 1/3 of the money spent on the relief to the poor is given on account of irremovable paupers, the principle of liability now asserted goes a great way towards the establishment of union, as distinguished from parish rating, and it is to be hoped will produce ultimately the breaking up of that exclusive parochial system, which has so long fostered and preserved the laws of settlement, the most mischievous in the eyes of political economists that have ever appeared in the statute rolls of the empire. This audiobook was created by the Mental Chemist for Personal Study and Education, copyright 2025.